Good morning, Mkhalaka. Khosiyaka. Honorable Pangazita.
Good morning, Honorable Chair.
Honorable James. Honorable Matthews. Thank you so much. SC, good morning. Good morning, Advocate Mokhait. Thank you, Advocate Batohi. Good morning and welcome the National Director of Public Prosecutions in South Africa. Are you good?
Good morning, Chair. Good morning, honourable members.
Thank you so much
thank
and
you.
welcome and your team. Can we just check that the people who have accompanied you are appropriate people to be before this committee?
Chair, I think they can introduce themselves, Chair. They're right behind me, just the two of them.
Okay, no, they were with us last week. I just want you to confirm that, so that we focus on the business that we are here for today and we don't find ourselves having to answer other questions not related to our work. The staff of Parliament, good morning to you. Good morning, members of the media. The support staff of political parties, you are welcome. We should commence with today's business. It's just 1 minute after 11. Bonani, can I check if we have apologies? The only apology that we have is from Honorable Vessels. That is the apology which we gave to the meeting previously. He should be able to rejoin us very, very soon. We were going to proceed in that way, honorable members. Hand over to, or maybe before I hand over to the council to confirm that the witness is appropriately served before us. Just to indicate that we have allocated 1 day for our witness. Members of Parliament know that tomorrow is the day for the medium-term budget policy statement. And we have also agreed that we will receive Mr. Cedric Nkabinde on Thursday. SC, may you please do the rituals and confirm that the person before us is the witness that all of us have expected.
Good morning, Honourable Chair, honourable members, members of my team, the parliamentary legal team, media, and other colleagues in the room. I can indeed confirm, Honourable Chair, that is Ms. Shamila Batohi. We have consulted with her, and yeah, I confirm. I don't think anyone else would want to be an imposter in that position.
Okay, thank you so much. We are going to move to the next item and welcome Honorable Sangoni. The next item, Advocate Batohi, with due respect, we are going to administer oath. And before we do that, allow me to read the following to you, that you have been invited to appear before this committee, the ad hoc committee, to investigate the allegations by Lieutenant General Mkhanhla Mkhwanasi, the Provincial Police Commissioner in the province of KwaZulu-Natal, for you to provide information in relation to the committee's oversight work. The committee has been tasked to investigate allegations made by the KwaZulu-Natal Provincial Commissioner, which include, among others, the alleged unlawful disbandment of the Political Killings Task Team, otherwise the PKTT or the NPKTT, Secondly, alleged moratorium on the filling of vacancies within the South African Police Services, the SAPS, and alleged corrupt relationship between senior leadership within SAPS and members of the public, as well as political interference in the work of the SAPS. In extending the invitation to you, the committee chairperson has indicated that you may provide such information to the committee if you so wish under oath in terms of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. Advocate Batohi, you are, however, protected in that the evidence given under oath or affirmation before a House or Committee of Parliament may not be used against you in any court or place outside Parliament except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or Committee of Parliament with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are required to take an oath to affirm that the evidence you are about to give is truthful. Which one do you elect, Advocate Batohi, oath or affirmation?
I will take the oath, Chair.
Thank you so much. If you take the oath, you will then say aye and state your names in full.
I, Shamila Batohi,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
So help me God.
Thank you so much. SC, we are going to run until 13 hours. Thank you so much.
Thank you, Honourable Chair, Honourable Committee members. Good morning, Ms. Batohi. How do you want to be addressed? Ms. Batohi, Advocate Batohi, NDPP,
I don't mind, whatever
or
works.
some other?
I'm okay with all
Advocate
of the above.
Batohi, let's keep it formal. You are the National Director of Public Prosecutions, having been appointed to that office on the 1st of February 2019 by the President in
That's
terms
correct.
of 179 of the Constitution and sections 5 and 10 of the NPA Act. And you are due to retire soon.
That's correct, at the end of January 2026.
So maybe just to kick off, just describe briefly your experiences in the office, the ups and downs. Don't need to dwell too long on it.
Sure. Didn't expect this question, but I'm happy to take it. It was, well, I took office on the 1st of February 2019. I came back to South Africa having spent just short of 10 years, 9 years and 3 months at the International Criminal Court in The Hague, working in the Office of the Prosecutor as the Senior Legal Advisor to the Prosecutor of the ICC. Prior to that, I had worked in the Prosecuting Authority. This is my 40th year as a prosecutor. I was a DPP in KwaZulu-Natal, worked in various, was part of the investigation task unit that President Mandela set up in 1995 to investigate hit squads in KwaZulu-Natal. And I think before the TRC, it was perhaps the most important post-apartheid unit that was put together to investigate atrocities that were committed during the apartheid era. There were 2 prosecutors there and a team of investigators. We reported to a board. And yeah, that was 96, 97 work. There was the DPP in KZN, headed up the Scorpions in KwaZulu-Natal for about 2 years when it was set up, and then became the DPP, went abroad, and then started here in 2019 as the national director. Came back to South Africa to take the call to serve the people of this country. And at a time when it was a difficult decision to make, given what the country had come through. But my commitment to serve brought me back home. And coming into the National Prosecuting Authority in 2019 was a difficult situation because you were trying to rebuild an entity which, like many other entities in South Africa, SARS, the DPCI, had been hollowed out in the decade or so before that. There were huge challenges in the NPA. Some of them I could just mention briefly. It's lack of capacities and capabilities, lack of, we had staff shortages, budgetary issues, skills and capacity, demotivated staff for various reasons. So there was a lot of work to be done. I came in without a leadership team, and it was about 18 months after I took office that my senior leadership was appointed in June of 2020, which was in the middle of COVID. We came out of COVID in 2021, and then that's when the rebuilding really started. And it's been, as you put it, ups and downs, a roller coaster, 5 years. But I don't know how much of detail you want me to go into, but what I can maybe say at this point is that the strategy was to turn around the NPA, to rebuild the NPA, so that it can really serve the people of this country in the way a prosecuting authority should. And so a lot of time was spent institution building, and that is the drudgery of institution building that doesn't make the headlines. The boring back office work, but is critical in any democracy to have strong institutions. And so there was a lot of time that we spent getting the capacities, capabilities, in order to do the work that we needed to, and that is to prosecute crime in this country. So we've done a lot of work, and I'm very pleased with how far the NPA has come in terms of institution building. And generally, the prosecuting authority is doing exceptionally well, but I can accept that there are areas where I had certainly hoped that at this time in my career, we would have gone further than where we are, particularly investigating and prosecuting state capture matters and some other forms of high-profile corruption. And there are various reasons for that. I shouldn't say for prosecuting them, perhaps to have, because many cases are in court, but getting through a court system to finality is something else, and I can talk more about that later if I'm asked. But that is perhaps the one maybe disappointment in terms of the things, how far we've come in the NPA. But apart from that, we've certainly built a strong NPA. There's a lot of work still to be done that the new national director will need to take on, but we've certainly set a very solid foundation to serve the people of this country in the way that a prosecuting authority should.
Thank you, Advocate Batohi. So perhaps we can start at the end in terms of your own statement. You accept that there's still urgent reforms that need to be effected within the NPA. Would you welcome the opportunity, this opportunity before the ad hoc committee to discuss some of them, given that you are now addressing the lawmakers?
Sure.
We know about the much publicized Zondo Commission, the Nugent Commission into governance in SARS. But this is the first opportunity, really, isn't it, to actually engage with lawmakers in terms of what still needs to be done, reforms that need to be effected. So perhaps discuss some of those which you deal with at the end of your statement from paragraphs 81 onwards.
Yes, thank you, Council. I think it's safe to say that, as I say in my affidavit, as South Africa, we are at a critical inflection point in terms of consolidating the rule of law and accountability in this country. And the allegations that have been made by General Mkhwanazi and where it has brought us, both the Madlanga Commission as well as this committee really gives us as South Africa the opportunities to consider what are the vulnerabilities in the systems. And these allegations have brought that into sharp focus in terms of the fact that there are vulnerabilities. And we have to accept that not just in South Africa, but throughout the world, institutions that are fighting for the rule of law are under serious threat and open to vulnerabilities, different types of vulnerabilities, open to compromise because of the type of the work that we do. And so this moment that we are at right now, should not be squandered. We really should use this as a catalyst for comprehensive institutional reforms that are critical to safeguard the integrity as well as the effectiveness of all the law enforcement entities across the system. As you mentioned, the National Prosecuting Authority has not been the subject of institutional review. The Zondo Commission looked at this issue for a long time. I'm aware that there was a lot of investigations that went into it. A number of, it was a time that I was not in South Africa at the time, but I'm aware that a number of prosecutors and other staff members of the NPA made statements, deposed to affidavits in the context of the Zondo Commission. But sadly, the Zondo Commission did not make any recommendations about systemic weaknesses within the criminal justice system, so that these could actually be acted upon to strengthen the system as a whole. And this is actually, the Zondo Commission did incredibly good work and looked through, laid bare, the extent of corruption in this country and the impact that this has had on the ordinary people of South Africa, where there's no water, sanitary, we all know this, basic infrastructure, schools, hospitals have all been impacted by corruption. And in the context of the Zondo Commission, they certainly looked at corruption and did incredibly good work, but at the end of the commission, they handed over to a criminal justice system that was seriously weakened during those years to do the work and hold people accountable. And into a system that was at that point, and still is trying to recover from that, to get to a point where we can properly deal with these matters. And so I think in that sense, I see this as an opportunity for the lawmakers to come together and carefully look at what are the weaknesses in the system and how do we actually, it's an unprecedented opportunity to look at what are the weaknesses, what are the recommendations that come out of this, and how do we at the end of the day strengthen the system to serve the people of this country and to deal with not just corruption, but the crime crisis that this country is facing, including organized crime and other forms of criminality, sexual and gender-based violence. So I see this as a really good opportunity for institutional reforms across the criminal justice system.
And is it dependent on whether or not the allegations, the wide-ranging allegations made by Lieutenant General Mkhwanazi on the 6th of July is or are verified or confirmed?
I certainly hope not, that it wouldn't be dependent on that. I'm hoping that the Commission and the lawmakers would take what comes out of this and then consider systemic inefficiencies and make recommendations in terms of how the system can be strengthened. One is to deal with crime, but also to address the serious vulnerabilities to potential corruption and compromise of whether it's police officers, prosecutors, members of the judiciary, etc. It's important that those kinds of recommendations come out of this.
Apologies for jumping around a bit in terms of the structure of your affidavit, but because we on the issue of institutional reform of the NPA, and we might as well just look at the paragraph 4.1.11 of the committee's terms of reference, which refers to the alleged existence of an organized crime syndicate controlled by drug cartels as well as business people, and its infiltration of key criminal justice role players involving politicians, law enforcement, SAPS, and the NPA is mentioned. And just fast forward, you had made, even ahead of the 6th of July Mkhwanazi media statement, can you go to paragraphs 74 and 75, where you had made, there's a reference to a media interview on the 5th of June 2025 and the 6th of June 2025. Honourable Chair, those media statements or copies of it are now available in an exhibit. What's it, Talia, Delana? 11 or 12? 11. Exhibit 11, thank you. It's not attached to the statement. Advocate Batohi, you want to just address those and contextualize them?
Yes, thank you, Counsel. So, Honourable Chair, I was, at that point in time, during a media interview on the 5th of June, I made comments relating to infiltration of the NPA. And the next day, I then also had another media interview where I sought to clarify what I meant by that. But let me just explain to the House and Honourable Chair, honourable members, I speak to the House, I speak to the people of South Africa as well. And I want to explain that the reason that I made these comments at the time was that I had received confidential intelligence that there was a very concerted attempt to compromise members of the prosecuting authority. Also, concerted attempts to undermine and attack the National Director, and by individuals that are seeking to undermine the rule of law in this country. I'm not able to say who gave me this intelligence, but it was not passage talk, it was a formal meeting that I had with a particular agency, a member from a particular agency, and who gave me this information because the person thought it was important that as the head of the NPA, I should be aware of this attempts to undermine the work of the NPA. These were very serious. I was informed that the matter will be reported to the President, but I immediately informed the Minister of Justice about this, and had a meeting with her when I briefed her on what I had been told. I also, at some time later after that, when the president was available, met with him and briefed him about my concerns about this. And my understanding is that there was not a, and this is my understanding, I'm not sure how these agencies work, but that there wasn't a particular tasking to look into the NPA. But I asked the president, I said to him, it's important that we understand what is going on and that there should be a tasking by our intelligence services to properly look into this matter. And that was the situation. Of course, when I made these comments, there were prosecutors in the NPA who also became concerned about this. And I hasten to add that, Chair, the majority of the prosecutors in the NPA are hardworking, committed prosecutors, and our performance will attest to this, that serve the rule of law and the people of this country and nobody else. But of course, the hardworking prosecutors were concerned about these comments that I'd made, and wondering about who do you trust in your work environment. And I said to them, we work in a work environment where we don't know who to trust. That is the reality. Even sometimes within the prosecuting authority, definitely within the SAPs and other partners, we work under conditions where you do not know who to trust. But you have to have safeguards, and we have to do the work to the best of our ability to serve the people of this country. I then I went to meet prosecutors across the country and started off in the bigger provinces of Gauteng, KwaZulu-Natal, Eastern Cape, and now I've traveled to Free State, Northern Cape, far-flung regions to meet with prosecutors, to assure them that the NPA, that as prosecutors, their commitment is to the Constitution and the rule of law. And that if there was any attempts to undermine any prosecutors, that it's not worth it, because your reputation is not worth being compromised at any point. That we serve nobody but the people of this country and the rule of law. And so I've been trying to make efforts to assure prosecutors that the work we do is important, our integrity is important, our personal reputations are important, and that we should never compromise that for anyone across the spectrum. So I hope that clarifies what happened in that context.
Just two further aspects on that. At paragraph 73, you reference receiving information also from the National Commissioner and from the National Commissioner and Lieutenant General Khumalo about a potentially corrupt
That's
prosecutor.
correct. So, Honorable Chair, I received information from the National Commissioner and General Khumalo about a particular member of the prosecuting authority who was involved in organized criminality. I am not going to mention the name of that prosecutor in this House. The matter is under investigation. I immediately, upon receiving that information, I made a formal referral of the matter to the IDAC to investigate the matter. And that's the one direct bit of evidence or information, I should say, because I did ask the National Commissioner and General Khumalo. I met with them and I said to them, please, we need more evidence so that we can look into this matter, because it's unacceptable and untenable that any member of the prosecuting authority is involved with organized criminality. That there should be a fair process, and I've said this to prosecutors, there must be a fair process, and if you're found to be compromised, you will be kicked out of the NPA. We serve the people and we fight crime. We cannot be criminals ourselves.
But what's the status of this particular prosecutor, given these serious allegations coming from high-ranking sex?
I don't. The prosecutor is under suspension.
Okay. Okay. So it's currently not been temporarily removed
correct.
from the system. Now, just while the second aspect I wanted to while we're at it is, you otherwise reference at paragraphs 71 and 72 some statistics with us relating to complaints or allegations of corruption, presumably less serious, but nevertheless complaints of misconduct at paragraph 71 and 72. Do you want to just briefly refer to that?
So, in terms of
Just a moment, Honorable Skosana.
Thank you, Chair. I just wanted to make a seeking clarity question, because the Advocate Batohi is saying he can't reveal the name here. But if it's the same person who was mentioned in the media, why not revealing it here? Because in the media, if as members here of the committee, and the South African, some people knows exactly what we are talking about, who's that person we are talking about, why are we hiding it here? Thank you, Chair.
Advocate.
Chair, I will not want to hide anything from this committee. I regard it as a very important committee. But I do want to be responsible at the same time. I'm not sure who the person is that the honourable member is referring to. But even if the name is given to me now, I'm not going to make a comment about whether it is or isn't. It's not fair on the process. It's not fair on the person concerned. And this might turn out not to be true. We may not be able to verify this information. And then it destroys people's reputations and lives. And I think it will be hugely irresponsible for me at this stage, with just the bit of information that I have referred, to mention names in this House. So I would please ask the House to be understanding and not to insist that because I will not reveal the name, Chair, with all due respect.
Chair, the advocate says that he won't reveal the name, and he's not sure whether I'm talking about the same person. Do you know the name?
Chair, if I may ask the name of which person, the person in the media or the person in respect of whom the information was received?
No, the person you mentioned that is sitting at home, the prosecutor, which you said is sitting at home as we speak here.
I do.
But we are talking, you said you don't know that person.
No. It is not what she said.
Yes?
You alluded to knowing a person who
The media is.
who might be on suspension because the report is in the media.
Yes.
And what we may have to check with her is whether the report that you have seen in the media and the report that she gives here are one and the same report, or are two different reports.
Yes. Yes, no, I agree, Chair. And maybe if he said that, if he can say it, is it the same person, maybe he doesn't want to mention. But if it's mentioned in the media, and it's the same person, and he says it's a secret, for me that's a double standard. I mean, we deserve to know as well, formally so, not from the media. But if it's a different person, it's okay.
Yeah. She says for the purpose of professionalism. Honorable Malem.
No, thanks, Chair. I thought she was suggesting we must just go home if she's going to proceed like that. Because we deal with names here. What are we dealing with? What are we dealing with here? We want to know who captured the criminal justice system. And if we can't be told names and we accept that, let's go home. Especially names that are out there. There is a prosecutor, I'm just forgetting the name of, is it Johannesburg or something, Pretoria, who's suspended by the president. Joburg, Chauge. What's difficult saying something like that? What's difficult saying something like that? If we're referring to Chauge, or if there is more, we need to know. There is nothing unprofessional about that, because if we're going to proceed like that, we're becoming toothless. We cannot allow a situation where there is an allegation of a prosecutor who is being captured or infiltrated, and we are told we can't be given a name. If it was wrongly mentioned, there are recourse in South Africa where that name will be cleared. There are so many names of people being said here, people who are also in jail, people who are already on criminal trials. We get deep into those issues because we're seeking to unearth the truth. If it is true, indeed, there are people who are captured in the prosecuting authority. We want to know that. What if Chauge is wrongly accused? What if he's correctly accused? We need to come to a determination that, look, there is nothing in the NPA that suggests there is any infiltration by the drug cartel or anything of that sort. Or there is, and if we say there is, these are the issues. And these are the individuals responsible for those kind of activities in the NPA. So I don't think Honorable Skosana is being irresponsible in that regard. Thanks.
Advocate.
Thank you, Chair. I really want to emphasize, honorable members, that I do not seek to be disrespectful to this committee. I haven't even said, the members have mentioned names. I haven't even said whether it is or isn't that name that has been mentioned. And I will not, I don't want to make it difficult for this House to be able to do its work. But given that I was given, I think what at the level of intelligence, because I haven't even said it's evidence. I went back to the National Commissioner as well as General Khumalo and I said, can you please give me evidence of this? Because I need more evidence. And so I really urge that it will be hugely irresponsible of me to mention a name in this House on the basis of intelligence that I've received that may or may not be true. So I really urge honorable members to understand that I do want to help this House, but I do not want to put people's names at risk. For various reasons, you never know how people are put at risk. I mean, and we don't know whether it was a direct consequence of what happened in this House, but you know that our chief investigator of the IDAC was attacked a day or two after his name was mentioned in this House. But one might say, look, he is the chief investigator, it's not difficult, that you shouldn't really draw that conclusion. I will understand that as well. But it does put people at risk, and I do not want to be irresponsible and do that when all I've received is intelligence about the possibility that someone, well, about the fact that somebody is involved with organized criminal networks. Thank you, Chair.
Honorable Ngola.
Thank you very much, Chair. Chair, we have evidence before us that there are rogue sections within the NPA, which suggests that we must dig deeper to look into the allegation. And part of what has been a modus operandi of this ad hoc chair was that names must be given to the committee so that it is actually assisted in formulating a finding and recommendations. From the evidence of General Mkhwanazi, whom part of it is what he termed as an intelligence information. So we have been, for example, Chair, General Mkhwanazi stood in front of this ad hoc committee and said, him and General Khumalo went to the Minister of Police to brief him that General Sbiya is a rogue element within SAPS in terms of intelligence information. So I'm trying to display, Chair, that this is not the first time we're dealing with the situation of this matter. And I'm trying to make the NDPP comfortable to mention the name of the person that she's referring to. It is not certainly a finding or a guilty decision if you mention the name. Part of what we've been placed on here, Chair, is that there is an evidence General Mkhwanazi even brought to the committee and later withdrew some parts of that evidence, and it was acceptable. So I want Chair, the NDPP to feel comfortable to provide the necessary finer detail of the evidence he's giving before the committee. Thank you very much.
Advocate Honorable Matthews. So sorry.
Thank you, Chair. Just to add on, number one, within our terms of reference, as a committee, I know this is an open, it's an open hearing at the moment, but we do have an option of a closed session. I'm not saying that we need to go there. We cannot have, we are wasting our time if we are not getting names. We're also going to leave, and when we go through our deliberations, we are going to say our National Director of Public Prosecutor gave testimony, but we have no proof. Because this thing of having classified intelligence reports is something that is so old that we've heard. I mean, if we go back, even in the history of Parliament, so many decisions have been made on intelligence or classified intelligence reports that we've never seen, we don't know. So we need to make a decision on if this thing is like that high profile, do we take it into a closed session? But I don't think it is that serious, Advocate. On a very serious note, there are many people that have come, they've been cleared and they've cleared their names, but we are definitely wasting our time if we are going to be protecting individuals who, number one, have already, you've said they've been suspended. That means there has been action that has been taken, and I don't think our citizenry is that stupid or not to be able to put it in context that this is still under investigation and they're currently being suspended. We're also undermining the intelligence both of this committee and South Africans at large. Thank you.
Honorable James.
Thank you, Chair. Advocate, you've just mentioned that you don't trust crime intelligence. Am I right? Earlier on, you've said that you don't trust crime intelligence, and now we are expected as South Africans and as this committee to trust crime intelligence. The purpose of this ad hoc committee is basically for show and tell. We want those names, and I don't think we're going to be okay today with leaving here because everyone else's names, and I don't want to repeat what my colleague has just said. We've mentioned names of all other people that's implicated in this, and the words that were used was allegedly involved. I'm not sure why we can't do the same here today.
Advocate Batohi.
Thank you, Chair. Firstly, I want to make a correction. I didn't say I don't trust crime intelligence. I said there were people across the system that we couldn't trust. We don't know who to trust. Actually, not specific people that we don't trust. The way I said it is, I said you don't know who to trust. So, just to clarify that. Chair, I hear what the committee members are saying. It has always been the position that when we are investigating, we do not give names of anyone that is the subject of an investigation. From the NPA, we only mention the name of a person in any media report or publicly after the person has appeared in court. That is the only time we do not even mention that people are the subjects of investigation. Names are never mentioned by the NPA generally. That is our policy, and that is to protect people. I don't want to protect criminals, of course, but we live in a constitutional democracy, and we must protect the rights of people, even if you are the subject of an investigation. And I hear what the honourable members are saying about the fact that other names have been mentioned by other people that have appeared before the committee. I don't know whether that's right or wrong, but I know the committee wants to do its work and wants to get to the bottom of this. Maybe the idea of a closed session is not such a bad one, because it is at the level of intelligence, and I think it will be hugely irresponsible of me to mention the name of a person. You know, it's easier said than done. We can sit here and say, you know, there have been allegations and people have been cleared, but these things destroy people's lives. And as prosecutors, we have a lot of power to make these decisions that affect people's lives in a very real way. And I've always implored upon prosecutors to please take your responsibility seriously. The impact of our decisions impact people's lives. So we must make the right decisions and make sure we have the evidence when we make a decision to prosecute. But that is taking it to another level. At this level where we are here, when we make a decision to prosecute, we have a lot of evidence already. Here I'm in a situation where all I have is the flimsiest bit of intelligence with a name that may or may not be true. And I still urge and I ask the committee to respect that. I cannot say it in an open platform where the many people of South Africa are listening. And I want the people of South Africa to understand that I don't mean to be disrespectful to you at all, and this committee. I really want to be responsible and not destroy even a single life. It's one too many. So I unfortunately cannot say it in this open platform, Chair.
I want you to help us here. Because you give us a report here that the official is on suspension. Is that correct?
That's correct, Chair.
And then this suspension, who effected the suspension?
Chair, if I give details about this, it could reveal the identity of a person, and it becomes if you say enough about something that actually reveals the identity, it's the same as saying a name. So I really want to urge that I can say things in a closed session, as I said. I'm happy to consider that.
I hear what you are saying, Advocate. You know, if you start investigations, because you want to discover certain things, you can say now, because we are still at a stage where we are investigating, we may not want to jeopardize the process. But if you investigate and reach a stage where you make a decision to say, Lakhanyan, we now come to a point where we suspend you, you are acting in public office, isn't it?
Chair, for the sake of clarity, I didn't say the person was suspended for this issue.
But the person is on suspension. Yes, that is exactly what I'm saying, that if you act in public office, any decision that is taken by, it's an administrative act, isn't it? And for sure you should be able to explain that decision, unless you were to say to us, like, you know, when we administered oath here, the law says you are expected to answer any question fully and satisfactorily, and failure to do so, you may be committing an offense. And if there was a law that prevents you to do that, maybe it will be advisable to you to say, I'm mindful of the oath that I've taken, but there is this law that prevents me. Because when you act in public office, the other arm of that action is accountability. you should be able to account on the decisions that you have taken, especially that, I mean, the suspension of a person or removal of a person from office is in public interest. I mean, the public wants to know why this person is no longer in office. How has it happened? Is this decision arbitrary or is it justified? If you understand what I'm saying, it's not like you are still investigating. A decision has already been taken to suspend the person. So what is it that makes it difficult to you, advocate, to say the person who is suspended is Soviet Lakhanyan?
Chair, I said that the person is not suspended for these allegations. And if I mentioned anything more about it, it may become clear who the person is. And for that reason, I do not want to say anything more about it. Chair, I would think that the Constitution actually requires me to act fairly when we take decisions. And this, in my view, is being fair to someone who may or may not be implicated in organized criminality. But of course, the matter is under investigation. Those allegations have been referred and they are being investigated.
Can I check honorable members who want to speak on this matter? Honorable Skosana, Honorable Ngola, Honorable Nomvalo, Honorable Malema.
Thank you, Chair. I'm sorry, SC. Perhaps.
Honorable Sols will be the last.
Oh. I'm sorry, to have, because there was a nice questioning to advocate. I never thought this matter is so complicated. But in my view, names have been mentioned. The president has suspended someone, which perhaps, maybe there's another ones who are suspended, some prosecutors, fine. But I don't think it's right, advocate. Because where do you draw the line? When things are genuine or are not genuine, where do we draw the line? Because this committee sits here to probe these issues. The allegations which were made by General Mkwanazi. Hence we are here. We are not casting aspersion to anyone. But we want the truth. But if it's an animal farm, names were mentioned here. No one ever complains about names being mentioned here. It's for the first time for me, from hearing from you as a national director of public prosecution. When you talk about people's life being destroyed, I can tell you, don't go there. Because he invokes pains to many South Africans who have lost their lives, others their livelihood because of the NPA. Some are still being prosecuted, for many years. Their cases are still in court. But we are going to come to those questions to you at a later stage. But for now, it was only about the name. Because the media has made those names. But we don't want to rely on the media because we are here. We don't want to have the merits of the case.
I don't want to debate the question. I want to hear you. What are you saying on this matter?
I'm sticking to my question, my earlier question. Thank you, Chair.
That the name must be revealed.
Thank you.
Thank you very much, Chair. It does look like the NDPP is putting a barometer or a barrier in that they can only disclose the name of the person once that person appears before court, which I presume that she means the first appearance. Chair, given the fact that we have agreed to seek for an extension as the ad hoc committee, I think for progress' sake, let's say we will require the NDPP or anyone who will be at the helm of NPA before we consolidate the report to submit a written report in specifically on that particular aspect. So that we proceed for now, but the committee must not be disadvantaged in collating necessary evidence so that that particular evidence informs what the committee finds in its findings and recommendations. So I propose, Chair, that before the committee does its winding up report, that evidence must have been sent through a written report to the committee. Thank you very much.
No, thank you very much, Chair. No, Chair, we just want to make a clear statement that if the NDPP continues to refuse to reveal a name, it means she is not cooperating to an investigation. Because here we're not doing oversight. This is not a justice committee being chaired by Honorable Ngola, where you give annual reports. We're doing an investigation, and names have been tabled before this committee. Names of people who have not even been charged. Just names of people who do not appear before any disciplinary committee. So it means you don't have confidence in this committee. Two, you are undermining our intelligence. What adverse impact is it going to have if you tell us that a person is so and so? There will be no adverse impact other than an impact that is imaginary. We are just imagining that there will be an adverse impact if you mention names. How? So we are going to understand you to be refusing to cooperate with this committee if you refuse to give us names. Yeah, we are investigating, so you can't tell us how we should investigate. We can't be told by you. We have terms of reference. We know what we are doing here. So don't undermine our intelligence. Chair, I'm in support of what Honorable Skosana is saying, that the name must be revealed to help our investigation, to pursue our investigation, because that name might be relevant for us to take a certain posture with regards to this investigation. So you are refusing to give more insight about issues which are affecting our justice system if you refuse to give us a name. And we are not just asking from an ordinary person. You are the NDPP with a statutory responsibility to oversee the running of the NPA. And you come here and refuse to give us names as if it's a choice. It's not a choice. We're investigating you. We're investigating the allegations, I mean. And if we say give us names, unless you are telling us that you are refusing, then we're going to note it as such. We're going to write it down that you are not cooperating with this investigation. Thank you.
Honorable Malemo.
Chair, NDPP must know that she's got a duty to protect this country more than individuals. You can't say, I want to protect individual because of their rights and all of that. A rotten NPA, it's very dangerous to our constitutional democracy she speaks about. A rotten NPA is dangerous to the Constitution of the Republic of South Africa. So you cannot protect an individual over the Constitution of the Republic of South Africa. Just her failure to respond to this question, she must take her bag and go. She's not going to be useful to us. We are asking names. That's why we are here. We are told there are people who kept people is names. Who are those people? We want names of drug cartels. We want names of corrupt police. We want names of corrupt judges. We want names of corrupt prosecutors. That is the whole idea of us being here. So you call a witness, when she left home, she left saying she's going to do what here? She's coming to read a policy statement in an inquiry. Yeah, we even discuss boardroom. We're discussing pillow talk. Yeah. Yeah. That's how far we go. Now we're being told, no, just a name. We can't be given a name of a prosecutor who's suspended. I know that there is a prosecutor called Chauke in Gauteng who's put on a special leave or suspended by the President of the Republic of South Africa. It is the President who communicated that publicly. What is so difficult for an NDPP to refer to such a case and say, for instance, we've got this case that is on, but I can't give details. This is what it involves. A lot of people came here and said so. This is a public information. But to come and say, I won't give you names, even on matters that are public, that is having taken a conscious decision that I'm not going to cooperate with them and I'm going to show them that they can't do anything. She's completely undermining us. To put it mildly, she's undermining us, and she left her home having taken a decision to come and undermine us here. What is so secret about telling us about a public prosecutor of a public prosecution? Everything is public there, except when you are dealing with the case. It says I will give you a name when a person appears in court. The person that we're speaking about, for instance, Chauke, he's not going to go to court. It's an inquiry that is on. The president is investigating a particular conduct, wrongly or rightfully, I don't know. So it means we'll never hear that name Chauke in this committee, because he will never have a first day appearance in a criminal court. What happens? There is an internal, inquiry that the president has constituted. The head of NPA must know about that, must be comfortable to speak about it. And the refusal to speak about such an incident is to say, I'm not going to cooperate with you. Actually, the allegations goes further, which we are going to probe later when it is our turn to ask questions. They say after they arrested Advocate Chauke, they are able to register cases easily. That's what SAST says. And cases are moving smoothly in Gauteng. Is that true? We want to get into those issues, but if the head of NPA is going to shy away from that, then which issue are we going to deal with? We need prosecutors who are cooperating with drug cartels.
Thank you, Honorable Malema. Honorable Sauls.
Chair, indeed, advocate is required to give us names. It is true. However, it is not true that names has been given in this committee. We still don't know the names of 3 out of the big 5. Why? Because the witness stated that it is under investigation and the names will be revealed, and it can be revealed in camera. It can be revealed in a closed session. So we must be honest about this, that it is true that advocate must give us the names. But the question is not must you give us the names or not. You must give us the names or name. But the question is how? Which platform? What is the requirement for you to give it in closed session? If we go by what has happened in the past in this committee, the statement was, I cannot reveal in public the names of the other 3 of the big 5, even though the committee wants to know, and that's what we are investigating. It's because it's still under investigation. You testified, advocate, that the person you are referring to is suspended, but the suspension is not connected to the allegations that you are referring to. In other words, whatever you are referring to is still under investigation. And it is for that reason that you don't want to publicly reveal the name, if I understand you correctly. This then satisfies the same requirements that was put forward before. Where I will disagree with you, advocate, is if we say to you, you must reveal the name, but you must reveal it to us in closed session because it is still under investigation, and you refuse at that point, then I will disagree with you. Because that would be you intentionally hampering us from doing our work. But if you are willing to reveal the name in closed session, that would be in line with our terms of reference. So, Chair, I support the position that the advocate must reveal the name. But if the advocate opts to do so in closed session, that is in line with our terms of reference, and she should be allowed to do that. Thank you, Chair.
Advocate Breitenbach.
Thank you, Chair. Chair, I understand the need for the members to hear the names, and we all need to hear them. Advocate Batohi has made it quite clear that the person she is referring to has not necessarily been suspended for the facts that we are now talking about. And she doesn't have control over the investigation, and the other agencies that are involved in, obviously involved in such an investigation. And so for her to sit here and publicly name people could not only undermine the investigation, but it could also undermine other agencies who are busy with important work. And so I would agree that she must be fully open and honest with this committee, but not in an open forum. And for the sake of progress, I think we should move on with everything else and then deal with this issue at the end, and in a closed forum. Thank you, Chair.
Honorable Sangwan.
Yeah, thank you, Chair. No, I think I've generally been covered by all the members who spoke, and I align myself with the recommendation on the closed session. Chair, because we were discussing this matter and we don't need an answer now, I can wait until we're questioning. But I'm hoping that Advocate Batohi is also going to give us the reasons why she recommended to the President that Advocate Chauke be suspended. I would appreciate that we get that. Thank you, Chair.
Pangazit.
Thank you, Honorable Chairperson. One, I actually wanted also to align myself with the shall I call the demand by this committee for the name to be actually mentioned. However, I do want to support Honorable Ngola in the proposal that he made, namely that perhaps at the end of this process, the NPA, whether it would still be Advocate Batohi or the new one, be able to actually supply us with the information related to the matter that we are dealing with right now, including the name. But I also am not comfortable if the advocate simply refuses to give the name, because names have actually been mentioned here. And Mkhwanazi did not actually beat about the bush in saying categorically that within the NPA, there are elements that have actually compromised the operations of the criminal justice system. So we cannot be overprotective of individuals, because we might be protecting the very element that we need to know about and deal with. Thank you.
SC.
Thank you. Thank you, Chair. I was going to propose just a short adjournment for Advocate Batohi to confirm with Council to consider making the disclosure in camera. Thank you.
No, I will grant you that time during the break, because I think we should go ahead with the work of the committee. Advocate, I think you hear the sentiment of the committee that The committee, one of its terms of reference, which we read to you this morning, is that it is also investigating alleged corrupt relationship between officials in public institutions in the crime in the criminal justice system and members of the public. And if we are going to successfully do that work and report to Parliament, but also when I carefully listen to you, when you made your opening statement, you say, this ad hoc committee and the commission, the work that they do provide an opportunity for Parliament to make necessary interventions in the strengthening of the law that we have. So it's going to be very important that we have. Remember, the reason why we want the names is we have to decide on the witnesses that we invite before us here. And if we don't have those names, all these witnesses, the reason why the committee said the first witness must be General Mkhwanazi was because we couldn't just sit like this and throw the bones on the floor and the bones will say there is an elephant here, there is a lion here, there is a porcupine here, you must call them before. General Mkhwanazi came here and named institutions and mentioned names of officials, and we were able to make decisions on who we must invite, who must be a key witness, who is secondary witness, and the order in which those witnesses must appear before the committee. So I will take solace to what the SC says that during the break, I mean, when you come back from the break, you will give an answer as to how that name is going to be made available to the committee. And in this regard, I would like us to continue with the proceedings. Is that fine with you, Advocate?
Chair, it's a good first step. I will certainly confer with Council during the break. Whether we'll be able to come back immediately or whether I need to get a proper legal opinion on this is something we will consider. But I really want to assure this House I do want to cooperate with this House. And I certainly do not want to be disrespectful. This is important work as you put out. So we will certainly look at how we can best deal with this issue. Thank you, Chair.
Thank you, Advocate Batohi. Can we perhaps just explore this very issue a bit further? What is the difference between the suspension of Advocate Chauke by the President? Is it because he's a DPP and this particular prosecutor is not?
Advocate Chauke has been suspended by the President because he is a DPP. That is correct.
So the suspension in this case would it have been effected by you? As the
Well, it depends.
NDPP
As I said earlier, Council, I don't want to say anything further because it could reveal the identity of the person.
Yeah, I'm just trying to explore what the reasons might be. I can understand from a reputational point of view that someone's name who's still being accused not be disclosed, but it is so that many names have been mentioned during the course of these hearings, and members understand it's on the basis that there are allegations. But there may be a different perception out there in the public that I can also understand. The other thing is this, you actually mentioned that the reason for the suspension is not related to what was mentioned to you by, I don't know, just you can correct me if I'm wrong, by Lieutenant General Khumalo and the National Commissioner. It is for some other reason.
That's correct.
Isn't that a reason why perhaps the name should be mentioned? Because I think the concern is that given that allegations have been made by, amongst others, Lieutenant General Khumalo and also the National Commissioner and Lieutenant General Konazi, that this appears to be a person who's been suspended, but not for the reasons that they allege. So why can't the name be mentioned?
For the same reasons that I mentioned earlier. And I'm not sure if you want me to repeat those.
No, that's fine.
Chair.
We did say that, I think that the chair did point out that during the break you can consider your position and take legal advice and get a legal opinion if necessary. Because as you know, we in a different forum to the Madlanga Commission. You are also protected by parliamentary privilege. And it's parliamentary privilege is only lost if at the end of the day you are found to have lied or for some unlawful reason. So you are protected. So you are in a protected environment. You're not persuaded.
I'm in a protected environment. I'm trying to protect others.
Well,
for the reasons that I mentioned.
I think that person will understand that you have to make the disclosure because of parliamentary privilege that protects you, and now there is a request, strong request, from the committee that the name be disclosed.
Chair, I ask that I be permitted to seek legal advice on this matter and come back to the committee, but I assure the committee again that we do want to cooperate. I do want to cooperate fully.
Yeah. I think that's why the chairperson had, like with other witnesses, read out the oath and even before that explained what this committee is all about. Okay, if I'm just, I think we were going on to the statistics that you mentioned at paragraphs 71 and 72. This is all in relation to misconduct cases in the period from 2019 until March 2025. You want to discuss that briefly? 71 and 72?
Yes, so in terms of the NPA Act, there is a provision that allows for the creation of such an office to deal with issues relating to integrity. There was an integrity management unit in the NPA. But that was not in terms of the Act. We've now, in terms of the Act, set up the Office for Ethics and Accountability. And it's responsible for handling or investigating any complaints relating to improper conduct on the part of a member of the NPA. But not just reactively, it is also responsible for promoting a culture of ethics and accountability within the institution. So there is a proactive part to the functions of the OEA as well as a reactive part to it. And so we've, the Office of Ethics and Accountability, and as we say, its precursor, the Integrity Management Unit, has received 58 complaints which relate to allegations of corruption from 2019 to 2025. 31 were closed as unsubstantiated, 16 referred to labor relations, and 7 were classified as representations linked to particular cases, which means there's another process to be followed and not a disciplinary process. And 4 are investigation. Of the 11 matters that were concluded, 8 employees were dismissed, 2 resigned, and 1 was found not guilty. But the Office of Ethics and Accountability is really a very important development in terms of trying to inculcate a culture of ethics and accountability in the National Prosecuting Authority, and making it clear that to prosecutors, that we serve only the people of this country. We are the people's lawyers, and we pride ourselves on being just that. And that we serve only the people of this country. We should act as the Act says, without fear, favor, or prejudice. And this, the Constitution and the NPA Act. And this shouldn't just be a cliche. It should be demonstrated by the work that we do, that we in fact act without fear, favor, or prejudice. So this office is very important in terms of ensuring that we inculcate a culture of ethical conduct in the NPA, of the highest standards of integrity. And if these are breached, that they will be properly investigated and there will be consequences. The one thing I can assure the people of this country and this House is that when there are allegations against any prosecutor, we do not sweep it under the carpet. It's a fair process, it is properly dealt with, and there are consequences.
The issue of the suspension of this potentially corrupt prosecutor, was that referred to the Office of Ethics and Accountability? Because I see it's been referred to IDAC.
Yes, it's been referred to IDAC because I believe that there should be a criminal investigation into this matter, and we needed to get more information, because I just got, as I said, some kind of information. So we needed to look into it more carefully to ensure that at the end of the day, we can decide on what processes should follow from there. So this is the first step in what could lead to other processes as well.
But still on this theme, I'm afraid, given the seriousness of the allegation, I'm talking about this particular prosecutor, but also given, as several honourable members have pointed out, given the importance of the work that the NPA does, given that we all accept that trust in the criminal justice system across the board, NPA, the police, other law enforcement agencies, is at its lowest. Isn't a last and the more effective deterrent to name and shame errant or miscreant prosecutors, rather than going through this formal process, which one understands that must be followed, given that you've got to weigh up the rights of those accused and the accusers.
Chair, I agree.
If prosecutors should know that an allegation is made against them, it might be made public.
Chair, I agree that errant prosecutors should not be tolerated in the prosecuting authority, and there must be processes. We do not, as the NPA, make any comments about internal disciplinary processes that are ongoing. That has been the policy of the NPA. But it's not because we are protecting anybody. Processes do, as I said, when there's allegations, we make sure there's a proper process, whatever it might be, and there's consequences. Because there's absolutely no room for errant prosecutors, dishonest prosecutors, corrupt prosecutors in the NPA. And so I'm not sure whether the council is going back to, your question relates to disclosing the name of this person. But again, I'm imploring that we be given the opportunity to consult and decide on how we take it forward. And a closed session which has been proposed might be the best way forward. So I would urge that we be allowed to at least take advice on that.
Okay. Can we also perhaps just jump to the actual reason why you're here? That's in relation to allegations by General Mkhwanazi in relation to the PKTT, the Political Killings Task Team. I think you attended a first meeting, or one of the first meetings of the Interministerial Committee when it was, the Interministerial Committee was established in 2018 in May. You were appointed in 2019. Subsequently, did you attend any meeting? What was your first sort of contact with the PKTT?
Chair, if you can just refer me to the, Honourable Council, to the relevant paragraph, but just to say that it was in 2019, I'm not sure, but it was earlier in my tenure that there was a meeting in Durban. The meeting was attended by the Minister Kele at the time. It was Commissioner Sitole who was there, and the DPP of KwaZulu-Natal was there. There were members of the PKTT. I don't know who was there from the PKTT, but it was about the political killings task team and having a dedicated capacity of prosecutors to support the work of the PKTT. And so that meeting was held in Durban, where we reached agreement in terms of how the NPA will work, the NPA in KZN will work with the PKTT. That was the one meeting that I did attend.
But you yourself, you weren't involved. I think we reference it from page 13 of the statement.
What paragraph is that, Council?
From paragraph 31. Sorry. There isn't a specific reference because of your own direct involvement is not with the PKTT at all. What you do reference is that Advocate Harrison, DPP of KZN, was involved with the PKTT, with the prosecution guided intervention that she made. You're aware of that?
Yes, that's correct, Chair. I am.
And you would have received the reports from her from time to time, certainly on an annual basis, about the work that they were doing with the PKTT.
Well, not specifically just the PKTT, but DPPs submit reports to the National Director, and we include various aspects of the operations of a DPP's work in a province. And so in the context of that, they would have been reporting, and there may or may not have been reports that related to the PKTT in that context.
And she, in relation to her own experiences, she has given evidence elsewhere, and that can be referenced.
Yes, absolutely. She's testified at the Madlanga Commission, and if necessary, she can testify before this committee.
But in the almost 7 years now that you've been in this position, is there anything that stood out for you about the work done by PKTT, whether it was a successful task team or unit, in relation to resolving political killings, in particular in the KZN province?
I can't comment on whether they were successful or not, but if, you asked me about anything that relating to the PKTT that I was involved in. There was a time early in my tenure when there were complaints by the police, I think it was particularly Minister Kele, that the prosecutors were not enrolling cases were from the PKTT. And there was a bit of a problem between, in terms of how the prosecutors and the PKTT investigators were working. And there were a number of dockets that were referenced that the police were not happy about. I then got a report from the KwaZulu-Natal DPP about each of those cases, with reasons why the cases were not enrolled. But that is the one specific instance that I recall about getting a report on cases being dealt with by the PKTT from the DPP KZN. Apart from that, there's no specific issues that came up regarding the PKTT. So I cannot say whether it was successful or not. It was something that the DPP will be able to testify about. They did work in the prosecutor-guided model that you mentioned earlier on. This model, I deal with it in my affidavit. I'm not sure in which paragraphs.
It's from paragraph 62 onwards, and you discuss it in the context of the functioning of the criminal justice value chain and the role of prosecutor-guided investigations.
That's right. So,
which relates to paragraph 4.1.8 of the Honourable Committee's terms of reference in relation to interagency coordination among SAPS, Crime Intelligence, IDAC, NPA, Correctional Services, Metro Police, and the legal basis for directives affecting the PKTT. It commences at paragraph 56.
yes, thank you, Chair. And so, the importance of working together with our partners in law enforcement is hugely important. I mean, to state the obvious, the system can only be as strong as the weakest link. And I'll get to the prosecutor-guided model, but this is just one example of how we have tried to work very closely with the South African police in particular in utilizing this model so that prosecutors and investigators start working from a very, very early stage together in order to ensure that the evidence is something that will meet any kind of challenge in court. And so this model is not peculiar to the PKTT. It's a model that's been adopted for many years in the prosecuting authority, starting from when the specialized commercial crime units were set up. It's over 20 years ago, I think, when the police and the prosecutors co-located to deal with serious economic offenses, commercial crimes. And so we've also utilized this methodology in the PCLU, the Priority Crimes Litigation Unit, which deals with certain types of specialist crimes, for example, international crimes, as well as terrorism. And the organized crime component also utilizes the same methodology. And if there's a case that is complex or high profile enough, and we think there's a need for prosecutors and police to work closer together, the same methodology is adopted. And so, it really...
So just to pause there, it's not only in relation to a specialized unit or particular task team. That model would or could also be adopted in relation to a particular case, a case of some complexity.
Yes, absolutely. So, this methodology can be adopted at, under as long as the criteria are met. It's sufficiently complex.
What are the criteria?
Complexity, it depends on the gravity of the offense, the complexity in terms of corruption. There's often layering, money laundering involved. But it could also, where you require data analysis, lots of forensic work to be done, really enhances the complexity of investigations. But we could also, a matter could be high profile, but not necessarily complex. But because it is something that is a priority case, we might then say, look, there's a need for prosecutors. It could be a murder matter. That's a high-profile matter, and prosecutors and police officers need to work closely together. Then we would say, look, this is something that we should adopt this model in.
I ask that because there is some criticism. For example, why is such a model not employed here, say on the Cape Flats, where it is notoriously, it's a notorious fact that it's controlled by gangs, 27, 28s, We now see the high-profile prosecutions currently in court with Modak and Donkey Boyson and people like that. Or is it a case that they were brought to court having adopted the same model?
Absolutely, that is the response. I did say organized crime cases as well,
Yeah.
and the cases in Cape are a good example of that, where this model has been employed rather successfully, because prosecutors, investigators working very closely together in extremely difficult circumstances and dangerous circumstances to bring to book some of the most violent and dangerous organized criminals globally.
Now, you wouldn't be directly aware, but the PKTT, their reach had also been extended beyond KZN. For example, they were investigating the alleged corruption at Fort Hare and made a number of arrests there. And then also in Gauteng itself, going into and arresting Molefe and assisting the Gauteng murder and robbery unit in Gauteng. Would that have also been pursuant to adopting the same approach?
Yes, definitely. In those cases, in the Fort Hare matter, although it was a political killings task team, but their mandate clearly had expanded to include, in the Fort Hare matter, it's an economic commercial crime, commercial case. And so they were involved in the University of Fort Hare matter. And I am aware that they also were involved in Gauteng.
Has this approach enhanced and improved the success in the rate of prosecutions at the NPA, especially in relation to high-level crime, organized crime, drug syndicates, and so on?
So it certainly has, in some very, very complex matters where prosecutors and investigators work together. I don't have the figures here. I can certainly give you, I think I'm not sure if I've got the organized crime stats, etc., in terms of successful prosecutions, but I can get that.
We have your annual report.
Yes,
there,
we can certainly get
24,
those
25.
figures. They are all in there. So it's a model that works. It's an internationally recognized model, and we do have evidence that it is better. But I do think that the model itself can be improved, because even with some very complex matters, we find we're not moving as quickly as we should. And those are because of systemic problems, whether it's, lack of capacities, capabilities, lack of, whether it's corruption within our ranks, but some cases just don't seem to be moving, even though this model is adopted. So there are various challenges in the system, and the model can only be as effective as the efficiencies in a system as a whole. But we have found that where we do employ this model, it does work better in terms of the results.
Because, as you well know, better than anyone actually, that there is a lot of frustration amongst members of the public, even the honorable members in this House, that that the high-level criminals are not being prosecuted successfully and not being seen to get into what is called orange overalls. Or you can also in that context discuss several of the referrals that were made from the Zondo Commission to the NPA and the prosecution of those individuals.
So I think firstly, Council, before I answer your specific question, just in terms of coordination as a whole, the PGI model is just one, that's a prosecutor guided, is one model. But I think a really good example of how we did well as a country was coming out of the FATF grey listing. And that was really an example of how, when we as government come together with a common objective, and we put the necessary skills, resources, capabilities, and energy into making sure we get over the line, we can do it. And the FATF collaboration is an excellent example of, because you have, it's not just law enforcement, it's government, it's agencies across government. So we're looking at Treasury, we're looking at the Reserve Bank, we're looking at state security, the police, SARS, the NPA, and all of these entities, the Department of Justice because of mutual legal assistance. So a whole of government approach in 2 years for us to get over the line, to get off the grey list, was a monumental effort by various entities in government. But again, it's a really good example that we can, when we get together with a common objective, deal with something effectively. And so I hope that we can take lessons from the FATF process to make sure that we're able to deal with some other types of priorities and matters that need attention in our country. Dealing with the high-profile cases not coming to court, I really want to make the point that a prosecution is only as successful, and I'll get to Zondo because, the Zondo Commission recommendations, because in the NPA, the IDAC has an investigative capacity to investigate very specific matters that are in the Act, specified in the Act, its mandate. But with regard to dealing with organized criminals, the kingpins that are not or rarely brought to court, I think the Western Cape organized crime is a good example. But the reality is that we are not winning the fight against organized crime in this country. And it all starts with good intelligence. The only way of getting to organized criminals is to ensure that we have solid, good intelligence that investigations can be built around. And the other way is you have to follow the money. We have to make sure that we have capabilities, capacities in government to be able to do effective, quick financial investigations, because people at the upper echelons of organized criminality don't get their hands dirty. But they certainly don't stay far away from the money. So whether we're dealing with all kinds of organized criminality, a range of them, whether it's drugs, whether you're dealing with wildlife crime, whether we are dealing with gangsterism, fuel theft from pipelines, illegal mining, environmental crimes, all of this requires us to have capacities and capabilities to deal with more effectively with investigating money trails. But it starts.
But can you explain the relative success of the SIU, the Special Investigation Unit, even your own asset forfeiture unit, because they follow the money. Mm-hmm. And they go to the special tribunal, they go to court, and they freeze huge amounts of assets, and subsequently they get forfeiture orders, and billions is paid into the state account. But the people who are involved in the proceeds of this illicit amounts of money, they still are free. They still walk free. They are not being prosecuted. So perhaps this is an opportunity to just explain the differences, the standards of the kind of evidence that you need to successfully criminally prosecute these people.
So the work of the SIU is, of course, to deal with civil recoveries primarily. And the standard of proof in terms of the SIU Act, which I don't have in front of me, but it is on a balance of probabilities. It is not a criminal standard. And in terms of the SIU Act, where there is evidence, and I stand to be corrected because I don't have the Act in front of me, where there is evidence that points towards criminality, then the matter must be referred to the National Prosecuting Authority. This in itself, and I would ask honorable members, when you are looking at amendments to the SIU Act, that an amendment be effected to the effect that when the SIU finds evidence that points to criminality, that they refer the matter to an investigative agency, not to the NPA, because but for a very small group of, class of crimes that could go to the IDAC, the majority of these matters, when we get them, we have to send them to the DPCI for criminal investigations, because the standard in criminal investigations, and I deal with it somewhere in my affidavit, is a reasonable prospect of a successful prosecution. And that means we have to ensure that that is only when that standard is met are we able to then decide to prosecute. And we have got figures on, we in fact have reported to Parliament, many times appeared together with the SIU and the DPCI to deal with all of the referrals from the SIU, what happens to those matters, those that are prosecuted, those that aren't. And so there's a huge difference between a civil standard of proof and a criminal standard of proof. And the same applies for the Zondo Commission. The Zondo Commission did not give the law enforcement a blueprint for prosecutions. They actually, gave us a lot of information, leads, evidence, but we still needed to investigate to ensure that we met the standard of proof required for criminal investigations. So I have somewhere, if your chair, if you'll just give me a few moments to just access these figures that will actually give the committee a better understanding of what the position is regarding the Zondo Commission recommendations. Advocate Johnson did allude to this. But if I'm allowed to just look at the work of the IDAC again in terms of its numbers, and I'm struggling to find it in my, but if the committee will allow me, I'll look at the actual figures, but we are looking at over 300 entities and accused persons that are already in court as a result of the work of the IDAC. I also want to emphasize that, yes, of course, the frustration that you talk about in terms of people not yet being in orange overalls is something that, as the national director, I feel as well, because I would have certainly, as I said earlier on, hoped that some of these cases moved quicker, not just through the investigation phase, but also after they are enrolled. With regard to the investigation of these matters and why they've taken this long, many of them, although there are over 300 matters that are enrolled or accused entities and persons in court. The IDAC was made permanent in August last year. And prior to that, the capacitation of the IDAC was dependent on secondment model. And that is, you have other entities, government agencies that actually second resources to the IDAC. It was extremely difficult because when you have other agencies that are also struggling with capacitation challenges, you don't expect that they are going to give you the best to allow the IDAC to do its work. So there were a lot of challenges with getting the right capacities, capabilities to IDAC. Also, it's very difficult to capacitate, as you know, as parliamentarians, a temporary structure. And IDAC was not a permanent structure. Since it became permanent in August last year, we have been able to have a proper structure in place. We've been able to capacitate, get the necessary skills, etc., to ensure that IDAC is able to do its work. And so that is one of the reasons why it's taken this long. But now we have partnered with various entities to get the work of IDAC, and the numbers show that there are a number of cases in court, but getting to the point of orange overalls also depends on the court system. And the Stalingrad tactics that are employed in a court system really frustrate court processes in terms of getting cases to finality. And there's a lot of work to be done, including by the judiciary, that requires stringent case management to make sure that these cases do in fact move quicker through the court system.
So, just at this point, then discuss briefly the main aspects of the prosecution policy which prescribes the various factors that must be considered by a member of the NPA, also called a prosecutor, which applies across the board to yourself, DNDP, PPs, directors, prosecution, the investigation directorate, and the whole range of officials. Just discuss that policy so that again we can understand what your own role is in it, and whether or not you can interfere in the prosecution process. Perhaps sometimes if you're frustrated that a particular case, especially high-profile cases, are not moving or getting to court.
In this context, it's important to outline how the structure works. How the structure works. So, you know, the National Director is the head of the NPA. And I'm going to deal with this as crisply as possible because I'm mindful that we need to understand, but I need to try to be concise at the same time. So the NDPP is the head of the organization, but the directors of public prosecutions in each of the divisions, in terms of the Act, they have the specific power and authority to institute prosecutions. So it is sometimes misunderstood as the National Director deciding to prosecute cases. In terms of the Act, the NDPP does not decide to prosecute any cases. The NDPP actually is a review mechanism in terms of the Act. So it's very important that the powers of the DPP are respected, and that in the event that anybody is not satisfied with a decision of a DPP, they may then apply to the National Director to review that particular case. So it's very important that we understand that. But that said, the DPPs do act under the control and direction of the National Director. And it's important to understand what exactly this means in terms of the control and direction of the NPA. And so
just to pause there, is it then, given the structure and the structure of the NPA, that it would be DPPs who are more likely to be targeted by organized crime, drug cartels, and so on, if they want to infiltrate the system? Because the decision to prosecute obviously in a particular province lies with them to institute.
I would say DPPs and potentially the prosecutors themselves, that, you know, the deputies or the senior state advocates that are actually the ones that are, you know, involved in the case. The DPPs would very often act, you know, on advice of the prosecutors that are involved in the case. So I think definitely they would be at risk, that category of persons.
They're not likely to approach you to influence the outcome of a case, or not to proceed or prosecute the case?
Nothing would stop them if they think I'm open to it. And
Well,
as a
we
national
obviously
director,
have an unfortunate history where there has been the involvement of the NDPP in
that is an unfortunate history, I agree.
yes.
So it's important, and that is why it's important for a national director and DPP, for us to understand what is the constitutional framework that the NPA functions under, and the roles of the DPP and the national director. And the national director and DPPs, we need to respect the delineations and ensure that you know, we do what we mandated to do and we have the power to do in terms of the Act.
But we know, and I want you to reference paragraph 41 of your statement at page 16, to also understand what it means that the exercise of general prosecutorial powers is still subject to the control and directions of the NDPP. What does that mean? And you give some six examples of what it means.
Yeah, and I think, and I start off, I start off by saying what it does not mean. And what it does not mean is a national director can instruct a DPP, a special DPP, or the investigating director to prosecute or not to prosecute a particular case and who to prosecute. That would be unlawful. And in fact, it would also fly in the face of the provisions in the Act which say that the DPP has that specific power, or a special DPP, depending on the circumstances and the ID. And then it means that, as I mentioned earlier, the national director can only intervene when there is a prosecution process, when the policy directives are not complied with in process. The next instance when a national director can intervene is when the policy directives or the NPA code of conduct has not been observed. And then you look at instances where a national director can actually transfer a criminal case from the jurisdiction of one DPP to another DPP in specific circumstances. A national director can direct that certain offences are excluded from the area of jurisdiction of a DPP concerned. And I suppose some examples of this would be where you have centralization, but that's catered for in the Act. But for example, if you have a special DPP that has prosecutorial powers, then it could also be in those instances where it could be removed. And then the sixth one is the normal reporting lines that DPPs have to the NDPP relating to a whole range of issues, whether they're operational, financial, administrative. That is another sort of supervisory role that the National Director has. And of course, we now have the Office for Ethics and Accountability, which is another layer of supervision or oversight, if one wants to call it that.
Honorable Nombalo.
Yeah, no, thanks, Chair. In the context of the response that he has given the NDPP on things that he says she can't do to the DPP. Now, I just want to get his understanding of Section 22, subsection 4A, which says that the NPA states that the NDPP may direct a DPP to submit a report to him or her in respect of any case, matter, prosecution, etc., etc. Now, the question is, if the statutes gives you such powers, then to do what if you can't intervene when there is a need to intervene? Maybe let me illustrate through a practical example. This section says you can direct the DPP to give you a report in any case. Let's say you request for a report for a particular case, and you realize that actually there is no prima facie evidence here to prosecute. Now you say the Act does not give you powers to direct the DPP to either prosecute or not prosecute. So in the event where you request for a report for a particular case, and you realize in that case that actually there is no case here, so does that mean your hands are tied in that regard? You can't advise the DPP to say, let's take this case out because there's no prima facie. Is that what you mean?
Thank you, Chair. That's an important question. So if there's a report received from a DPP And generally, the reports of the DPPs don't go into detail of all the evidence that's in a docket. But if the scenario that's sketched out by the honourable member does play out, that there is a report and that it appears from there that there's no prima facie evidence, that is a serious non-compliance of the prosecution policy. And in those circumstances, the NDPP would be able to say, I'm going to review this matter. I want all the evidence, I want the entire docket to be sent to me, or a national director, and then the matter is reviewed, and a different decision that decision can be overturned.
Now, upon reviewing the matter, and you realize that actually there is no prima facie, after we have engaged in your investigation, then you come to a realization that there is no prima facie, then you can advise the DPP not to continue with prosecution, right?
Honourable Chair, it's not an advice to the DPP, but it will be the National Director overturning the DPP's decision.
Then it means you can have a decision on whether the DPP can prosecute or not.
Precisely. So if
Exactly.
the matter is, it's not a matter of advice, the National Director takes a decision to overturn the decision of a DPP, and then the charges must be withdrawn.
And you call that an oversight mechanism. How do you call it?
It's a review process in terms of the Act.
Okay, no, thank you.
Let's see.
So just in summary, in following that question by Honourable Nomvalo, you do not and cannot interfere in any original decision taken by a prosecutor to prosecute a case, save where a matter is referred to you on review.
That's correct. And the National Director can, if the National Director is of the view that prosecution policy has not been complied with, then you can intervene. But generally, it's on a review process. Otherwise, it is legally incorrect to direct that a DPP prosecutes or not prosecutes a matter.
Well, isn't that perhaps a thin end of a wedge, that under the guise of saying that a prosecutor hasn't followed prosecutorial directives, which are operational, isn't it, in terms of your statement?
Directives are more operational.
They're
and policies-
operational, and so a particular step, for example, hasn't been followed. But how would you know, or who would bring that to your attention, which may result in you intervening, if it's not on review?
That's a valid question. It could be brought to a National Director's attention by any number of persons. It could be a complainant, it could be an accused person, it could be a prosecutor. But when that is brought to the attention of the National Director, you can intervene if it's a question of non-compliance with the policy or the directives. But generally, these matters are brought by way of a formal representation for a review of the matter by the National Director.
Thank you. Chair, if we can adjourn on that point.
Okay. Thank you so much. SC, thank you so much, Advocate Batohi. We'll come back at 14 hours. Good afternoon, honorable members. We must resume our business. Welcome, Honorable Norma Butelis from the MKP. Thank you so much for coming to support us. I saw Honorable Trolip was also here before we took a break. We want to thank you so much, honorable members, for giving the committee your unqualified support. Thank you so much. SC.
Thank you, Honorable Chair, Honorable members. Good afternoon, Advocate Batohi. Advocate Batohi. Good afternoon. Just three more things from our side. The first is you had during the break discussed the issue of the disclosure or non-disclosure of the name. Do you want to respond to that, to the chair, through the chair?
Yes, thank you, Chair. We've discussed that. I've discussed it with Senior Counsel. We will get a legal opinion on this, but we will seriously consider the two options that the committee has put before us, and that is the one to either do it in a closed session or to submit a document to the chair with the name before the committee concludes its work. Thank you, Chair.
Honorable Matthys.
Just a clarity question. Why before the committee finishes its work and not even in the next couple days? Like why would the legal opinion, etc., take such a long time?
Can I note hands of members who want to speak? Honorable Malema, Honorable Sangoni, Honorable Skosana.
No, thanks, Chair. You know, NDPP, it's so embarrassing because behind there is a senior counsel. You see what we're paying for? This is what we're paying for. She brought a senior counsel here. She still wants to be consulting somewhere, how? When you brought a senior counsel here? How much per hour are we paying the senior counsel brought by the NDPP? We can't accept that. At the end of today's session, we'll ask the media to leave, and she will have to give us that name. We can't leave here without that name. The senior counsel is here. It means there's going to be another second senior counsel. How much is that going to cost us? As government. These are the resources of the state we're speaking about that the NDPP should be looking after. So we need that name before we leave here, Chair. When we finish, we excuse the members of the media and the public. We have a closed session, and then we are given the name here. There's no any other consultation which can be made anywhere else. When they brought a senior counsel here, we understood his presence to be meaning on such matters, they want to quickly consult and be able to provide answers. Now we're being told something else before the committee conclude its work. Seated there, seated here, I don't know when is this committee concluding its work. And she's saying she's going on a retirement in January. Someone is going to come and say, no, I'm new, I don't understand, I still want to familiarize myself with the environment, like the one who took the whole year familiarizing themselves and not giving deputies responsibilities. We're going to have the same problem. So we shouldn't allow that. We shouldn't allow that. So please, Chair, I suggest when we close, we have a closed session, we get the name.
Honorable Sangun.
Thank you very much, Chair. No, I think to a large extent I've been covered by Honorable Malem, because what I was going to say is that there are no two options for consideration, Advocate Batohi. We normally take decisions here based on a majority, and I think the majority of members were agreeing to a closed session, and which session we understood to be happening today. I remember Honorable Mates even said we can break and have that discussion. So I think that is what was most acceptable to the committee in terms of the deliberations. Thank you, Chair.
Thank you, Chair.
Honorable Skosana.
Thank you, Chair. I think that we should, in fact, agree that that has to happen now, SC. You know, this issue of postponement, for me, it reminds me of why we are in this problem in this country. You have the Sezomenyiwe case which has been going for long, for a very long time. We are still talking about Sezomenyiwe because the justice system is failing our people. We can't have a NDPP here with us here, sitting with us here, and then it's going to go and ask for a legal opinion elsewhere. We are here. Last week we had Advocate John Johnson. He left some documents, no attachment. Now we are here again, we are going back to that. It's unacceptable, Chair. It's unacceptable, Chair. For me, it's like, yeah, thank you, Chair.
But I did not hear what you are saying. What are you saying, Honorable Skosana?
I'm saying this must happen now, Chair. Thank you.
Honorable Sols.
Aye. Advocate, it is extremely disappointing. I shared my views earlier, and I was hoping that you would see how the committee is accommodating what you are saying, but you are not returning the same gesture. And perhaps it's not even a gesture, it is. This committee is constituted constitutionally. You have a constitutional obligation as a witness, a credible witness, to assist us in this investigation. By you withholding that information, even though we are providing a closed session for you, is very disappointing. And you would be responsible yourself for now tainting your legacy here. After having served with so much excellence and tact internationally and here in the country, to come here at almost the end of your journey in the profession with the NPA, for you to now appear as though you would prioritize the protection of one person over and above the protection of South African citizens. I would implore you, I would urge you to reconsider and make it a point that we do a closed session today and you share with us the evidence that you have that we can use in our investigation for this purpose. So I stand with the House, with my fellow colleagues, that you have to give us that name today during a closed session. That is the best we can do. Thank you, Chair.
Well, the motion is agreed to. At the end of today's session, or at the end of today's proceedings, we shall have that closed session. Thank you.
Immediately or later?
No, I said that at the end of today's proceedings, we shall immediately have a closed session.
You must remember that immediately does not mean now.
I have simplified it for every one of you to understand. At the end of today's proceedings, we shall immediately have a closed session. And in this case, it resonates with what Honorable Nomvalo is saying, that immediately does not mean.
If I may, Chair, thank you very much. I understand the reason why this committee wants the name. This relates to it goes to the very heart of your mandate. And I want to, Chair, respectfully say that in response to, I think it's Honorable Saul's and maybe other members also, I'm not protecting an individual. So I want to be clear, because if I was protecting a member of the NPA, I would not have referred the matter for a criminal investigation. I take it very seriously, and that matter is being investigated. Criminal charges are being investigated. So there's absolutely no issue of protecting any individual. It's just that we have rights in the Constitution, and we must respect those rights. And as the National Prosecuting Authority, we have, as a matter of policy, we have never disclosed the names of people that are the subject of any investigation, even disciplinary matters and criminal investigations. We, as a matter of policy, do not do that. So I hear what the House is deciding. I will have to confer with my counsel again. And to Honorable Malema, just to say that Council has indicated this is a serious constitutional issue, and we don't want to be disrespectful at all. Council needs to understand the context of what happens in these hearings so that we can get good advice that is properly contextualized. It's not just requesting something in a vacuum. So in that sense, I asked, the indulgence, but we hear what the committee is saying, and I will have to consult with the council again before the closed session, Chair. Thank you.
Chair?
No, I don't want us to...
No, I just want to clarify.
To discuss the matter, because...
Not to discuss, Chair. I just want to clarify.
We have taken a decision, isn't it?
Chair, can I just clarify what Advocate has said about myself? I was not saying that you are protecting Advocate. I was saying you are causing it to appear as though. And so I was encouraging you or discouraging you against that.
Thank you, Chair. Understood.
SC, may we proceed?
Thank you, Honourable Chair, Honourable Members. Edward Batohi. Yeah, the second issue relates to the accountability of IDEC, and in particular the head of IDEC, which arose during the evidence of Advocate Johnson, the head of IDEC. You deal with it from paragraphs 52 onwards. We know, well, there's certainly, it seems as if that's the proposed legislation, makes provision for the appointment of an independent judge, Judge Ralinga, who has been appointed. But what is the current position there, and what has been the position prior to his appointment?
Honourable Chair, the appointment of the judge in terms of the NPA Act was provided for as a complaints mechanism for IDAC staff. They can complain, the judge will investigate complaints made against IDAC staff or even by IDAC staff where their work is being interfered with. So, but as this House knows, that those relevant sections have not yet been put into operation. And it is something that the Department of Justice is working on in order to ensure that the Act is brought into operation. But even though this is the case, the Public Service Act and the Public Service Regulations still apply to members of IDAC in terms of any disciplinary processes relating to complaints that may be lodged against members. So just to say that there's no gap in terms of if there is a complaint, nothing will be done. The matter will be investigated in terms of those provisions. But the IDAC herself, of course, being a DPP, the coming into the operation of the Act doesn't even matter. If there's a complaint against the IDAC herself, then of course, being a presidential appointment, there could be an investigation in terms of our OEA, and potentially, if the evidence supports it, then a recommendation to the president. But that is the legal framework at the moment to deal with complaints against IDAC staff members.
So, because this was also a criticism which I'm sure might be taken or explored further by honourable members. So there's no mechanism currently, independent third-party mechanism to ensure accountability and oversight. It's still in-house.
Until those regulations are promulgated, yes, it is currently the Public Service Act and regulations will apply.
And the criticism which you will understand is that this is not a satisfactory state of affairs.
I want to agree. I mean, in a constitutional democracy, you know, when an institution like the IDAC has the powers that it has, none of us as citizens want to be on the wrong side where somebody, IDAC, acts improperly or not in terms of their mandate, and, you know, and we as citizens are affected by that. So I agree that the mechanism needs to be promulgated as fast as possible, put into operation rather, as fast as possible. But in the meantime, I can give the assurance that if there are any complaints against IDAC staff, they will be properly investigated, as are complaints against any NPA member. We investigate and make sure that there's consequences. But the appointment of a judge will actually give a higher and better complaints mechanism to ensure that IDAC acts properly within its mandate.
Thank you, Edwin Batohi. My last issue relates to bail, the granting of bail. And the reason why I raise it with you and giving you an opportunity to discuss it with the Honourable Committee is the criticism of former Minister Cele, who maintains that hard-working, honest police officials are often let down, disappointed. They end up even being killed because what he describes as dangerous criminals. Presumably is also referring to accused of dangerous crimes, murder, rape, robbery, being let out on bail, and then continuing to conduct a reign of terror. Is there a policy? We know that bail is granted by the presiding magistrate or judge. Where does the prosecution fit into this picture?
So the purpose of bail is to, as you know, secure the attendance of an accused person before court. And a prosecutor can object to bail in circumstances where the accused person is either a flight risk or will interfere with investigations. And I should say that in some instances where bail is granted, hardworking, honest prosecutors feel equally aggrieved as police investigators, because especially if we are objecting to bail, and more often than not, if a police investigator advises the prosecutor that bail should be objected to, it's very rare that a prosecutor will not object to bail, because it's the police investigator that must give the evidence to object to bail. And if the evidence is there, we would generally object to bail. And of course, yes, bail is granted by the judiciary. I should say that I am aware that in the process of the amendment to the Criminal Procedure Act, there are considerations in terms of how this regime can be strengthened. But that is the position with regard to the granting of bail.
The the default position is that you're entitled to be granted bail, subject obviously to meeting certain conditions, flight risk, attendance at court, etc., unless it's in the interest of justice not to grant bail. But that involves the prosecution leading evidence that it's not in the interest of justice to do so, and it obviously depends mostly on the investigating officer to either lead that or deduce that evidence or through other witnesses.
That's absolutely correct.
And then you have the extreme cases, the Schedule 5 and 6 offences, I think, where the accused, they have to show exceptional circumstances where they should be granted bail. So there's a bit of a reverse onus.
That's correct.
But notwithstanding that, you still find Schedule 5, Schedule 6 alleged offenders getting bail.
As I said, evidence is presented before the courts. And, the stronger the evidence that the police present to the prosecutor, we'll be able to present that evidence. And where in circumstances where we find that the magistrate or judge got it wrong, we will appeal against it. And that has happened as well. But those are the only remedies that we have.
I think the reason why this issue arises and why I'm asking you about it today also is that's again a potential weakness in this chain where it's susceptible to bribery and corruption, and sometimes the reasons are just inexplicable why an accused is getting bail, given the nature of the offence, given the evidence being led by the investigating officer.
You're absolutely right. And, so we got to strike the balance between a person's right to freedom and, of course, the necessity to ensure that crime is properly prosecuted and those that are accused are held accountable. And so perhaps the amendment process to the Criminal Procedure Act might strengthen that, but currently that is the legal framework within which we operate. And as I said, where we believe that the decision was wrong, we appeal those decisions. But sometimes it's not that clear.
Thank you very much, Advocate Batohi. Thank you, Honourable Chair. That concludes my section of leading evidence.
This is very, very beautiful. You should have warned me that you are only going to take 20 minutes after lunch. I doubt if honorable members, are you ready? Are you sure? I've said to you that we only have one day because tomorrow we have the medium-term budget policy statement. So full member, I'm allocating 30 minutes. Alternate, I'm allocating 10 minutes. And the time is inclusive of the responses. So at 2:30, it's now 25 minutes past 2. Honorable Ngola and Honorable Sokanyile, you are starting at 2:30. Your time ends at 10 minutes past 3. And Honorable Shongwe and Honorable Nomvalo, your time starts at 10 minutes past 3 and ends at 10 minutes to 4. Did you hear what I'm saying? Yeah. And you know the rules about time, ne?
And you start immediately.
You show respect to fellow members by the manner in which you respect time. When your time is up, it is up. No negotiations. You can't extend time. You can extend many things, but it's not possible to extend a second or a minute.
Yeah. Can't you start immediately? Sir?
Yeah, I'm saying the clock will start ticking at 14:30.
Why, Chair? Not now.
I can't hear what Honorable Breitenbach is saying behind you because her microphone is not on.
We all want to start right now. We don't need to wait 3 minutes.
Okay. You want him to start immediately?
Yes, he's ready. For the first time in his life, he's ready. Let him go.
Okay. Can we start? Thank you so much, Honorable Buteles. Thank you so much.
It's God.
Can we start, Honorable Ngola? Thank you.
Thank you very much, Chair. And
Chair, we have that problem of MK again. They are out. We don't know if they will come back or what, I don't know.
highly possible that they've been changed, Chair. So let's be patient.
The Honorable Skosana, you might have seen him. He came to me to say, no, I will be back. Chairperson, I'm not leaving. So I just assume that those other members have some pressures that they have to deal with. They should come back immediately. If we have to use it in its appropriate context. Okay, Honorable Ngola.
Thank you very much, Chair. 1212, Chair, but if time is against me, I know you will humbly borrow me 10 minutes from your time. Thank you very much, NDPP. Good afternoon. I know that when you are doing what we called then the attorney's board examination, where the specific module on ethics, I know when you do a master of laws, you do an ethical clearance application. So that whenever you want to move on your research, you are ethically cleared. I'm not quite sure when you do a pupillage if there is a particular module specifically training prospective legal practitioners to focus on or this expected ethical standard from legal practitioners. Is there one?
So, Chair, through you, is Honourable Member, Honourable Ngola referring to in the NPA?
No.
Generally?
I'm talking about, I spoke about attorneys in general. So, because I've never been involved in the pupillage curriculum. So I'm talking about, is there a module that specifically trains advocates on ethical standards expected of advocates of the High Court of South Africa?
I have to be honest, Chair, I don't know, but I certainly hope that there is.
Okay. Fortunately, we've got about 6-7 advocates in the room. They may later help, because I'm asking this particularly because the head of IDEC, Advocate Andrea Johnson, considered before this committee that she has been part of a recruitment panel that has actually employed her husband. Do you think that is that conduct ethically and legally correct?
I have to agree, on the face of it, it is very bad error of judgment. She should not have been on that panel. She agreed before this House as well that that was not something she should have done. And I agree with that. If your husband is on a potential candidate, you should not be on a panel. Although she explained the steps that she took to make sure that she wasn't part of his interview, but still, I think I agree, it was a bad error of judgment. I've only just received the information last week, and I'll look into it and see whether that was appropriate conduct, if there's anything that needs to be done about it. This was 20 years ago or so. She was a young prosecutor at the time, but it's certainly something that will need to be looked at, because on the face of it, it's a really bad error of judgment. She should not have been on that panel.
Thank you. General Khumalo, amongst other charges that he's facing, is a matter relating to an employment of a brigadier or an SAPS official. Amongst the issues that which have made IDEC or motivated IDEC to arrest General Khumalo is that particular matter. Do you think that Advocate Andrea Johnson should suffer the same consequences?
I don't know the details of the case involving the IDAC case, but what I can say is that context is sometimes everything, and one has to look at the evidence, the circumstances, the context of each case before you can decide whether the consequences should be the same or not.
So is it the evidence of the NDPP that until date, she has never received any form of update in respect of the IDEC case against General Dumisani Khumalo?
Can you please repeat that?
I'm saying, is it the evidence of the NDPP that until this date, she has never received an update or a report in relation to the case of IDEC against the head of crime intelligence, Lieutenant General Khumalo?
Thank you, Honourable Member. No, through you, Chair, that's not the case. I have certainly received high-level reports on this case prior to the arrest. That is the position.
Okay, let's start on prior the arrest. An adult male from Parliament goes to IDEC and alleges that they have got an intelligence information which they picked up from the doorstep, but does not bring that information, but bring the word of mouth that I picked up this, and then I'm going to do an affidavit with you explaining it. Then that informs the basis of the arrest of General Khumalo. So, was it supposed to happen like that, or how does it naturally become procedurally correct?
So, through you, Chair, to Honourable Member, the IDAC has certain processes which Andrea Johnson explained to this House. I'm not involved in those processes. But of course, the start of the process was the referral by one of the members, one of the honourable members of this House. But after that, I'm not aware of, the precise nature of those processes, except that I do know there's a preliminary investigation and there's potentially an investigation that will be authorized. But the IDAC has its internal processes to assess the evidence at each stage.
So you don't have the details of a case between an investigative directorate against corruption, which falls within the ambit of NPA, against the head of crime intelligence in the country?
That's correct. I don't have the details. As I explained earlier, the NPA, the National Director, is a review mechanism. I don't have the details of the case. And if General Khumalo or anyone else is aggrieved about that decision to prosecute, as I outlined earlier, they are at liberty to refer the matter, to bring a representation to the National Director to consider that matter, and then decide whether the decision of the IDAC head was correct or not.
Can I come to IDEC to lay a complaint against whoever and allege that I've got in possession, I am in possession of classified information, intelligence information, and I don't have a clearance certificate to handle classified intelligence information? will IDEC be legally in correct parameters to attend to such a case?
IDAC's mandate is to investigate crime. And in my view, if IDAC gets evidence of criminality, they have an obligation to investigate it. The other side of it is the legality, etc., can be disputed at a later stage. But I would think that IDAC's mandate requires it to investigate cases as such.
Okay, maybe let's move on this one. Can a labor recruitment process of any institution become a criminal trial against anyone who was part of a panel or was part of a interview selection panel and all that? Can it be a criminal case?
Honourable Member, I have what Advocate Johnson mentioned in this House, that the way state capture happened was that critical people were recruited and replaced, many boards, etc., and in the granting of tenders, specific people are appointed to specific positions. That was her evidence. And I don't know what the evidence is surrounding just the recruitment. She also said that this was part of several other matters. And so, to answer your question crisply, it would depend on the evidence.
Okay. General Mkhwanazi appeared before the committee and narrated a story, a very sad story when you look at it from the face value. Now, there was a time when securing a warrant of arrest against an accused person was actually eminent. Eminent. To an extent that the prosecutor did sign, so when it was to be taken to a magistrate, so that a warrant of arrest is officially issued, that prosecutor received a call from the bosses. The bosses in this context would mean someone higher than him or her in the NPA. Then later came back and said, I am withdrawing my signature on this because I don't want to lose my job. Now, part of what 3.1 of the terms of reference of this committee is to investigate collusion. Whether there is collusion between state officials and crime syndicates. So have you noticed any form of collusion except that one that you don't want to mention his name here? We are going to mention later. But have you noticed from 2019 until this date, as you're presiding over the prosecuting authority, any form of or characters or features or signs of collusion by the NPA officials and crime syndicates?
Honourable Chair, I can't say that I've noticed collusion between NPA and crime syndicates, NPA members and crime syndicates. But what I can say is the OEA has been getting reports of compromised prosecutors who are involved in criminal activity that is under investigation. But organized crime syndicates, I can't say that I have that information.
Okay. Let's step out of that. 6 July 2025, General Mkhwanazi takes it to the public and alleges that NPA is playing part in aiding criminal syndicates to evade justice. Then since then until now, before we called you to this committee, what internal mechanisms has the NDPP established to ensure the truthfulness or the untruthfulness of the allegations, and to ensure that there are systematic mechanisms that are will actually enable NPA to avoid such kind of things? Because you'll remember, between me and you, we know that there are part of the cases, big cases, that have directly damaged the image of the NPA. So this is adding to that. So what did the NDPP do in between this time? Because I would ask, because, well, for example, the Chief Justice did issue out looking for evidence and all those things, because judges, judiciary. So what were the steps taken by the leadership of the NPA in attending to the matter?
So, look, these processes are unfolding in the Madlanga Commission as well as in the ad hoc. Now, we've testified, the National Commissioner has testified. I discussed it with Advocate Johnson, and I will be writing to the National Commissioner to ask him to reveal that we want the names of those prosecutors that General Mkhwanazi alleges is involved in any kind of criminal activity, because this is something that we have to investigate. There were no names mentioned. I don't know that he was pressed to reveal names in this committee, but he didn't reveal them. I wish he did. Would have made it easier for us as well.
Actually, I was the first member to ask him questions, and the first thing I said was that, tell us names.
And he didn't.
He did, to a certain extent.
Okay, so
And passed others to General Kumalo.
Chair, those are the names that we need. And I will be writing to the National Commissioner to get that information, to make sure that's properly investigated. It's just that we need to time it because there are these other inquiries that are going on, but it's an urgent matter that needs attention.
Okay. Let's take it back to your conversation with the evidence leader of your sentiments on infiltration of the NPA, which when you were explaining it, you said there are people within the organization who do not have the interest of justice at heart. Did you mean what we are experiencing now? Or you meant something completely different from what is accused by Lieutenant General Mkhwanazi?
I made something different because you'll recall, Honorable Member, through you, Chair, that I made my comments before he did. And so I had no idea what he was going to be talking about. So they were not related.
Do you have internal mechanisms to detect and tackle corruption within the organization?
We have aspirant prosecutors go through a course. They go through an ethical training as well. We have the Office of Ethics and Accountability that's been set up to be proactive in terms of and trying to create a culture of high standards of ethics, and as well as investigating thereafter reactively. We also have a hotline that any member of the public can make reports to, so that we can get the information regarding potentially unethical conduct by prosecutors.
Have you ever been invited to a meeting of the Interministerial Committee dealing with the political killings?
Sorry, Honorable Member, which meeting?
Meetings, interministerial meetings, dealing with political killings. You'll recall that PKTT is a born child of an interministerial committee where NPA is part of the PKTT.
Honorable Member, not that I can recall that I ever attended an interministerial committee meeting relating specifically to PKTT.
So you don't know how effective has NPA been in aiding the fight against political killings?
I have the statistics from the PKTT, and whether it's been effective or not, we have numbers, but we don't know the extent of this problem, but certainly there are people that have been arrested and have been charged. So we have those figures.
How many political killings matters have been prosecuted?
I'll have to get those figures. I don't have them at hand. But
You said you have.
Pardon me?
You said you have.
We have numbers. The NPA has numbers.
Okay. So as things stand, you don't know how many prosecutions out of the work of the PKTT and how many successful prosecutions out of the work of the PKTT NPA was part of?
I don't have those figures before me.
Okay. Chair, can the NDPP later submit that information through writing? So on the PKTT dissolution, remember PKTT is a multidisciplinary team. On the dissolution of the PKTT, has there been an information sharing, consultation, briefing about the dissolution of the PKTT NPA is part of?
Chair, there's been no meeting with the police, not that I'm aware of, certainly not at national level. The National Commissioner did mention to me at some point that the Minister had ordered that the PKTT be disbanded, but that it had not happened. But that was not really a consultation, it was a casual...
So you heard it from the corridors?
I think you could call it a corridor talk, yeah.
You were on the way walking out of a tea room, then you were briefed?
Absolutely, that's the way it happened. It was an informal conversation.
Okay. On your affidavit, on paragraph 6.3, you make mention of the criminal justice value chain, which I think is one important aspect if we are to fight crime effectively. Now, the common knowledge is that SAPS becomes the first point of entry in the criminal justice system. So, to what extent and in what occasions does IDEC become the first point of entry in the criminal justice value chain?
That's in terms of referrals, in terms of the NPA Act.
Okay. That's fine. Let's talk about the reasonable prospects of a successful prosecution. Do we have internal norms and standards that govern or that determines to what extent, what kind of evidence and that? Or it solely rests with that particular individual prosecutor to take that decision, then it can be overturned later?
Our prosecution policy sets out criteria to be considered in determining whether the standard is met.
Okay. Is IDEC independent?
IDEC is part of the NPA, and the independence of the NPA is guaranteed in the Constitution. I would say the National Prosecuting Authority is not sufficiently independent in that its financial and operational independence still needs to be addressed. The Minister has committed to dealing with this matter. I'm pleased she takes it very seriously, and this House, well, the Justice Committee, Portfolio Committee, has also dealt with this issue, and I'm hopeful. The Minister has indicated that there will be legislation, this matter will be dealt with before the end of this financial year. It is very, it affects the operations and effectiveness of the NPA broadly, not to have its own accounting officer in many ways. And so that is why I say it's not sufficiently independent, because the DG of Justice is the accounting officer of the NPA.
So the independence would mean that the NDPP be the accounting officer of the NPA?
There are options. That's the SARS model. And in fact, the SAPS as well. The National Commissioner is the accounting officer. In SARS, the SARS Commissioner is the accounting officer. So that is an option. Or it's having a chief executive officer is also an option. Those things need to be determined by the Minister.
So as part of your suggestion to Parliament, is that let there be legislative amendments to strengthen the independence of IDEC and the NPA as a whole?
Absolutely. That is a suggestion to Parliament, and when the Minister brings it to Parliament, as she has committed to, I certainly hope that there will be support from the committees to ensure that that happens.
Okay, because the terms of reference actually direct us to also investigate system failures, so that what we get from the testimonies actually inform how we move forward. Myself and you had got a very concerning situation of prosecutors being assassinated. Very worrying situation. Now, do these assassination of prosecutors suggest that it might be a work of some crime syndicates and stuff, trying to silence them on the basis of doing their work?
Is the Honourable Chair, is the Honourable Member saying within staff members? Did I understand the question correctly?
Let me repeat.
Thank you.
Myself and you have been, for quite a long time, been concerned by a growing assassination of prosecutors. And it turns out that in most cases, these assassinations are linked to the cases they're prosecuting. So, does this mean that this is as a result of the work of the alleged crime syndicates trying to silence the prosecutors from doing their work? It's off.
The short answer, Honourable Member, is certainly in the one case, it was people have been arrested, and it was clearly related to a case that the prosecutor was prosecuting involving organized criminals. In the other case, it is not clear whether it was directly linked, but that prosecutor was involved in prosecuting a bail application involving organized criminals. But no one's been arrested there, but certainly the circumstances suggest that it was a hit because nothing was taken. And you're right, it's a very serious and growing concern. In my 40 years of prosecuting, we've not been concerned about prosecutors being killed. Now, we are living in and it demonstrates what's happening in this country. And prosecutors being killed is a new phenomenon. Sadly, we've had police officers that have been killed in the past, but more often for firearms, I would think most of the cases. But now targeting prosecutors for the work that they do, and whistleblowers, and forensic investigators, is something that we as a country have to consider. And that is why I mentioned earlier when I was being led about whistleblower protection. We've asked for an increase in budget to protect prosecutors. These are expensive. It costs a lot of money. And you protect not just a prosecutor, you protect families. And it upsets your life. So it's a very serious issue that as a country, we need to look at how government needs to strengthen its protection mechanisms, also working with the private sector.
But has NPA done an internal assessment on the causal links on the assassination of prosecutors so that it helps you develop proper mechanisms to prevent that?
We've looked at the two recent cases and assessed and analyzed what happened there. Even though one of the cases was clearly because of the work, we have put in place mechanisms to strengthen the safety of prosecutors, our security and risk team in the NPA. We've got mechanisms for them to react at very short notice to give immediate security to prosecutors who feel the threat immediately. But of course, there's a process, if it's not an immediate threat, to assess the risk and to make sure that we protect the right prosecutors. But we will not compromise on the safety of prosecutors. And we've also been engaging with our external partners, with the Canadian government, with our Society of State Advocates, to get trainers in to assist prosecutors to be more proactive, to protect themselves in circumstances and not put themselves out to additional risk.
So out of all the prosecutors that were killed, there is only one case where the alleged perpetrators were arrested.
We have, I think the short answer is yes. I hope I have that right. The short answer is yes. We had 2 prosecutors that were killed this year. And another prosecutor that was killed in what looked like a hit. It was probably about 2 years ago. But there have not been arrests in those matters. There's been arrests only in the one case.
But what are the bottlenecks? Because society expects, at least, that if a person is a police officer, is a prosecutor and stuff, expects that at least justice will quickly be done. But beyond that, as we attend with those families who lose their loved ones, we promise every time that we're going to prioritize this. The statements of NPA do promise that this matter will be prioritized, blah, 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 blah. So, but what are the bottlenecks so that if there is a way Parliament can meet halfway, we do that? What are the actual bottlenecks?
So, through you, Chair, this is a complication that we face with a lot of crimes, and one would expect, correctly so, not that other crimes are less serious, but when it is one of your own, that the police, the prosecutors work together and do everything possible to try to bring the perpetrators to book. What the challenges with investigating these matters is something I think that's better dealt with by the police. But clearly, whether we have, we have more cameras installed, for example, in certain high-risk areas, so that the evidence could become more readily available. I don't know, but it's about the difficulty of getting witnesses, getting evidence, and also people coming forward to testify. So I think the police are best placed to, really talk about the challenges with investigations. I don't know what the challenges in these particular cases have been, but it's a challenge we're facing in dealing with crime in this country generally.
How does all this affect the morale of your staff?
It sends shockwaves through the organization. And, to lose one of your own who's working hard for justice in this country. I went to the home of Tracy Brown and Ilona Sambalula when they passed away. And speaking to the prosecutors, I spoke to one young female prosecutor, and she said, "Ma'am, we are warriors. When one of us falls, we keep fighting." And I feel incredibly touched by the strength of prosecutors who still fight the good fight in extremely dangerous and difficult circumstances. So trying to keep prosecutors motivated at a time when we are under attack in this way is extremely difficult. But I think a lot of prosecutors do the work because it's a calling to serve in a very real way. But something like this, it's very difficult to motivate prosecutors to keep fighting the good fight when we are under attack in this way. So the short answer to your question is, it sends shockwaves, and it really, prosecutors become very fearful.
Evidence suggests that there is a collusion between prosecutors and Metropolitan Police, to an extent that there are instances where EMPD, for example, would arrest someone outside their jurisdiction. In Soweto, which is JMPD. But still prosecutors are prosecuting those cases, even at the time when the arresting officer did not have a local standard to arrest because it was outside their jurisdiction. What is your take on that?
It's unacceptable. It is totally unacceptable. And these are things I urge the public. We have an Office for Ethics and Accountability. Please, when these things happen, you must bring it to our attention, because there's an absolute zero tolerance in the NPA for unethical conduct. And the only way we can act on this is if we get people reporting to us. The challenge with corruption is that two people are benefiting. And when these corrupt activities are happening in courts, the person that is receiving the benefit is not going to say that prosecutors are corrupt. So it's extremely difficult, but we have had some information coming through about certain courts where prosecutors are behaving in this manner, and those matters are under investigation by our OEA.
Will the NDPP be assessing all the cases brought by Metropolitan Police to check if they did have jurisdiction over those accused people?
Since the matter has come up, we must certainly do that. And I commit to this House that we will look into that issue.
What damage do you think all this fracas has done to the image of the Independent Prosecuting Authority?
There's damage to the entire system. We have to look at how the system functions. And the system is as strong as its weakest link. So these are all these issues are systemic issues. And of course, they damage the image of the NPA, they damage the independence of the police, of the Metro Police, of the court system. And that is why we need to look at how do we deal with all of these systemic challenges, because they are not going to go away. We need to, as a committee, seriously consider these issues to see how do we strengthen the system. And I'm sure I'll get questions later about the NPA and its image, and I can deal with that later.
Okay, Chair. That's all from me. Thank you.
Yeah, you must hand over to Honorable Sokanyile, because I was worried that you are eating from her plate.
No, it's you for me.
It is 7 minutes left, Honorable Sokanyile.
Thank you. Advocate, on paragraph 78 of your statement, you indicate that since you joined the NPA in 2019, you never experienced any undue executive political interference. What, now considering, in your view, what will constitute an undue executive political interference?
Thank you, Honorable Sokanyile. It's where a member of the executive tells the prosecuting authority to protect people or to prosecute people who should not be prosecuted for political reasons. That would be undue, as the simplest example of undue executive influence and political interference.
So you have never experienced that?
I have never experienced that ever. And I don't know if as a country we appreciate how important this is. The fact that we have an executive that does not interfere in the work of the prosecuting authority, that supports appropriately the work of the NPA, but does not interfere in terms of its independent mandate, in terms of the Constitution and the Act. And that is such an important aspect of our constitutional democracy and a huge strength that our country should really be proud of at this moment in time.
Okay. You also indicate that you are not winning the fight against organized crime. Do you think that organized crime has its tentacles spread across the criminal justice system, which include the NPA?
I will be surprised if they don't, because organized crime is a business. And in business, the risks are assessed and there's mitigating factors, mitigating measures put in place. And in the case of organized crime, one of the business risks is that you are investigated, you prosecuted. It's a big business risk. And so trying to secure the protection of politicians, of prosecutors, of police officers, are mitigation measures. And it happens all across the world. So we are vulnerable to that kind of risks.
Through the rogue elements within the prosecutors, it cannot happen.
If there are rogue elements, of course it can happen. And we must make sure that we weed them out and kick them out of the NPA. There's no place for them at all.
Then on paragraph 26, regarding the impartiality of members of the NPA, how is impartiality assessed in the NPA?
The easiest way of assessing impartiality is to ensure that when we prosecute, there's sufficient evidence and we are guided by our policy and policy directives. If all of those, we tick those boxes, then we know we are acting in terms of our mandate and prosecuting when there's a reason to prosecute. And that shows impartiality, and it doesn't matter who is at the end of the prosecution. That's what the rule of law means. You prosecute irrespective of who is the person that you're going to prosecute. It could even be a family member. So it's very important that we actually maintain those standards.
Then looking at the Omotoso case and other cases where judges made scathing remarks about the capacity of prosecutors in prosecuting cases. I've already mentioned the Omotoso case or Omotoso matter. Will you agree that that case didn't build any confidence to the public on NPA? And what interventions were put to address this on capacity challenges within your judges?
Thank you, Honourable Member. I agree that that decision seriously dented confidence in the ability of the NPA and the system to deal with sexual and gender-based violence. But I would urge this committee and the country not to judge the NPA's ability to deal with sexual and gender-based violence on one case, one really important case. I don't want to detract on the importance of that case and what we've done to take lessons from that. But every day, prosecutors across the country are prosecuting sexual and gender-based violence and are getting life sentences. We've got these figures, life sentences, 20 years, 25 years, almost every day in this country. High-profile cases. Look at the Jocelyn Smith case in Cape Town. So I would really urge that we do not judge the ability of the NPA to deal with these matters on a single case, because there's thousands of cases every day that prosecutors across the country are dealing with. Our Tutuzela care centers that we have set up with partners is an international good practice, and we are giving the best service to victims. Our prosecutors can talk about this at international conferences, and other countries are learning from South Africa in terms of how we help victims to go through the court processes. We have court preparation officers in court that make sure that victims are properly prepared to testify in very difficult circumstances. So we've learned strong lessons on Omotoso. We've looked at the conduct of the prosecutors. We've reported on this to the Justice Portfolio Committee at length. We've put in place various interventions. We've also looking at our Sexual Offences and Community Affairs Unit, their strategy We've reassessed that. There's a process to relook at that and see how we can strengthen the work that it does. So there's a lot of lessons that's taken from that one case. It is still on appeal, and we certainly hope that the outcome will mean accountability and justice for the victims at some level.
Looking at the arrest of Lieutenant General Khumalo, if we're looking at the speed on how things were done, then what we can say about the entity that falls under your direct authority, whereby in some cases there are delays in prosecuting serious and corrupt matters coming from the commissions and elsewhere. But how does it say about the speed in which you acted on the issue of arresting Lieutenant General Khumalo and the prioritization of cases within NPA?
So we get criticized when we act with speed, and we get criticized when we don't act with speed. In this case, the speed of prosecutions depends on the availability of evidence. That is the determining factor. The more complicated a matter, the harder it is to get the evidence, it will take longer. In this one, I can only say that the evidence was available, and that is why the IDAC was able to move as quickly as it did.
You know, the people out there, they're saying that the speed on how we have done it, it is because of the factions within crime intelligence or within your prosecutors. Thank you.
If I could just respond to that, Chair, in 30 seconds, through you, Chair. I'm not sure whether it's related to factions, but as far as the IDAC is concerned, IDAC didn't go after people in crime intelligence. There was a referral. Someone brought the case to them. If that did not happen, IDAC would not have been involved in that case.
Thank you. MKP. Okay, can I check if there are members who want to ask follow-up questions? Honorable Sangoni, Honorable Matthys.
Thank you very much, Chairperson. Good afternoon again, Advocate Batohi. I don't think I got a response on the issue that Honorable Ngola was asking you, just in terms of your knowledge as a jurist, how you handle classified information that's obtained in an illegal manner. Maybe you don't have to reference the IDAC case if you like, but I think the principle that we're trying to get to is that when somebody has obtained classified information they're not supposed to access, how then would you treat that? And then my final question, which is also a follow-up on the issues that they raised, you did say that we are not winning the war against organized crime, and I assume corruption, crime in general. Advocate Batohi, what is broken, right? Because, I mean, the people, a number of witnesses who have sat there, and everybody seems to really skirt around the issues. We'd really like to know what is broken, what do you think needs to be done to fix it? Thank you very much, Chair.
Chair, on the issue of illegally obtained evidence, if my memory serves me right, and I haven't been in a court prosecutor for a long time, there is a provision in our Criminal Procedure Act that allows for illegally obtained evidence to be admitted in court as evidence if it serves the interest of justice. And there might even be something in the Constitution, but I'm not sure. But that would be my response to that. On the second part, what is broken in the system? How much of time do you have? Honorable Sangoni, it is, I really don't know where to start. our crime is ravaging our country. And it seems like we are watching this movie in front of us in slow motion, and those of us in power that should be doing something about it are powerless to do anything about it. That the criminals are taking over our country, organized criminals. As a national director, the one thing that I do is authorize racketeering prosecutions. And the numbers of racketeering prosecutions don't give any confidence that we are, and the types as well, that we are dealing with the top level of organized criminality in this country. I want to hasten to add that there are some good cases, and there are good people within the system that are working really hard. So whatever I'm saying must be taken in that context. But when you start off to deal with crime, you have to have an efficient crime intelligence. That's the starting point. Then you have to have in the police, you have to have not just the numbers. You have General Lebear, who has testified in Parliament that the Hawks are sitting at 50%. How can you fight crime, serious crime, when you have a 50% vacancy rate? If you have to deal with high-level organized crime and corruption, you need financial capabilities to investigate this. I stand to be corrected, but if I'm not mistaken, General Lebear at one point said that the Hawks had 2 chartered accountants. 2. And I understand that one of them was recently taken to the private sector because they can afford better salaries. That brings me to the salary issue. We have to be able to have competitive salary scales within government, and I'm not sure that we'll ever be able to participate and to compete with the private sector. But within government, we also have serious issues relating to salaries. For example, the prosecuting authority and I think the police are bound by public service salary scales. The SIU and SARS are not. And so they themselves are able to, people will, as the NPA and as the police, we constantly training people that would leave to join other departments or even leave. So the salaries are a really important issue. So, and it's about instilling an ethical culture in our organizations, professionalize. How do you, the public service has had a strategy professionalizing the police, the JCPS agenda for years. What does that mean? Professionalizing the public service, and how do we ensure, what systems do we put in place to make sure that we have a truly professional, ethical public service? And I think it starts with, corruption happens when you have lack of ethical leadership and lack of good governance. And we have to focus on on appointing ethical leadership and ensuring that there's good governance in all our systems to, make sure that we are not susceptible. I don't think we'll ever get rid of corruption, but we minimize the risks. And so then we move to the NPA, we need same capacities, capabilities, skills, the independence, and then you move to the court system. And there are huge challenges there. So that is why I said I don't want to be seen to be taking a lot of time on this, but there's a lot of challenges in the court system. There's from interpreters, for example, the different languages, you need more interpreters. We need to look at how do we use AI in our court systems so that we could be more efficient and get onto the AI bandwagon as well.
Honorable Matthews.
Thank you, Chair. Mine is just to address the issue of gender-based violence, Advocate. And I think your response, or how you are saying what the NPA is doing in regards to gender-based violence, is a slap in the face for so many victims right now who have gone to court. And prosecutors have not even bothered. Child rapists have not even bothered to say that this one must be denied bail. And it happens more often than not. Even those centers I don't know when last you visited them. I was at the Mohammed Gandhi Hospital in Phoenix the other day. It's hardly even operational. So, and mine is just more of a response that advocate, don't leave here and like misrepresent. It's almost like a slap in the face of an ordinary South African who has been subjected to this criminal justice system to say that it's working and it's functioning. When it is working and when you are having successful prosecutions, it is an exception rather than the rule. So I'm just asking you to be sensitive to the cries of the ordinary South Africans today. Thank you.
Thank you, Chair. Chair, I want to emphasize that as prosecutors, we are lawyers for the people. We represent victims and we represent the people of this country. And I certainly am not, I didn't say the system is functioning. In fact, when Honorable Sangoni asked questions, Chair, I was very clear that there are lots of challenges in the system. And so we have to look at the systemic challenges. And the work that prosecutors, ordinary prosecutors, every day are doing in courts. Of course, there will be those cases when prosecutors don't do what's expected of them. But that must be reported. We have a sexual offenses and community affairs unit where when we get, if I see a report in the media, for example, I immediately get onto it and I say, I want to report on this. DPP, can you look into this? If I see that there's been some case involving gender-based violence, it's in the media and we haven't acted quickly enough, I ask for a report, I send it through, and I want to know why. But I ask the public, victims of crime, if you're unhappy with any service you're getting from prosecutors, please report it up in the provincial structures. The DPP is there. Please lay your complaints, and you will be listened to, and we will make sure that you get the service that you deserve. I accept it's not perfect. You mentioned the TCC in Durban. We have been working to, the TCCs, we have been working recently together with the private sector to build more TCCs, to refurbish those that were getting into disrepute. And I agree with you, there are some of them that are not the way it should be, because we haven't had funding, we haven't had finances, and we've not been able to really keep them at the standards that we would like to. But working with the private sector, there's been a lot of work that's been done. For example, the one in Madadeni is we've just opened a new TCC because that one was in a terrible condition. So we're working slowly, and as we get the funding, we will be able to, because it's not acceptable that we should have TCCs in that state. But we're working really hard to make sure that they are refurbished, and that when complainants come to an area, it must be conducive to them being able to get all the services that they need.
MKP, your time starts now. It's 24 minutes past 3.
How many minutes are you adding, Chair? I noticed Honorable Sokanyilo of the ANC took about 4 minutes more. She started at 03, finished at 14.
The time is 30 plus 10. 30 for the full member and 10.
Yeah, she took more, Chair. Oh, you're a full member today? Oh, wow. But they said you have 7 minutes left, and then you finish 14 later. No, it's fine, Chair.
I know that the MKP comes from the ANC. No. You can't stop him from being nostalgic about the ANC.
Calm down. When I'm stopping corruption, guys, you must calm down. This ANC. Thank you, Chair. Sawubona, ma'am, how are you? Sawubona. I have 2 issues that I came across on social media that I need to ask. Starting with the issue that we're talking about, gender-based violence. I came across an issue of a father in Johannesburg. His name is Asif Kasoji, who has an issue with a lawyer called Camilla Pauls, who works for Harold G. Attorneys here in Cape Town. Now my question is, You see, there's this thing of fathers not paying support. And we lack such fathers. But this father pays his due accurately, but is deprived of an opportunity to see his children, spend time with them, see medical cards, medical reports and all those things, and school reports. Now, and this is happening because there's a blockage from a lawyer, a certain lawyer whom I mentioned here, Camilla Pauls. Now, what I want to know is that, do you take lawyers who have been running their legal firms to be prosecutors? That's my question.
In terms of the NPA Act, we are able to acquire the services of private practitioners to assist the NPA.
Do you vet them?
I think there's some tax clearance requirements. There's confidentiality documents that are signed, but they are not vetted. Vetting takes, I think there's a basic level of vetting. I need to get details on that, but it's not the kind of vetting that happens in SSA.
Okay. So do you check with the LPC the historical background of such lawyers? For instance, it once reported that there is a lawyer, which is this one, in this newspaper. So do you check such historical background of such lawyers?
I will have to check what internal checks are done and come back to you on that. But there is, I think, a basic level of vetting. Whether they check with the LPC, it would certainly be a good thing to do that, and I'll just look into that.
You are widely perceived as a Mr. Cyril Ramaphosa's protector. I think you know about that one.
Not that I'm aware.
Why has it been that he has not been charged with the Phala case?
If the chair will give me a moment, I just want to get my facts in terms of where this matter is currently. There's two matters in this matter. There's two matters in relating to the Phala case. One is the possession of US dollars by the president, case opened by Mr. Arthur Fraser, and the other is, and this particular case is in the, a decision was taken by, no, there's no decision on the matter yet. This matter is with the DPP, I think it's Limpopo. The file is with the Specialized Commercial Crime Unit in the head office, and they are going to get a panel to sit on this matter to consider it, but there's no decision. So that is that matter. The other matter relates to theft of cash from the president's farm, which is in court.
Okay, tell me about this one. The section. Oh.
Can I check what is the point, Honorable Malem?
No, Chair. She can't say she's not aware of where the decision lies on the matter of Phala, because there's a decision by DPP in Limpopo not to prosecute. And even the head of IDEC told us that the matter is with her because there were people who took that matter on review. And the question is, why is she unable to prosecute on that matter? Even when Limpopo declined, there was a review which was brought to attention. That's where that matter is. To say there's no decision on Phala is incorrect.
What I want you to do is to hold that question and allow the honorable member to conclude his questioning. I will come back to yourself and Honorable Nomval. As a belief, honorable members, you are going to distract the chain of thought of the honorable member. Just take note of your questions. You will be afforded that time. You see, my problem is if I deviate from the principle, and then we will,
but not on my time.
We will end up having unintended consequences. May you continue, Honorable Noval. I'm going to credit you for 4 more minutes.
I appreciate that, Chair. But kindly do me a favor, Chair. When my 10 minutes lapse, can you stop me so that I don't take his time? Thank you very much. Okay, on that note, ma'am, the Section 189 Parliamentary Panel, chaired by former Justice Sandile Ngobo, do you remember that one, right? Found a prima facie case evidence against President Ramaphosa. The former head of Hawks publicly stated that investigation report is already on your desk. So why have you not acted on that?
Chair, I want to understand for clarity, is the honourable member saying that someone from the Hawks said the matter was on the National Director's desk?
Yes.
That's incorrect. I've never received this matter.
You've never. Should we do a follow-up and find that the matter you did receive? Are you willing to come on record and say, I did and I didn't act on it?
I would have received reports from the DPP, but certainly not a complaint from the Hawks relating to this matter. I'm not dealing with a review process. They would have been reporting in terms of high-profile matters, but there's nothing on my desk for my consideration in this matter.
You spoke of ethical leadership. So, do you regard yourself as an ethical leader?
I do.
Why have you not acted on Palapal?
I beg your pardon?
Why have you not acted on Palapal?
Because there are processes to be followed in the legal process. The DPP takes a decision on the matter or not. And of course, anybody is entitled to ask that the National Director review this matter. That review process is not kicked in, but I'm trying to get clarity on whether Honorable Malema might be correct, whether the DPP in fact took a decision in this matter, and whether there is a review process in the SCCU head office. But I want to get clarity on that. But for now, to be clear through you, Chair, the matter is not on my desk. I have never considered this matter or the merits of this matter.
So the ethical leader in you doesn't say do something about Palapala. Anyway.
There are processes at the moment that are happening. The matter is at the head office.
The ethical leader in you.
That's correct. There are processes and the matter is at the SCCU in the head office.
So the ethical leader in you only says that. It doesn't say do something about Palapala. It only says just know where the matter is.
That's not correct. If the DPP has done anything wrong in taking the decision, then of course I must intervene. And there are processes, the matter is with the SCCU head office at the moment.
Let's pass. Do you know Paul O'Sullivan?
I beg your pardon?
Do you know Mr. Paul O'Sullivan?
I've never met him, but he does send emails. I may have met him at I better hasten to add, if he was at some social event where I was there with him, I might have, but I can't recall.
Chair, I think I'll end here and donate my time to Honorable Nomvalo. Thank you. If I may.
Just hold it there. Thank you so much. The honorable members who want to make follow-ups, can I see your hands? Honorable Nomvalo, Honorable Skosana, Honorable Sangoni, Honorable Malem, Honorable Breitenbach. And I must remind you that there is no honorable member who is going to be allowed to make a follow-up on the question that he or she asked. Thank you. Can we proceed in that order?
Yeah, no, thanks, Chair. My follow-up relates to the first question of Honorable Shongwe about enrolling attorneys who have been running their private firms into your organization. You know, there are lawyers who have been struck off the roll by the LPC. Now, I think the question is, if they apply to your organization, do you accept them? But secondly, there are lawyers whose DC hearings are pending or DC outcomes are pending. Like this lawyer that he has mentioned, I think her name is Camilla Pals, practicing in Herald G attorneys. In relation to a matter of Asif Kasuchi, I think it was widely reported in the media that he has been deprived of his parental rights. Now, do you consider such lawyers who have pending cases and lawyers who have been struck off the roll?
I don't consider that they would be people that the NPA should be hiring. So my colleagues have informed me that they do a vetting process, which is normally whether they fulfill the requirements to run a business properly. I don't know what that means. I need to get clarity on that. But also reference checks. But I think we do need to add checking with the LPC if that is not the case, because I certainly agree with Honorable Navalo that we should not be hiring such lawyers to be working with prosecuting cases for us.
Honorable Skosana.
Thank you, Chair. Advocate, you said that if the decision, the DPP has taken a decision, whether that is that the decision, let me put it in a simple term, doesn't make sense to the people of South Africa. Remember, justice is not operating in a silo. If there's an outcry, as an NDPP, are you not allowed to intervene?
Of course, if there's an outcry and it appears that the DPP has in fact done something wrong, then the NDPP should intervene. But if the reports received by the National Director suggest that the DPP has not done anything wrong and has complied with all the policy requirements, the evidentiary standards, etc., then there's no need to intervene in that matter.
Chair, because I'm still going to have my time about the DPP we are talking about here. I thank you.
Honorable Sangon.
Chair, I didn't have a follow-up. I was just requesting to address you. Can we please ask the DA to ask the Minister of Public Works to get the aircon working? We are dying. It's been 2 weeks. Where is good governance, Chief? Please, Chair. Thank you so much.
Can I respond to that? So the Minister of Public Works has been the Minister for 3 minutes. And for 30 years, the ANC has been the Minister, and they did nothing here. So don't come to me.
Honorable Breitenbach, let me tell you this to you, Honorable Breitenbach and Honorable Sangon. You know, Walter Sisulu, when he was asked what made him one of the best secretaries of the ANC, he answered by saying that the day he was elected, he took Walter home and brought a secretary to the ANC. The two of you, can you take the ANC and the DA home and bring public representatives here? Honorable Malema.
No, I wanted to check if Advocate have you confirmed, because it will be very worrisome that you come before this platform and you know one of the high-profile cases you're dealing with is this matter of Phala Phala, and you come and say you don't know what's happening with it. I mean the NPA withdrew this matter. I mean, refused to prosecute. And it was announced, and it was said that the matter is before you. I think that should be in 2024, somewhere there, where the DPP of Limpopo said it's not prosecuting, and then there was an outcry, and the response was that the matter is being reviewed by the NDPP.
You, Chair, can I clarify? Yes, I've now got clarity on this. My notes were not clear. It is a review process. The matter is in the head office in the NPA. It's being dealt with by the Specialized Commercial Crimes Unit that processes the reviews. and that matter will be dealt with. Thank you, Chair, and I apologize for the lack of clarity on that.
You can apologize to Honorable Shongwe first, because that's a question I asked.
Thank you so much. It's
Apologies,
now
Honourable Shongwe.
15:40. Your time starts now, ends at 10 past 16 hours. Is that Nombalo
thank
or
you.
Skosana?
Thank you,
Is
Chair.
it you or
Yeah,
Skosana?
no, it's me, Chair.
Okay, thank you.
Good afternoon, NDPP. You know, I've got a privilege because you account to a committee which I'm part of, the Justice Portfolio Committee. And my observation with you, which I've shared openly, is that you are very quick to become dismissive. And that leaves me with an impression that you are the NDPP who does not understand his statutory responsibilities. And I'm going to a particular question with this statement. I'm not just making a statement here. When I arrived here, we had the first meeting with you. I asked you about the Cindy Somakaka case, which was widely reported in the media space. You said you don't know what is happening on that case before it reached the stage that it is in today. You came to our committee when you came to report about the Omotoso case. You admitted that you never made any supervision to the case up until the ugly consequences that South Africans experienced. The Gupta extradition. There are many cases that I can explain which you failed to supervise in terms of the statutory responsibility that is given to you. Now, I'm not crucifying you here unfairly so. I'm saying this based on experience. And I even requested that you resign before January because I think you are just in this position for the sake of being in it. You don't understand it. I made a plea and I even said to you, even if I meet you in town, in the toilet, everywhere, I will request you to resign because in my understanding, you are not fit for this position. Now, Section 34 of the NPA says, the NDPP may direct a DPP to submit a report to him regarding a specific activity relating to his or her powers, duties, and functions. That is the first section that gives you huge powers to run the institution holistically. Section 22 says, the NDPP may direct a DPP to submit a report in respect of any case, matter, prosecution. Now, when it says prosecution, it gives you a responsibility to summon a report, even if the prosecution is still underway, to say, NDPP, come to my office or give me a report about this matter and advise or overturn, as you said that you can overturn the decision of the NDPP. But in many instances, you refer a responsibility to the DPP and says, no, it falls in his competency and you have no statutory responsibility. Now, do you agree with me if I say to you, you have a particular understanding of your statutory responsibility other than the responsibilities that you are given by the NPA Act?
I'm not sure I understand the question, Chair. If that can be clarified so that I can properly answer
Let
it.
me ask it like this. You said here, when you were asked about the KZN issue, I think so, you said it falls in the competency of the DPP, and you never involved yourself on that issue because it was done by the DPP. I've explained different events here wherein you used the same excuse to say, no, this does not fall in my competency. I can't instruct the DPP to prosecute or not to prosecute. And you have repeated those words here today. Now, I'm saying the statute gives you those powers, but you are not using them. You can advise the DPP to prosecute or not to prosecute, in my understanding, based on the provisions which I've just read for you.
Thank you. I understand that question better now. Firstly, I cannot advise a DPP, Honorable Chair, to prosecute or not to prosecute a case because I do not get involved in assessing the evidence in a case. And the fact is, Honorable Chair, the Act makes it very clear what the responsibilities are, what a DPP's responsibilities are to decide and make decisions to prosecute, as well as the Act creates two offices, actually. It creates an office of the National Director, and it creates an office of a DPP, which consists of a whole, the Act sets out what that office consists of. And it's very clear what a DPP should do and the powers of a National Director. So in terms of decisions to prosecute, the National Director cannot tell a DPP who to prosecute or who not to prosecute. But you are correct in that there are certain other powers. The National Director is in charge of the National Prosecuting Authority. And as such, the National Director's got to ensure that the institution is well run. And that would mean calling for reports on certain issues. That would mean a whole range of things. And so certainly I also want to deal with the examples of cases that the Honourable Member mentioned, because I think it's important that I don't leave that unresponded to. So with regard to the Omotozo matter, again, I emphasize the day-to-day management of cases rests with a DPP. And of course, yes, when things went horribly wrong in that matter, then I had to step in to find out what was going on. But we were not aware that there were risks before that. And so that's the one case. And again, I implore that it is not regarded with the greatest of respect as an example of how NPA deals with gender-based violence issues. And Chair, I've dealt with that extensively, so I won't go back to that. The issue of the Gupta extradition was also raised. And it's important that I deal with this because, with all due respect, I speak to this honorable committee, but also to the people of this country. The Gupta extradition matter, I won't go into details, but we are still trying to understand what for extradition that will be submitted fairly soon. I don't want to give timelines. But one of the risks are that we actually fail again because we didn't know what the reason was for the failure in the first instance. But that's not going to stop us. We will submit a further extradition request. So I think you are correct in terms of the powers of the National Director to make sure that the institution is run properly. And I want to assure the Honourable Member that the NPA is a well-run institution today. We have ethical leadership. The performance of the NPA, besides these couple of cases, very important cases, setbacks, none of those cases have reached the end of the legal process. We are certainly hoping that there will be a successful appeal in Omotozo. In the New Lane matter, for which the NPA was crucified, the Supreme Court of Appeal has overturned that decision, and we will have to start that case all over again, which already puts us at risk. So I just want to emphasize that the performance of the NPA has gone up from 50% to 75%, and in Q1 this year is sitting at 81%. That is not indicative of a failing organization. I agree there have been setbacks, and we've learned from that. And we need to make sure that those things do not happen again. But the NPA is certainly, with asset forfeiture, for example, which is an important aspect, we have recovered almost 50% of everything that was recovered in 25 years of the AFU has been recovered in the past 4 years because of a very determined asset forfeiture strategy, because of innovative policies. And money from Kara, that I think it's 6.6 billion, that's like 6 times what it cost us to fund Zondo Commission. We're already seeing results of that because it's mainly because of evidence led there that we're able to recover this amount of money, which also funded government's response to dealing with illegal mining. So you make important points, but it's important to understand the context. Thank you, Chair.
Yeah, no, because my problem, NDPP, with these cases that I've just mentioned is that you only came in after a crisis presented itself. During the course of prosecution, you never intervened, even when these cases were widely reported in the media space. Don't you think that somewhere, somehow, you were irresponsible? Because when a case is broadcast, it gives you an opportunity as well as the NPA to showcase your strength, to intimidate criminals. Now, when you just go on TV, you watch like all of us ordinary South Africans, and you do absolutely nothing, and wait for a crisis to come, and only come in when there is a crisis, whereas you have a constitutional weapon, you have a statutory weapon that you can use, because at any time, you can call the DPP and say, DPP, can you give me an update on this matter? And support them when there is a need to support them. Now, you have just been observing, like all of us, sitting at home, watching TV, doing absolutely nothing to assist the prosecutorial work that has been done in these cases. So I think if you are a responsible DPP, NDPP, you must accept that you abdicated your responsibility, especially in the Omotoso case, because you never did anything up until there was a crisis.
So, Honorable Chair, I want to emphasize that directors of public prosecutions are highly paid, responsible, powerful members of the prosecuting authority. And I, as the national director, any national director, expects them to be doing their job. Of course, if there's an obvious crisis that's happening, you must intervene. We have put in place processes where DPPs now do a proper risk evaluation of every high-profile matter, dealing with any potential risks and what they are putting in place to ensure that those risks do not materialize, or if they do, we mitigate the consequences. So I understand the role of a national director, but the DPP's responsibility, there was no apparent crisis waiting to happen in this matter. And DPPs are required to manage risks in their division. But if there's an obvious crisis, of course, the national director must intervene, which was not the case in these matters. Thank you.
Now let's move to another one. If I had enough time, I was still going to pursue this one, because still I'm not satisfied. On paragraph 83, page 29, you are saying in your statement, the process of appointments should be synchronized and depoliticized to ensure transparency, merits, and accountability at all levels of prosecutorial leadership. Do you want to expand more on that statement which I've just read?
Through you, Chair, which paragraph again?
Paragraph 83, page 29 in your statement.
Yes, thank you, Chair.
Yes.
So the appointment process of a national director, not just a national director, but 4 layers below the NDPP are political appointments.
Yes.
Let's say the power to appoint lies with the executive. The president appointing the first 3 layers, national director, deputy national director, and DPPs, and the 4th layer, which is deputy DPPs across the country, is a ministerial appointment. And so I think it's important that, and it's very good that the president and the current minister have now initiated transparent processes to appoint the national director. I certainly hope that similar processes are put in place for the other layers in the NPA as well. But in order to ensure that you have a professional national prosecuting authority, you need to ensure that the person that is appointed, persons appointed at all those levels, understand what their oath of office means, understands what the rule of law means, and understands that you conduct and you do your work without interference of any nature, whether it's across the board, and that's set out in my statement. But I think what I would want to say is that perhaps the process should be depoliticized in the sense that if there is an open and transparent process, I like what the current minister and president have done, is that except for the minister, I think there's no politicians in that committee. That is a way of depoliticizing it, which is a good practice. So those are some of the things that need to be done.
Yeah, you know what attracted me in this statement or in this paragraph are these two words, synchronized and depoliticized. And they left me with an impression that your impression is that the current process is problematic in that it attracts political interference by its nature and by its design.
I think an NPA, given the way it's structured, I'm not sure that there are many prosecuting authorities in the world that do not have some line of accounting to the executive. So that is something will be there, but you need the executive and the prosecuting authority to have people in these institutions that actually respect the authorities and independences of each. And as I've said, we are very fortunate in this country right now to have that situation where there's no political interference at all. I've worked with 3 ministers now, and I've not had political interference from any one of them or from the president himself.
I think you are now confusing me because you are saying here, unprovoked and voluntarily, that the process must be synchronized and depoliticized. In the same breath, you are saying there has been no political. So where are you taking this thing from? From the atmosphere? Because when you say it must be synchronized and depoliticized, you mean currently it is politicized.
No, I don't. I mean, that was what will be. This committee also wants, recommendations in terms of how we can improve processes. So it doesn't mean it's currently politicized.
I thought maybe to a certain extent you are agreeing with a perspective of the MK. We've made a submission in the constitutional review that the appointment authority must not be vested in the powers of the president, as it is suggested by Section 11 of the NPA, and the removal authority as well. Our view is that the NPA must go under Chapter 9 institutions. They must be either appointed by Parliament or by any objective panel. That is our view. And 2, the current system doesn't allow a Parliament to act when there is a crisis in the NDPP, in that it only allows Parliament to come at the tail's end. So the process, the suspension or the removal process is initiated by the president. That is our perspective. So I thought maybe we are in agreement, because our view is that the current form or the current system attracts political interference. Now you are saying the current process is not politicized, you have never experienced any political interference, but in a statement you are saying it must be depoliticized.
If I may respond to that, the Chapter 9, and see the MK party is aligned with the DA as well in that regard, with regard to the Chapter 9 institution. As I said earlier, there are very few countries in the world where a prosecuting authority is completely outside of any executive accountability lines. And so, from that perspective, we'll have to change the constitution to start off with, and of course that's not impossible to do, I understand that. But to make the point that this is very rare where a prosecuting authority is completely without accountability of some sort to the executive. And that being the case, I think one way of strengthening, I agree, the advantage of a Chapter 9 is that the removal of the head of a Chapter 9 requires a 2/3 majority from Parliament, when in fact the removal of an NDPP, I hope I get this right, is a simple majority. And so I think what you can do is amend legislation to make the removal of a national director dependent on a two-thirds majority in Parliament. And I think that is the one really good advantage of a Chapter 9 institution over and above the current framework of the prosecuting authority. But I want to hasten to add that the financial and operational independence of the NPA, which the Minister is addressing, is a critical aspect that will certainly strengthen the prosecuting authority.
NDPP, do you know that the ANC, and I'm not mentioning its name here because I've got some obsession of some kind, but it's inevitable. Do you know that the ANC has a policy called the step aside policy? The ruling, I don't know whether it's a ruling
read
party
about
or
it.
it's a former ruling party.
I've read about
I
it.
don't
in the,
understand this GNU thing. Do you know that they have a policy called the step aside policy?
I've read about it in the media.
Has that policy not influenced the running of the NPA? Especially towards conferences. Have you never been exposed to a case where politicians want to influence how you must prosecute and who you must prosecute in pursuit of factional objectives that are related to an elective conference of the ANC?
I will vehemently deny that that is the case in the NPA. Certainly at my level, whether prosecutors at lower levels are being influenced, I don't know. I certainly hope not. But if they are, then with the right evidence, because there is no place for any kind of political. In fact, our policy is also clear on that, that acting without fear, favor, or prejudice also means acting without any political influence or any other kind of influence. So I have certainly not experienced that.
NDPP, as a legal person, do you agree with a principle that says justice denies is justice delayed?
Justice delayed is justice denied.
I mean, justice delayed is justice denied. I'm sorry.
I do agree with that.
If you agree with it, is it justifiable for the NPA to charge people when they do not have, or to prosecute people when they do not have enough evidence to prove their case? Is it justifiable? For instance, in a case of the former mayor of eThekwini, Zandile Kumete, that she was charged, I think, 8 years ago, if my memory serves me well. Up until today, the NPA is zigzagging. There is no clear direction from the prosecution side. Do you think that is justifiable?
So there's a number of questions in that question. Firstly, at a principle level, it's not justifiable. We, as a matter of policy, we will only prosecute when we have evidence that meets the standard of reasonable prospects of a successful prosecution. And we have impressed upon prosecutors that in the case of economic offenses, we should be almost trial ready, because there's no need to rush with a case and enroll it and then be seeking adjournments for further investigations. So at that level, I certainly agree with it in principle, but I'm not going to comment on the Zandile Gumede matter because that matter is in court currently.
No, I'm not saying let's talk about the merits. I'm saying a crisis surrounding that case generally, that it has been postponed for, I think, for almost 8 years without any successful prosecution.
If I get the detail, I don't know if I have it here, about why this case has not proceeded as quickly as it should for 8 years. In most matters, we find that it is because of various reasons not attributable to the prosecutions. I'm not saying that there aren't instances when prosecutors are responsible, but for the majority of cases, it is a deliberate delaying strategy on the part of the defense to ensure that cases do not proceed. There are other instances where magistrates recuse themselves, magistrates pass away, it needs to, so there's a whole range of reasons why. I don't have all the reasons in the Gumede matter, but I'm almost sure that, excuse me, if I get the reasons, this is what will be borne out.
I doubt that you will give me a proper answer to a question that I'm going to ask now, because of my experience with you, that you don't involve yourself with many cases up until there's a crisis. So there's no proper monitoring and evaluation, no proper supervision from the office of the NDPP. The DPPs are just on their own. You only come in when there's a crisis. Now, I want to ask about the Kumalo case. Kumalo was arrested by IDEC for an HR matter. Have you ever done a supervision of that case?
If you'll just give me half a second, I have a tickle in my throat. I'm trying to get rid of it. Excuse me, I'm sorry.
Yeah, she's a location.
Sorry, it's my post-nasal drip. Triggers
Chair,
sometimes.
She has been coughing for a minute, Chair.
No, but Nomvalo, you are unfair. The question is hard. Yeah, she's a question.
So
My
consider my
apologies.
time, Chair.
I must apologize for this. So I explained earlier that with regard to these matters, the National Director does not get involved in, excuse me, in the detail of a case.
So you have never supervised, even after it was broadcast?
No, I'm sorry, I'm just trying to.
Or you're not done?
I'm not yet done.
Oh,
My
okay,
apologies.
Yeah.
Protect the witness.
You are breathing heavily.
I need a
on the
minute and
neck
I'm sure I'll be fine.
of the witness.
It
Can you
normally
please
works with
back
the
off?
lozenge. So
Okay, no,
Advocate.
we can take a break, Chair.
I think I'm fine, Chair. I can
Relax,
continue now.
relax.
Thank you. In that matter, as I explained, well, in all matters, particularly, well, let's deal with IDAC matters, because it relates to an IDAC matter. I get very, very high-level reports, and verbally, because of leakage of information, the ID gives me very high-level reports, verbally, generally. In this particular case, she informed me about the impending arrest of the head of crime intelligence. I said to her, Andrea, are you sure this is a watertight case? Because arresting the head of crime intelligence is not something one takes lightly. There must be a watertight case, and she explained to me that it was part of a much bigger case strategy. This was one case that's part of a much bigger case strategy, and that the case was solid. But again, I urge, if anyone feels aggrieved by that decision, to bring a review process. And I assure the people of this country that I will look at any case, whether it's Phala Phala or this matter, objectively, and decide whether the correct decision was taken.
So they informed you before they effected the arrest?
That is correct.
So you relied on a verbal briefing. You never said, bring me a referral if there's any, so that I can satisfy myself that we have a strong case here.
Sorry, can you repeat the question?
I'm saying, you are saying, you asked her if the case is watertight, and she said yes. I'm saying, to you, that was enough. You never went further to say, bring me a referral, bring me documents, so that I can also satisfy myself that we have a strong case here.
We have processes in the prosecuting authority to ensure that cases are, it's not just one person that takes a decision, not just the ID. There's a team of people that actually work together to decide on these cases. So when the head of the investigating directorate gives me her assurance that the case is strong, I must take her word for it.
So you took her words. You never required.
That is correct.
Or you only relied on her words.
And a very high-level briefing of what the case was about.
So, according to your knowledge, was the arrest procedurally fair? Were all the requirements met for the arrest to be executed?
Can I ask what requirements the honourable member is
There's a
referring to?
referral and so on and so forth. You don't just go and arrest a person. There was a referral which was brought by a member of parliament in terms of the report that was tendered here. I'm saying, did you satisfy yourself that all the required documentation and the requirements were met before the arrest was effected?
That is not the function of a national director, and I certainly did not go into that level of detail.
It means we have different acts, NDPP. Really, I don't know the act that you have, but in terms of the act that is before me now, you do have that statutory obligation. When it says a report can go further by saying, give me the documents which are relevant to this prosecution or arrest, so that you do not become a victim of misrepresentation. You can do that. There is nothing that stops you. That is why I said, to me, you appear as the NDPP who does not understand her statutory obligations.
Chair, as I mentioned, the IDAC head gave me a high-level briefing on this case, a high-level case strategy, and why this case was strong enough and important enough for them to proceed. I agree with you. The National Director requires that kind of assurance from the DPPs to ensure that we don't have errant DPPs or IDs that are doing their own thing. It's important to have that level of assurance. And in this case, I got the level at a very high-level briefing, that level of assurance from the ID in this matter.
Yeah, because we are going to rely on a half-cooked information, and you are the one who accounts in Parliament. We ask questions from you. Now, if you are responsible, you can't just rely on a verbal update or report. Documents must be submitted to you so that you are going to be in a position to make justifications if that need arises, and to give a report and to be confident and say the NPA here did everything that it could do. Now you are just relying on a verbal report. There is absolutely no papers before you. You are saying this was said to me and it ends there.
Honorable Nomval, I think you're right. In future, we have to find a way of managing leakage of information and getting written reports, because you make a valid point. But dealing with leakages in the institution is a serious problem. And that is something else that, we need to find a way of strengthening our information security across government. But that is a serious concern, and I'll certainly take your point on board.
In December 2024, the media reports that the IDEC boss was addressing the personnel of IDEC, and she made some remarks. She was saying to staff members, they leave it. They must go to court with empty files. But in summary, she was encouraging them to pretend to be busy while they were not. And you made an interview after that. I can't remember the media house that you were in, but I came across that interview. You were asked about that incident, and you denounced it. You denounced it. Is it correct? Am I correct?
I didn't denounce it. Perhaps what that honourable member, that the media house that you're talking about, the Amabungane interview, because I was interviewed, and that entire interview was one that the makers of that interview used the New Lane matter as a linchpin to lynch the national director and the NPA. I was asked during that, and I hasten to add that that New Lane matter was one of the most scathing judgments against the National Prosecuting Authority. And of course, the media had a field day quoting from the judge who called it a comedy of errors, etc. We took that matter on appeal, and the Supreme Court of Appeal overturned the New Lane judgment, and in fact said in that decision, and it's important because this case seriously dented the reputation of the NPA. But the Supreme Court of Appeal overturned that decision. And in fact, the judgment rendered by the SCA is one of the strongest against the conduct of a judge that I have read. And there were terms like it went against the administration of justice and things like that. So that New Lane matter is the interview that you are referring to. And of course, when the matter was overturned by the SCA, there wasn't much that was said about it in the media.
No, I will ask 5 minutes from Kosana. I want to ask about Paul O'Sullivan.
Yeah, no, the time of Skosana is not yet allocated. Yeah.
When it's allocated, Chair, not now.
Okay. Honorable Bradenbach, you wanted to ask a follow-up question. Okay. Can I check members who want to ask follow-ups? I see Honorable Ngola. Is your hand up, Honorable Skosana? Okay. Those will be the two hands. Thank you. The list is closed.
Thank you, Chair. NDPP, the country suffered an embarrassing legal battle. Whether substantively or procedurally, we lost the application Guptas to the Republic of South Africa to face the wrath of the law. Now, you indicate that NPA is planning to resubmit the extradition request to the UAE. But you are saying you are unable to give us the exact time frame. And that's worrisome because this matter has dragged for quite some time now. Now, why is it that you can't provide exact time frames on when is NPA going to submit an extradition request against Guptas in the UAE? What is the actual plan in respect to that? Thank you, Chair.
Thank you. Well, what I can say is from the information that I received from the ID, it will certainly be before I leave office. So, but I certainly hope it would be even before the end of this year. But it will be soon. We are working very hard on also ensuring that we have additional charges that will be added to the original extradition request. So it's the time that it's taking is that we're not just resubmitting the old request again. We have investigated some other very important cases involving other SOEs, and there will be other charges that will be added. That has been the delay and why we didn't submit immediately after that.
Honorable Skosana.
Follow up on top of follow up. The Honorable Ngola just asked the advocate. I just want to ask you, when the minister assured South Africans that...
Honorable Skosana, you are not asking a follow-up on the question that was asked by Honorable Ngola.
No, I was going to ask that. So on top of what he was asking, my way of questioning will be different from Ngola, but it's the same follow-up which I want to get from her.
I just want to remind you that when your hand was up, you did not know what he was going to ask.
No. I knew what I'm going to ask, Chair.
Okay.
Yes. Now, perhaps let me say this to you. Have you ever spoken to the minister then, Lamula, about this extradition Honorable Ngola is talking about?
We had many conversations.
About this matter, the extradition matter, have you ever discussed with him?
Yes, about that.
Are you aware that the minister assured South Africans that the Guptas will be extradited from Dubai? Are you aware of that?
I didn't hear that.
I'm saying, are you not aware that the minister assured South Africans that the matter of the Guptas, they will be extradited to this country? It's just a matter of time. Was that discussion between you and him, or it was a political statement? Maybe you distance yourself from what the minister told us.
No, I don't distance myself from what the minister said. I don't know the details of it, but what I can confirm is that there will be an extradition application, and this country will do everything possible, the NPA will do everything possible to extradite the Guptas, who have been responsible largely for bringing this country to its knees, for the state that the country is in terms of when corruption has a face. The face of corruption is no sanitation, no water, no roads. The basic infrastructure of people was stolen by Guptas and others allegedly working in concert with them.
Let me add.
If I may finish, Chair, I'll be very quick. We
Okay.
owe it to the country that they are brought back. So what the minister said, I'm not sure, but certainly we will do everything possible from our side to extradite them. Extradition does become a political process. And so, we can't guarantee it because the process is completely in another country. But certainly from our side, the minister would be correct if he said that we will do everything possible to bring them back.
But advocate, for me, we had a witness here, Minister of Police. We are doing exactly that now. I'm saying to you, my question is simple to you, a follow-up question on this matter, because you are talking about extradition of the Gupta family, which South Africans are waiting for. Now, my question was, have you discussed that with the minister? Because the minister assured South Africans. Because as you said, let me add on that. This country is in this state because of Pravin Gordhan. You might not want to mention him, but I'll mention him for you. That family. No, I'm saying I don't want to be selective. We want them to come here to account. But I'm saying to you, hence you said that we are in this problem because of the Guptas, wrongly or rightly so. I'm saying to you, it doesn't matter whether he died. I'm saying this country we are in this scenario because of one of the persons who has done that is Pravin Gordhan.
Point of order, Chair?
Now, no, I don't. He never respect us when we are alive. You can't tell me how to deal with that matter.
Point of order, Chairperson.
Now,
Can I take the point of order?
yeah, please, because they are starting their shenanigans now, raising point of orders, raising their hands, because I'm mentioning somebody which they love. And I'm saying let them refrain themselves, because I'm talking to the advocate. The advocate is capable of answering for herself. Now, my last one, Chair,
Honorable,
on this matter, I want us to finish it because they were intimidating me and we are not protecting me, Chair.
Honorable Skosan, I say to you that
Always, yeah.
there is a point of order. And even when I have alerted you of the point of order, you continue to speak.
No, but they are talking to me. They are busy. Why is I'm talking? They are making a point of order, but intimidating me. Why is I'm talking? They must just raise their hand.
Honorable Skosan. Honorable Skosana, may you please look at me. Thank you. Can you see me? Okay. Thank you. Can we listen to the point of order, Honorable Sangwen?
Thank you very much, Chairperson. And each time Honorable Skosana does this, I think he must know that we'll call order. Chairperson, Honorable Skosana must withdraw the remarks that he has just made. He did this on another day. We called him out. And it's on two reasons why I'm asking him to withdraw. Firstly, he's casting aspersion on a person who's not even in this house, cannot respond. Secondly, he is misleading the house. He must back up what he is saying. And if he's not able to do so, then he has to withdraw. He's misleading the house. Comrade Pravin Gordhan was not found guilty of anything. Comrade Pravin Gordhan was at no point, he's just coming up with aspersions, and he must withdraw that issue, Chair.
The point of order is sustained and the time that has been allocated for you to make follow-ups has also expired. Can we,
I'm sorry, Chair, my time.
for follow-ups,
Yeah, but I was not finished, Chair. Let's be beyond reproach in terms of political parties.
No.
If you're saying it's sustained, Sangoni, it means we are saying I'm wrong.
Honorable Skosana,
No,
if,
Chair.
if you may please listen to me. You know, when we allocate your time to ask you follow-up questions, we have always differentiated between follow-up questions and follow-up questions and opportunistic questions that come with the bandwagon. So the time allocated for follow-up questions has expired. You are going to be allocated your own 30 minutes where you will come and rightfully field the questions that you are opportunistically trying to smuggle now. So if you have seen the time that Honorable Ngola used to ask follow-up questions, you will agree with me that now you are 4 times beyond that time which was allocated to him. And I want to persuade you to agree with the chair and support the chair that we must move forward. Thank you so much. Can we move to the Democratic Alliance?
Chairperson, we can't move. You said the order is sustained, he must withdraw. He must withdraw, Chairperson. These matters relating to the Guptas were fully ventilated in the State Capture Commission. Comrade Praveen, there were no findings that were made against Comrade Praveen. And for them to keep coming here every day and misleading us and saying Comrade Praveen was responsible, that can't be allowed, Chair. He must withdraw.
Did you hear what it means when we say the order is sustained? And I can see that, Honorable Skosana, you don't have a temptation to compete with the date.
Chair, for the sake of progress, I'm going to do a noble thing. But I don't want people to say, yesterday I said that. Let's talk about what I said now. I'll withdraw now. Let's go. Let's finish with the advocate. Thank you.
Thank you so much. Yeah. And Honorable Breitenbach is applauding. Honorable Sokanyile and Honorable Skosana, you take Sokanyile home and you take Skosana home. Bring a public representative here.
Please repeat that, Chair.
I mean, take Sokanyile home, take Skosana home, bring a public representative here. Yes. Yes. That is what makes you a public representative. Yeah. Honorable Breitenbach and Honorable Cameron, who is starting between the two of you. So it's going to be you and Honorable Chopper. I'm allocating you 40 minutes. Yes.
Chair, I still had a follow-up, remember?
Okay, before Honorable Breitenbach, let's take the follow-up from Honorable Shongwe.
Thank you, Chair. Advocate, there's something that is stuck in my head that you said before I asked this question. You said you don't see us finishing corruption in South Africa. That worries me. I hope you will look into it on your own time. But this is my question. NgesiZulu we say iqala alboli. I don't know how to say that in English. But when are you opening a case for Honorable Umpati Andre Johnson, whom you said this thing that she did in being in the panel of her husband was 20 years ago? When are you acting on that, if I may ask?
Thank you, Chair. I think on the first point that the Honourable Shongwe raises about not finishing corruption, that will be utopia. It will be great if we have a country and a world without corruption. But realistically, I don't think we're going to get there, notwithstanding our best efforts. But we will keep fighting. With regard to case against, as I said, this has only just been revealed, and we need to look into it and look at the circumstances, the context, etc., and see if there's any steps that are required.
Well, can we maybe give it time, because you see, you acted fast when it comes to arresting General Khumalo. So can it be of the same pace, please?
Chair, firstly, with all due respect, I had nothing to do with the arrest of General Khumalo and in terms of acting fast. So that's the first thing. But we do try to do our work speedily, and I can commit that this will be done speedily. Thank you.
Thank you very much.
Honorable Breitenbach.
Thank you, Chair. Before I start, I will declare that I have known Advocate Batohi for many, many, many years. We work together at the NPA, so I think everybody knows that I know her. So, Advocate Batohi, there are currently prosecutors in senior positions in the NPA who aided and abetted state capture within the NPA. And not only are they still there, but they continue to exercise considerable influence within the organization. You'll agree with me, I think, that senior members of the NPA had an ethical and moral duty to oppose state capture of the NPA. And they failed. You know who they are, I know who they are. What have you done? What steps have you taken to rid the organization of these toxic bad influences?
So, let me firstly respond by saying that from the very outset of my term, it has been a priority to do exactly that, to ensure that there's consequences for prosecutors who were errant and who did not uphold their oath of office and constitutional mandate, acted contrary to that. A number of the prosecutors that are implicated are currently facing disciplinary processes. And I do want to say here again that it is a sense of immense frustration as a national director that these processes take so long. The NDPP cannot interfere in labor processes. And it is extremely frustrating that those disciplinary processes have taken a year or 2 years maybe now, and they're still not complete. And there are various reasons for it. So I can't take that any further. I certainly hope we are doing what we can. I've spoken to the evidence leader to try to fast-track those processes. But, of course, labor manages those processes. It is a frustrating thing for the national director not to be able to, you can't get involved in those processes. You're also aware that Advocate Chauke has been suspended, and there is an inquiry into his fitness to hold office that will commence on the 17th of November. That's on Monday. I did recommend to the President just over 2 years ago that he be suspended, and now the inquiry is proceeding.
Thank you. I'll come back to, well, let me do it now, because you've mentioned Advocate Chauke. So you asked the President 2 years or so ago to suspend him, obviously for good reason. It took the President 2 years to do so. Do you still hold the view that you articulated earlier that, that the executive supports the National Prosecuting Authority and that they have, you have unfettered support and no influence or interference?
Well, look, what I do know is that after the President received my recommendation, he requested another legal opinion, or his office. I'm not sure it was him or his office. But I know that another opinion was sought, and the matter was between the President's office and the Department of Justice. What I can say is when the current minister took office, I would say it was less than a month that she was in office that she got this matter back on track.
So are you suggesting that the previous minister was less than keen?
No, I'm not saying he was less than keen. I'm saying there was a delay in that time,
Well, then
for
it's-
whatever the reason is, but there was certainly a delay.
The conclusion is ineluctable then that it's the previous minister who was the holdup. If you don't want to say it, it's fine, I will. And I'm saying it.
I don't have any reason to come to that conclusion.
Yeah, right. Yes, but Chauke is not the only person that we're both talking about now. There are the prosecutors who insisted on, for instance, the Cato Manor prosecutions in the face of no evidence whatsoever. Nothing has happened to them yet. The disciplinaries are, we're told, in the post. And they're not the only ones either. There are more.
Sorry, Chair, through you, I should have completed my answer. The IDAC is also investigating these matters, and there has been considerable progress in the matters. So I don't want to say anything more at this stage.
So what would your view be with regards to the state capture of the National Prosecuting Authority and DPPs and senior ones at that, who took the view at the time, openly, that they wanted to keep their jobs and they weren't prepared to, what they, as they said, make waves, not prepared to oppose the capture of the NPA? What would your view of that be?
It's no prosecutor should do that. It goes against your oath of office, your mandate to agree and go along with supervisors. It's difficult who are acting in a way that is not in line with their oath of office. And in my regional visits to prosecutors recently, I've made it very clear to them that if you are in that situation where your superiors, the leadership, is doing something that goes against your oath of office, you must respectfully disagree to go along with something that goes against your oath of office. Respectfully. But you do not go along with it because it's your supervisor that is influencing you. It's unacceptable for a prosecutor. It goes against all our code of conduct, our policies. It, in fact, could amount to a crime.
Well, I want to suggest that you look closer to home and look in the ranks of your deputy national directors. You'll find who I'm talking about. I'm sure you know who I am talking about. Don't, I'm happy to tell you. Do you know?
I know who you're referring to, yes.
Good. So
I'm
look
not,
closer
I'm not
to home.
aware of evidence against him.
Okay. Well, I'm telling you, he said it to me. And to his entire management committee, several times.
Then I would say it's unacceptable.
I see. But he's the acting national director in Rodney de Kock's place. Continues to live a charmed life.
I beg your pardon?
Continues to live a charmed life.
Not sure, I was wondering if that was a question.
It's a statement.
I'm not sure what he said to his management, but he's given me no reason to suspect that he is not a person whose integrity I cannot trust.
Well, let me help you with that. He told his management and myself more than once, I need this job, I'm not making waves. Did you get that?
That's unacceptable conduct.
Good. Now, you say that prosecutor-led investigations have increased the successes of prosecutions. Is that correct? Did I understand you correctly?
We were talking about prosecutor-guided investigations.
Yeah, same thing.
PLI is the IDAC model.
will you agree with me that it only has the potential to increase successes if you have all the components that you need for it? So you need a capable police and DPCI.
I did make that point.
Yeah, which we don't have.
I agree completely.
Yeah, we don't have. You
There are a
need
number of...
You
sorry,
need a capable NPA, which we don't fully have. You
We-
need access to proper resources, which includes access to serious forensic capabilities, accounting forensics, cyber forensics, and other technological resources, which we currently do not have or do not have fully. But what you need most importantly is you need competent, experienced, and confident prosecutors who are able to confidently take cases to court in the face of strong opposition of defense counsel, who have no such restraints and currently have a free ride. Would you agree with that?
I definitely agree with that, but I want to add to that, that I agree with everything that the Honorable Breitenbach has said with regard to capacities, capabilities that's needed to deal with these complex matters. We did a capability review in the NPA, and we found that we have extremely competent, skilled prosecutors who can prosecute, should I say, traditional crimes extremely well.
Yes.
But the reality is that with complexity of corruption, cybercrime, we do lack the skills. And that's one of the reasons why we have also been employing the use of Section 38 Counsel to fill the gap that we have precisely for that, whilst we try to build capacity and capability in these fields within the NPA. And there's a lot of initiatives that are happening to deal precisely with that.
Well, I'm relieved to hear that. So I agree with you fully that the capacity to prosecute, again, without being disparaging, prosecute traditional crimes is there. And let there be no misunderstanding. I think there are thousands of prosecutors who go to work every day and do their best under very trying circumstances. That includes the police and everybody else. It's not a lack of trying. It's a lack of capacity. And this kind of capacity is not learnt in a book. You can't get a note from Justice College on it.
I agree with you. It comes with a certain level of training, but experience as well
Yes.
in these types of cases. And the sad reality is that the prosecution, the NPA, was not prosecuting these complex matters before 2019. So the capacity was not, in fact, there was a deliberate attempt not to deal with many of these matters. One of the things I did when I took office was to say that the SCCU, we need to do an audit of all the cases in the SCCU to remove the cases that should go to the normal regional courts, so that the SCCU focuses on the types of cases that it was meant to focus on. And so that was part of the process. But of course, when you have prosecutors that are not prosecuting these matters, then it comes with experience. So we've been trying to actually fill that gap in capacity through various ways.
Well, the SECU was never instituted or set up to prosecute traditional cases.
That's
Never been part of its mandate. So if they were doing that, there should be consequences for those prosecutors who allowed that to happen. You switched off your mic.
I'm thinking.
No, okay.
It was just that it was the culture in the NPA at the time where, you know, prosecutors also chasing figures and statistics for Parliament also leads them to take, because you've got to take more, produce more numbers. The criteria, intake criteria is different. So there were a whole range of reasons why prosecutors were not being unethical, but they were doing the easy cases, let's put it that way. And so one of the things I did say is that even to Parliament, that the SCCU numbers might drop. And that is because we are now focusing on the more complex cases. But I agree completely that, you know, the SCCU was never intended to be doing those kinds of cases. But that is a lot of what it ended up doing, which was the result, which was the cause for the audit when I took office.
Yeah, well, the SECU was set up to be exactly that, a specialized commercial crime unit. And doing ordinary cases hardly requires a specialist prosecutor. So they should be marched out and shot at dawn for allowing that to happen. It's a disgrace. So you and I differ somewhat on our interpretation of the Glenister 2 judgment. And you hold the view, I believe, and correct me if I'm wrong, that, that IDAC is independent, sufficiently.
Adequately independent, that's correct.
Okay, yeah. So you were around when the Scorpions were disbanded. And you know what the gutting result of that was. For many people, for prosecutors, for policemen, for the NPA. And it was a day of great celebration for the corrupt and for the connected. And the reason they were disbanded was they went after particularly politicians, correct?
Including politicians, yes.
Yeah. And they were disbanded with relative ease, 51% of votes in the National Assembly. You remember?
I can't remember the percentage.
51, well, that's all they needed was 51%.
Yes, I agree.
And with IDAC, where it's currently housed within the NPA, will you agree with me that all that's required is, again, 51%? So what kind of protection is that? What kind of independence is that? What security of tenure is that?
Why I raised the issue and said that the one benefit of Chapter 9 institution majority is required. And I think that that should be an amendment that would require a two-thirds majority for removal of an IDAC head or a national director, which will actually address that, I agree, that point.
And you'll agree with me then that the independence that was envisaged by the Constitutional Court is not satisfied with IDAC as it currently is situated. Because of that reason, can we disband it
I don't
tomorrow?
agree, because if we look at the Glenister decision in terms of what exactly adequate independence means, I think as far as the NPA is concerned, I mentioned earlier, there are very, very few prosecuting authorities in the world where they are completely separated from the executive. Most of them have some line of reporting to the executive. And so that is why I say it's adequate independence. The issue of the operational and financial independence is another matter. But if you look at the STIRS criteria that Glenister dealt with, specialized, we are actually now making sure that we get the specialist capacities. Now
One day in the future, yeah?
Well, we have to build it up, and we're trying to be innovative in terms of how we bring in the specialized capacities, whilst we're trying to address the scourge of corruption.
The fact is you don't have it today.
Pardon me?
The fact is you don't have it today.
No, we have a number of prosecutors in the IDAC that can do this job, and we are also hiring Section 38 lawyers to ensure that we boost this capacity to do these cases. So in that sense, we do have the capacity to deal with the cases, specialized, whether it's internal or external. Trained is, we are, many of them, because I say they have the capacity and the skills, means they are in fact trained, but we don't have enough of them. And so we need to get more of them. Independence, I think, as I've explained it, there's adequate independence. You're never going to get prosecuting authorities, of very few in the world, that are completely outside of the executive. So one way of addressing your challenge is to amend the legislation to make it a two-thirds majority, which will help with the security of tenure and enhance the independence. And then resources is the last criteria. And there again, we have, we've been getting support from the government in terms of budget to get the resources that we need. But there's still specialized resources that come very expensive, but we are doing what we can to get the necessary resources into the IDAC. And to emphasize that, again, the IDAC has a number of cases already in court, enrolled, which shows that they are getting cases to court. We must not forget that it's only been it's a year since the IDAC became permanent, and it's post-COVID, it's about 4 years since we really started turning things around in the NPA. And so what they've achieved in those 4.5 years maybe, and in the last year, I agree. I, as a national director, am also not, is the one disappointment that we couldn't move faster in this regard. But there were so many reasons why we're not able to. But there are a number of cases, and I want to emphasize, as I mentioned earlier, some of the key Gupta lieutenants are in court. We're one of the few jurisdictions in the world where we have CEOs, CFOs, ex-presidents, members of boards that are in court at the moment facing various charges. And so, I can name the Gupta lieutenants, but I don't think it's necessary. They're already in court. But there's a number of really important cases that are in court that need to move quicker through the system.
You'll forgive me if my comment to that is we need to count the convictions.
Can I respond to that?
Yes, please do.
Once a case is enrolled, rule of law does not end at an enrollment. A strong rule of law means that cases move quickly through a system to finalization. And if you look at all of the challenges in the system about why these cases simply do not move through the system, and I'm sure you, Honorable Breitenbach, will be well aware of these, the deliberate delaying tactics, the fact that the judiciary has to take a stronger role in moving cases swiftly through the system. I had the opportunity in the ceremonial sitting of Judge Zondo's retirement as well as Judge Madlanga's retirement at the Constitutional Court. And I raised the issue, maybe at one or both of them, about what is the role of the judiciary as the third arm of government to implement government priorities in line with the sacrosanct independent mandate of the judiciary. It is really important. So if corruption is a government priority, what is the role of the judiciary in ensuring that these matters move swiftly through the court system? So I think that's something that needs to be addressed. I'm not saying it's only the judiciary is responsible for this.
I agree with you that they have a responsibility.
But an important responsibility to get cases moving quickly through the system. And then hopefully we will say we have finalized cases, whether they are convictions, acquittals. But I agree, it simply takes too long in the system.
So then part of the issue remains that you also need well-trained and confident judges who are not allowed, don't allow themselves to be browbeaten by the histrionics of senior counsel. Yeah. So I'm going to save some time for the Honourable Klopper, so I'm going to leave some of my questions out. We'll have to discuss the STIRS criteria a little more later, not in this forum. You said that there's no political interference, and we're so lucky to have an executive that respects the independence of the NPA. And I already referred to Chauke and the time it took for him to be suspended. In my view, that is a very demonstrable lack of support for your national director. But you don't have to answer that. Would you agree that the closing down of the DSO was politically motivated?
Well, it's certainly something that went through the process and the Scorpions were killed in Parliament.
Yeah. Would you agree that the firing of Vusi Pikoli was politically motivated?
I know that politicians were involved in that process.
Would you agree that the abysmal failure of the system, with no consequences, mind you, that allowed the Guptas to leave this country at all, was politically motivated?
I was not here when they left the country, and I'm not aware of the details, but it's highly suspicious about how they were allowed to get out of the country.
But no consequences?
Apparently so.
Well, I'm asking you. You're the national director, and the NPA was in...
Sorry, I didn't understand your question.
Yeah.
No consequences for whom,
No,
with
whoever
respect?
was in charge of that matter, they were obviously a flight risk.
My apologies, I'm not understanding.
They were
Honourable
obviously a
Breitenbach.
flight risk. Why were they just allowed to wander around and do as they please?
That I understand. They were probably failures at various levels by various institutions that allowed that to happen.
And then this you probably won't agree with, but I'm putting it to you, I state it as my view, that the constant diminishing of the budget of the police and the NPA is indirect political interference to ensure that no one is put into an orange overall.
Generally, I would agree with that statement. If that is what happens, then that is a form of ensuring that entities can't do what they need to do. But I do want to emphasize that in my term of office, we have received the budget that we require. We still need a lot more resources moving forward, particularly if the operational and financial independence kicks in. So I do want to emphasize that we have got the financial support that we need, but into the future, with the complexity of crimes and the need for additional specialized training, security of prosecutors, etc., there's going to be a need for more financial, for more budget.
So the Justice Portfolio Committee can relax. We don't have to fight for budget for you anymore. You're sorted.
Well, just for this year we're sorted, but not for the outer years.
Thank you, Chair. I have nothing further.
Honorable Thapa.
Thank you, Chairperson and Advocate Batohi. I went through the 23, 24, 24, 25 reports, the annual reports, and there were so many similarities, though under different headings. I'm glad to hear that you mentioned you have enough budgets, because many of the lines that you would find is that there are delayed and withdrawn cases due to poor coordination between investigators and prosecutors. Unfilled senior posts, specialized shortages, weak evidence and incomplete investigations, and that's flowing from the SAPS, Hawks and NPA. And at the same time, we sit with the Zondo Commission reports, the Madlanga Commission, and this very ad hoc committee, which is trying to expose this structural rot that the justice system. And I think here's the point, no one leadership position seems to be prepared to take any ownership. It seems just to be passing the buck on to a different department, to a different person. Advocate Batohi, how do you explain after 2 consecutive annual reports, and I mean, you know there's many years that follow those, that the same operational failures with no measurable improvements in coordination, capacity, and conviction outcomes, especially when we refer to the high-level corruption?
Honorable Klopper, I can say it's not just 2 years. These challenges have been going on for decades. And it is a frustration that these systemic problems cannot be dealt with. I've come back, and I was a DPP in KwaZulu-Natal from 2000 to around 2009. And I say to prosecutors, the same problems that we had then still persist in the system. And that is why, as you know, the importance of this hearing, of this committee, is to properly understand what are the challenges in the system, why are we still having these problems, and what do we need, what kind of policy interventions, legislative interventions do we need to ensure that the system can work better. Because clearly when it's dependent on people cooperating together, and we do it, it works well in some areas, it doesn't work so well in other areas, but it doesn't work. I gave the example of FATF earlier on, where we worked exceptionally well in a coordinated way. So these are not just challenges over 2 years. They are challenges that persist in a system that is, for various reasons, not able to deal with them. Whether it's lack of leadership, whether it's lack of training, various reasons, but they are hugely systemic issues that needs to be addressed by this committee.
I agree with you, Advocate. I just mentioned the 2 years just for a direct comparison. Within your leadership structure, then who is directly accountable for implementing the corrective measures promised in every single report? And have any consequences followed the failure to resolve any of these recurring weaknesses? Because we sit with the reports in the committees, we read them, they come with the reforms, but it never gets done. And by your own admission now, it's been years and years upon years.
It will be, Honorable Klopper, it will be easier for me to understand that if, with respect, I understand exactly what the issues that Honorable Klopper is referring to, because a number of issues that were raised, and we've put in place a number of interventions. We have a Deputy National that's head of Strategy Operations Compliance. We have a head of our DDG Corporate Services head. So depending on what the issues, and of course we have Deputy National Directors that are dealing with these issues. So specific issues I can try to address in terms of what we're doing to address some of those challenges, but there were a number, and I don't have the annual report in front of me, my apologies. But we are definitely trying to work with the police, whole lot of training interventions to try to get better standard of investigations, to get prosecutors better capacitated, to get cases to move through the system quicker. I sat with General Labia to say to him, you know, we have the PGI model, but it doesn't help if police are still reporting to him, prosecutors are still reporting to the NPA. We need to sit down together and get a common report. We need to have joint indicators with the SAPs, because these are things that will really help everybody. When you have different indicators within a system, the police have arrests as an indicator, we have convictions, we need to have the same indicators so that we are all working towards the same outcome, like we did with FATF process. And I think those are the kinds of systemic issues that need to be addressed.
Thank you, because I can't go into the very specifics because of my time limitations. Many of the reports cite, for instance, poor coordination between investigators and prosecutors as some of the key reasons and delays of withdrawals. And I would just say, is it fair to say that the interagency cooperation between NPA, SAPS and Hawks has effectively broken down? When Advocate Johnson was sitting here, she spoke about that they didn't know where cell phones were, that they didn't know what the PKTT was doing. And this pointed to no communication. And when I spoke about protocol, she said, no, we don't need protocol, we just need to speak a little bit more to each other.
I would tend to think we need protocols, because we've been doing a lot of speaking, and depending on who's there, and I want to emphasize, we work very well with the police. And so, you know, we joined at the hip, so we have good relationships with them, we're working together in the provinces, but the reality is that there are still coordination problems and challenges. There are still quality of investigation problems and challenges. And so I think maybe protocols would be, you know, the way to go, so that it's not dependent on an individual, but it's the way we do business. There are coordinating mechanisms, but I think the indicators not being the same definitely is one of the reasons why, you know, we are not able to move in the same direction quicker.
Thank you, Advocate. I do agree with you. I always tend to think back to the committees that we sit in. And when we ask specific questions, why were there 700,000 backlog cases at a stage? It was said, no, but, you know, SAPS, a lot had to be referred back. They didn't do the investigations properly. And I think those are the things I'm trying to speak of. But that's just a statement I would just like to make on you, what you've said back to me. Advocate Batohi, I would like to come to the letter that you wrote to the President about the suspension of Andrew Chauke. And it took 2 years. In an oral session that I asked a question to the Minister about providing assistance to support the NPA, and specifically about this letter, her response was quite shocking, and you yourself have almost said the same now that she was, you know, the capable Minister. She said she cannot interfere. And now, while I'm fully aware that she's not allowed to interfere into prosecutions, and everybody in this room is, it seems that she was reluctant to follow up on a 2-year suspension letter that could be investigated. I won't go into all the allegations, but I mean things like weaponizing the NPA, protecting Richard Mduli, invalidated racketeering charges against Johan Boysen. This hits at the heart of why we're sitting here, Advocate. So suppose you are serious about fixing the justice system and fighting this corruption, what follow-ups did you personally make in those 2 years to make sure that the suspension was addressed? And not to influence the decision, but at least be attended to. And I think, was it just gathering dust? You know, you spoke about a legal request, but that's 2 years we're speaking about, Advocates.
Honourable Klopper, this was a process completely out of the hands of the NPA, but it doesn't mean we sat back as passive bystanders. There were regular follow-ups by my office to see where the process was. My Chief of Staff made follow-ups as well, with the different departments. But I do want to emphasize, I do want to correct if there was a misunderstanding. The current minister, when she took office, acted on this. I think it was less than a month that she was in office, that the matter has been referred back to the presidency. My understanding is that it was still in the Department of Justice. She acted very fast on this. But that was all we could do, is just follow up to see where the process was, which we did.
Thank you, Advocate. The impression I got from the oral question was just that simply it wasn't her duty to intervene there. I won't go into the length and the breadth of the 5th and the 6th of June statements that you made in the media, and I won't be asking specific names. I would just like to know, why did you go to the media, make statements? You drew attention, and you said in today you don't particularly maybe even have evidence on it at the moment. Does that not then incite possible panic and undue frenzy?
The reason why I made those comments at the time was, I said I was not prepared to talk about the detail of the one specific allegation. But that information, intelligence that I received during a formal briefing by an agency member, was a very serious matter. And at the time, the NPA, the national director and the NPA was under serious attack. And it seemed to all make sense about why there was the serious attack on the NPA, given the intelligence that I received. And that is why it was in an attempt to actually make the country understand that we are facing various challenges from so many different quarters in trying to deal with crime in this country. And that was the reason for it.
Thank you, Advocate. I would want to go in more into it, but I think my time has almost expired, so I'll come to my last question. On the 10th of September 2024, you spoke about having unhindered access to the Zondo evidence. But even in that meeting, you seemed to be very cautious. You were pulling punches, not openly saying what you wanted or what was the hindering. It seemed to be very a tense meeting. So I would just ask you plainly, Advocate Batohi, is this hesitation because of internal interference within your organization, or is it because of external interference from the department you fall under? I would just like to know which one it is. And I'd be glad to hear if you've since been granted this unhindered access to prosecute these high-profile cases. And I would also just like to make one last point. You know, you've repeatedly said that the NPA acts without fear and favor and prejudice, yet individuals like Lucky Montana still remains untouched. And I don't know if that's because of these Zondo Commission reports that are still inaccessible.
So just on, the NPA still does not have unhindered access. We request information from the department and then receive the information either through Section 71, I think, and Section 28 requests from the department. I don't want to raise this in Parliament now. There have been some challenges, but the IDAC and the department are working through this. And it seems like we do have solutions in place, but that is the current situation.
Sorry, are you saying that you had challenges getting unhindered access? Is that what you mean?
We don't have unhindered access. The access that we get, well, it's through a request process at the moment. We get information. But my understanding is that there is the IDAC and the mechanism are talking to allow IDAC to get better access to the database.
Advocate, I remember that meeting quite vividly. You were emphatically clear in that meeting that you can't ask for information you don't know is there, and hence was the reason for that unhindered access. So it sounds to me, and I think it almost leans on what Honourable Breitenbach was speaking about earlier on, is there an executive overreach, seeing that you fall under them, that hinders your access to information, and they have the final say on whether you can get to those reports or not?
All I can say is that it's not the executive, because I haven't escalated this to the minister yet. I said to the minister, we are working through it, and if I need to escalate it to you, I will. I haven't done that yet. As I said, the IDAC, you are right. You know, you can't ask for something that you don't know exists. So we are trying to find a way with the department to ensure that the IDAC is able to have direct access, that IDAC people, my understanding is that there's been an arrangement that members from IDAC will be able to go into the system. But they're putting that in place, and I haven't had any feedback. This is a recent development, and hopefully that will work.
Thank you very much, Advocate, and I really hope that you do get it right, because we are sitting in the crisis we are because of things like that. It's one thing, it's one of the cogs in the wheel that is causing the country to be where we're at. And if we go to every single department and we identify those very bottlenecks that are stopping us from actually doing our work, and especially you in the NPA and ADAC, excuse me, we just get those small solutions done, I think we can really make a difference. Thank you very much for your time today, Advocate.
Thank you.
Thank you so much, Honorable Breitenbach and Honorable Klopper. The list of follow-ups start with Honorable Shongwe, National Council of Provinces, and Honorable Mani from the MKP is a member of the National Assembly. Thank you so much. Can I note the hands? Honorable Shongwe, Honorable Ngola, Honorable Sangoni, Honorable James, Honorable Matthews, Honorable Skosana. Are you decided that your hand is up, or you will be the last? Thank you so much.
Thank you, Chair. Advocate, how did you find out about the Gupta extradition? Was it on a written note, or somebody told you or informed you, sir?
Chair, if I may ask for clarity, how did I find out about what aspect of the Gupta extradition?
You said that you are right, and you said when you're going to do that, you're going to study what really made you fail or not to get something like that. You said the reasons of why it was not approved. Am I correct?
Partly. I said that we will submit a new application with more charges, but that there was a risk because we still don't understand why the UAE court refused the application. Now, let me hasten to add, we have received reasons. We know what the reasons are, but they don't make sense. There were two things that are important in this context. The one is that the UAE had concurrent jurisdiction for money laundering, and that meant that they could prosecute money laundering. That's fine. That is perfectly allowable in extradition processes. And so our response was, we can give you the evidence that you need, that we have in South Africa for money laundering. But there's never been a request from the UAE for any evidence from South Africa for them to prosecute money laundering cases. That's the first part of it. The second part of it, there was some suggestion about a cancelled warrant being attached to the papers of the extradition. We are not sure why the UAE authorities attached a cancelled warrant to the papers, but we do know that there was a cancelled warrant. And the reason for a cancelled warrant was that initially there were certain exchange control contraventions that are not crimes in the UAE that were included in our warrant. And my understanding is that it was removed, and therefore one warrant had to be cancelled and there needed to be a new warrant. Generally, when these kind of technical issues come up in an extradition process, it would be referred back for that technicality to be corrected. But in this case, the court saw fit to decline the request. That being the case, we will still submit a new application as soon as possible.
Okay. You know, the fake it until you make it statement is starting to make sense to me by Andre Johnson, the head of IDEC, which you were asked on a certain interview, what's your take on it? And your answer was that she was motivating her staff. But let me read to you a judgment by the court when we are speaking about the suggestion. This was not a suggestion, it was a judgment. It said, whereas regarding extradition request for the fraud charge, Article number 3/9 of the extradition agreement stipulated that the extradition request must be submitted by a copy of arrest warrant, whereas in accordance with the submitted document, the attached arrest warrant issued for the fraud crime is cancelled accordingly. The extradition conditions for this crime were not fulfilled. Further down it says, whereas the submitted documents did not include any arrest warrant against the person to be extradited for the corruption crime accordingly, the extradition conditions for this crime were not fulfilled. So that was the judgment. The one that you say is a suggestion.
If I can comment on that. So, as I said, there was an issue with the warrant. Generally, when these kind of technical requirements are not met in extradition processes, the court will refer it back for that to be rectified. In this particular case, that didn't happen. It was declined. And if the court had referred it back to rectify it, we would have complied with that requirement. And as I said, we're not sure because the final set of papers is put together by the prosecution in the UAE. Although a team from South Africa, a team of prosecutors did go to the UAE to make sure that our papers were in order before the final set of papers were put together.
So this is from since March 2023 till now. So this is since from March 2023 till now, nothing has happened.
As I said, from the time of the decision, we have actually been working really hard to make sure that there are more charges in addition to the one.
All right, thank
Sorry,
you.
if I may finish, in addition to the ones that we put together. And I do want to emphasize that our prosecutors traveled on a number of occasions to work with the prosecutors in UAE to make sure that our papers were in order. Thank you, Chair.
But you are aware that this judgment was 2023 March.
I'm aware of that.
Thank you, Chair.
Thank you so much. Honorable Ngola.
Thank you very much. And NDPP, is it your evidence that requesting information from the Department of Justice and Constitutional Development in line with the Commissions Act is a hindered access?
Sorry, Honorable Member, I didn't get the full
I am saying,
import.
is it the evidence of the NDPP before this committee that requesting Zondo Commission information from the Department of Justice in line with the Commissions Act is a hindered access?
I'm not sure about the part in line with the Commissions Act, my understanding is, and I'm not sure what part of the Commissions
The
Act.
Commissions Act actually says the custodian of
Is the
commission
department.
work is in the Department of Justice.
That is correct.
Yeah.
In
So
terms-
is you complying with the Commissions Act a hindered access?
Well, it's an access by way of requesting the department for
So
information.
that's what you call the hindered access.
Well, I suppose it could be termed in that way, because we don't have access directly into the database. But I want to add that there have been recent discussions between the IDAC and the department where they have reached some agreement about IDAC investigators getting better access. So
No, but
what it-
NDPP, I want you to take us to how is requesting information from the department in line with the law a hindrance?
When we say unhindered access, I fully understand that the department is the custodian of the information from the Zondo Commission. And that is why, at the time, although there was an original agreement that the entire database will be sent to the NPA, we realized that the department is a custodian. So that is a correct process. But we need to find a way of, within that context, the IDAC getting the information that it needs from the Zondo database.
Okay, the department committed to train and give full access pins and other things to prosecutors so that it makes it easy for you to access that information. Has that been done?
There was some training that was done, that is correct. Some IDAC investigators were trained. But they still, my understanding, and I don't have all the information, so I stand to be corrected, is that even those that were given this access, that were trained, had access to a particular part of the database and not the entire database. That is my understanding. But now it is something that, as I said, IDAC is working with the department to make sure that we're able to access what we need. This is a recent development, and I would just ask that we allow that process to unfold to see if this better access works for the IDAC.
Okay.
And, you know...
So the law requires you to follow a particular procedure for you to access information. The department, further to help you, trains prosecutors. But you still come here and say you have got hindered access to the Zondo Commission information.
If I may say, I agreed to a suggestion that the honourable member had made to me in using that terminology. I was trying to explain with respect what exactly the process is. So initially, as I said, and I'm repeating myself, forgive me, but the entire database was meant to come to the NPA. That was the agreement that we had. But later on, the Department of Justice said that that should not happen because correctly they are the custodians and that all of that information will be under the department's control. We've then had a long history of the training took place probably more than 2 years ago or so of some investigators. And there's been a long history of us trying to get the access that we need. As I said, there have been ongoing conversations and discussions. There is still now a new process that is going to be put in place, and I'm asking that we allow that process to see whether the IDAC gets better access to the database and gets access to the information that it needs, because this is critical for the prosecution of these cases.
Does the NDPP have an appreciation that the information is not only meant for the NPA, but it's meant for all the law enforcement agencies of the country? Thank you, Chair.
Yeah,
Absolutely.
that
I
is
agree
the
fully
last,
with that, and I have an appreciation for that as well.
Can we move to Honorable Sangwen?
Thank you very much, Chairperson. Advocate Batohi, please, will you help me just understand? I need to know the difference or similarities, if there are any, between the Scorpions and IDAC. I'm asking this because I thought that what had made the Scorpions successful, I don't know if I'm using the right terminology, but this prosecutor-guided investigation approach that you're talking about, or something of that nature, which is exactly what I think has been given to IDAC now. Could you just clarify that for me, please?
Certainly, the prosecutor-guided there's two types of prosecutor-guided methodology and prosecutor-led investigations. The prosecutor-guided investigations are where the prosecutors in the NPA work with investigators in the police, and they work together in a coordinated way. That's ideally what it should be. In order, prosecutors guide investigations, but the investigators are from the police. The prosecutor-led model is the IDAC model, where investigators, prosecutors, and other disciplines that are needed fall under one structure. That's prosecutor-led investigations, and that is the model of the Scorpions as well. The difference is that it's the same model, but the Scorpions had a much wider mandate in that they also investigated organized crime. and high-level complex economic crimes. The IDAC mandate is restricted to certain types of corruption and other forms, related crimes, as per the Act. That is essentially the difference.
So would I be correct then? I think I'm drawing from this discussion that I'm following up on the Scorpions. So if the Scorpions were disbanded because they were chasing politicians, I paraphrase, right? They were disbanded because they were chasing politicians, then you go and you take exactly the same model that was a success in the Scorpions, you give that mandate to IDAC, you give them cases where largely the expectation is that you'll have, politicians, high-profile people in the cases coming out of state capture. Would that not mean that this government has taken a decision to go to exactly where the challenge was as it relates to state capture, create a model that works in the same way as the Scorpions in order to strengthen the fight against corruption, and even specifically corruption that is seen to implicate politicians?
I think you're right, Honorable Sangoni. And the danger of that is if politicians feel threatened by the success of a unit, they would want it shut down. So that is a threat and a risk.
And I heard you how you're saying we must respond to it. But I think the point that I'm driving is...
Paraphrase, so I'm using your term, sorry.
No, I get you, and I get you how you said it must be protected, right? But for all intents and purposes, those wrongs, or the wrong that was done, the original sin against the Scorpions, to a certain extent is being addressed by the establishment of IDAC.
If I understand your question correctly, Honorable Sangoni, are you saying that the part of the mandate of the Scorpions is the mandate of the IDAC and the methodology is the same? Am I getting it right? I just want to understand your question, please.
You see, I don't want to get the president into trouble by saying he re-established the Scorpions, right? But if the Scorpions, you said there may be political interference. So if the Scorpions were disbanded because they were chasing politicians, by creating an IDAC that you give a mandate to look at corruption, to look at state capture cases, basically where the politicians are, and then you give it the same methodology of operating which had proven to be effective in the Scorpions, then to a certain extent you've tried to right whatever wrong was done by the disbandment of the Scorpions as it relates to the chasing of politicians.
I would broadly agree with that suggestion.
Honorable Batohi. Are you asking the follow-up, or are you forfeiting the opportunity?
Mine is, Advocate, you said there were prosecutors between you and Honorable Breitenberg that know who aided state capture. We don't have their names. Can we have them, please? And some of them are currently in DCs, etc. I don't know.
It is very difficult, again, because as a matter of policy in the NPA, when there are disciplinary processes, we do not make any public statements about them. And even though in this case one might argue that the names have been bandied around in public, I don't want to fall foul of our own policy and mention names in this forum, because that is the policy of the NPA. But the names have certainly been mentioned in public in this instance, many of the names.
So we're going to have the same situation as we have earlier. I guess it's something we can discuss when we take the name of the prosecutor that has been investigated. I guess you're going to say the same thing about the politicians who you said who were involved in Vusi Pekole's prosecution or withdrawal of charges, his case. That was also a conversation.
He was suspended by the president and the ministers at the ministers.
So you're saying it was the president and the ministers that interfered with the case?
All I said is there was involvement of politicians because they of necessity suspended him.
The other one, my other question, which was already answered by, asked, was the Scorpions versus IDEC question. It was already asked. But in the same breath, the Scorpions was weaponized against factions in amongst politicians, amongst rivals, etc. And that was partly why it was disbanded. I mean, I think that is also a fact. So the fact that we have an introduction of IDEC, it's to serve the same purpose, to serve a faction in the political space. What would you say to that?
With all due respect, Honorable Mateus, I'd say before we say it's a fact, we should have the evidence.
So why do you think the Scorpions...
If I have the evidence, then I might agree with you that it's a fact, but I don't have that evidence.
So when the Scorpions... Okay, let's leave it. It's fine. Thank you.
Thank you so much. Can we take Honorable James?
Thank you so much, Chair. Advocate Mart almost skipped a beat earlier on when I heard you saying that NPA works very well with SAPS. Maybe if you had said, you know, we work fairly well, but the fact that you say you work very well with SAPS, maybe SAPS in the rest of the country and not in South Gauteng. I want to ask you, was NPA part of the counterintelligence task team?
Not that I'm aware of. I don't know. We sit on a number of structures, but whether we're on a counterintelligence structure, I'm not aware that we are.
Because I think with all these task teams
I'd be surprised if, sorry to interrupt, Honorable James, I would be surprised if we sit on an intelligence structure, but I must confirm that.
I'm just asking because we were told by previous witnesses that the composition of these task teams would obviously also have a component of NPA. So they would sort of work hand in glove. So you're saying that NPA was not part of counterintelligence. I'm trying to understand General Mkonazi's allegations that there are loopholes and cases were being struck off the roll. You said earlier on we need to follow the money. I'm trying to follow the money with this. And you said that NPA works well with SAPS. Why was the frustration specifically with counterintelligence that was investigating these drug cartels?
Honorable James, I'm not sure what the context of this is, and I'm not aware that we sit on counterintelligence structures. So I need to get that information first before I can understand what the frustration might have been there. But there are so many structures, and when I say we work very well with the police, I mean that they are our closest partner in terms of fighting corruption. And so at different levels, from national through to provincial, district level, local level, there are partnerships and relationships that are critical. They work at different levels of effectiveness, but we generally have good working relationships with the police. It isn't always as effective as we would like it to. So that was the point I was trying to make. But on your counterintelligence, I will have to get information about which structure exactly and whether we sit on that.
I want to disagree with you there because I know of dozens of drug-related cases that were struck off the court roll, specifically in the Gauteng area. And I'd actually like to forward you all those dockets because whenever we have these operations, especially in Gauteng, and I'm especially referred to Eldorado Park, we almost have to beg the courts to basically place those cases on the court roll. But I'm going to leave it at that. I'm going to leave it for my questioning. I'm just going to leave it there for now.
Well, Chair, if I could quickly respond to that, because it's an important issue that you raise, and if there are dozens of cases that are being withdrawn, we do need it to be brought to our attention. We have now put in place in the NPA, we are asking for reasons from prosecutors for every corruption case that's withdrawn. There must be reasons, and for withdrawal of sexual and gender-based violence matters, we're asking for reasons to be submitted so we can check to see what is going on. But if members find this as a problem, I would urge members to please bring it to my attention so that we could look into these matters and deal with any errant prosecutors or investigators as appropriate. Thank you, Chair.
The last person is Honorable Skosan.
Thank you, Chair.
The list is closed.
I've got 3 follow-ups. One, Honorable Brechenbeck asked you about the political interference. What's your view on that, about Advocate Piccoli? I wanted to get your answer clearly. What was your response?
My response was that he was suspended by the president, I assume at the recommendation of the minister, and to that extent, there were politicians involved. I didn't say there was political interference. I stand to be corrected, but there was involvement of politicians, because that is the way it works.
No, but you did not respond like that, but it's fine. Because she was very specific, hence I wanted to find out a clarity on you on that. But let me just say to you, if you don't believe that, I think you have McCarthy and Bulelani Nguga. He can attest to that if you want reference. The issue of the scorpions, that they were targeting people, is a fact. And when it comes to the IDEC, it's like now it's in a different name. And hence my Honorable James said he will forward you the issue of Gauteng in particular about these drugs issues, cases being withdrawn. Some of us were experienced about that. We are very experienced about that. I mean, we open cases, your prosecutors decline them. You know, they in other words, there's a smear campaign. Somebody must go to court several times before the matter is withdrawn or the matter is thrown out. Now, by that time, your character is gone. The perception is everything, especially with politicians. What they do, these factions, when they target advocate, like my colleague has said earlier, especially Honorable Mvalo, especially towards the elections, there's an arrest before investigation. They investigate a person after he was arrested. For the next 5, 6, 7 years, they are saying they are busy with investigation. Why arrest people before investigation? Because they want to destroy you. Now, we are saying because we are living, as you said, in January, other issues maybe are going to be attended by the incoming NDPP, which is unfortunate. But in my view, I'm saying to you, please, in the period which you are still in the office, can you please ask them to treat people fairly? But I'm going to have my question. You'll understand where I'm coming from, to say the rate which you were explaining here, to say you've got 81% success. We'll debate that later. Thank you, Chair.
Chair, if I may, though, there's been a number of comments that have been made, and I would like to quickly respond to them, because it is important that the correct messaging gets out to the public. Firstly, Honorable Skusana said it was a fact that the Scorpions were targeting. Again, as I responded, I would like to get evidence of that so that we can understand exactly what these facts are based on, and then I can comment on that, and then saying that the IDAC is doing the same. And Chair, I worry that the IDAC has been put together to deal with corruption in this country. I accept that it's a baby. It's still we've just given birth to it. And it seems like we're already having these conversations about targeting, and whether my concerns are that as a country we want to fight corruption, and that if we try to raise these kinds of issues relating to the IDAC without any substance, and if there are substance and facts, please, I will urge the department to get the investigating judge put in place as soon as possible, because this is the one instrument we have in this country to deal with the scourge of corruption. We need to strengthen it and not weaken it. So I urge that we get facts on that, please, Chair. On the drugs, Honorable Skusana, that's an important issue. If you please, again, please give us that information, because we need to understand exactly what the facts are so that we can properly investigate it and deal with it in the way that results in consequences after a good investigation. And the final comment that Honorable Skusana made was that arrest before investigations, particularly when it comes to election time. Again, please, Honorable Skusana, if you could write to me send me the facts of these cases, where it's happened, and I give you my assurance that I will look into that and make sure that whatever decisions have been taken correctly, and if not, there will be consequences. But we do need the facts of these matters. Thank you, Chair.
Thank you so much. Honorable Skosana was last on the list. We are now taking the economic freedom fighters, and thereafter we will take a break. Your 40 minutes start now. It's up until...
I'm going to only be 5 minutes,
It's
Chair.
up until 21 past 6. Yes.
Advocate, there is in your annual report says there was 57.4 million in funding that was received from the federal government of the Republic of Germany. What was that for?
So that is primarily to deal with capacitating the NPA to fight corruption. And to say that, it wasn't money that the NPA received, but we received services that helps us to
In
capacitate the NPA.
Okay. And who conceptualized the project?
It was conceptualized in the NPA.
Okay.
Of course, with the government of Germany.
Okay. Did the NPA approach the Hans Siedel, is it Hans Siedel Foundation? Because this is the NGO that the funding was channeled through, am I correct?
We worked with the government of Germany, and the government of Germany decided on the partner that will implement in South Africa.
Do you know why they chose the Hans Siedel Foundation?
I have no idea.
You didn't ask?
No, it was the German government. They were giving us the sponsorship, the assistance, and I assumed that as a government they would do the responsible thing.
Okay. Do you know that the Hans Siedel, but as part of our government, don't you think you should also do the responsible thing and find out what was the story behind the Hans Siedel Foundation? Because do you know that they also collaborate with News 24?
I'm not aware of that.
And that it collaborates with the Institution of Security Studies that is chaired by a Jackie Salas, who goes around calling for prosecution of members of parliament and engages political discourse.
I didn't know that either, but I'm not sure how that becomes a challenge. It'd be good to understand.
So you don't see how private funding can risk the capture of institution, of any institution for that matter, yet alone institutions like our criminal justice system. And we also had our previous Concord Mogoeng, who refused to take private funding as well because of the sacredness of these institutions that we have. And why do you feel differently?
So let me say that with regard to and it's not private funding. We are not getting funds, but we have engaged in innovative partnerships with the private sector to ensure that we get the skills and capacities that we need to assist us in the fight against corruption. The reason why we think this is not problematic is that we put safeguards in place to make sure that we distance ourselves from the funding as such, but also to be clear that this is in line with international good practice. The UN Convention Against Corruption specifically states that it's important for government to actually partner with the private sector in their fight against corruption. So this is an international good practice, and we have engaged in a very strategic way with relevant partners to ensure that we get the capacities, capabilities in the NPA, which in a very financially and fiscally constrained environment, we do not have. So this was actually bilateral meetings that we had with the government of Germany and the South African government. I understand even ministers been involved. And so we put in place the safeguards to get the assistance to train and capacitate, really bespoke training for prosecutors and investigators in the fight against corruption.
So, Advocate, are you alive to the facts on how foreign governments capture countries And it starts off, sometimes it's not always in the form of money, but exactly that, it's training. They're training prosecutors of our country. So the issue of being trained, being captured by another government, being in such close proximity, you don't see, leave the UN out. I mean, the UN cannot be our standard, and if we look at other issues on how they handle matters in the country, let's talk about what we need here in the country. We've come out of a country that's both been colonized and through the apartheid. We need to stand on our own feet, and we need to manage. The fact that you even say, Advocate, that you didn't see any need to investigate this organization because you figured that Germany would do the right thing is problematic.
Honourable Member, I can understand the concern that you could have countries that would try to, in some way, influence things in another country. That's, of course, it's possible. But in this case, we control, it's not like the German government or the implementing partner that they chose are the ones that decide on what training we get. The training has been, the manuals have been developed completely by South African experts and prosecutors that sat together for days to develop a complete training manual drawing on our expertise. So it's completely something that's in-house. It is something that we control all aspects of with regard to the training. We even train, we get experts here. It's just the support in terms of getting
It's money, though.
the funded. I understand that it is money, but it's different where people would go to another country and get training that we have no control over. Here we have complete control over what is happening. We want to ensure that our prosecutors have the necessary capacities, and because of the fact that we are in a fiscally constrained environment, we've been innovative in trying to deal with these gaps to ensure that we can fight this fight properly.
You also said we don't need any more money, and here we are getting 57.7 million from another foundation that you didn't do any due diligence on. And to even go as far as your disclaimer saying we do our own training, we do our own manuals, etc. here, but you've just said, Advocate, that you don't know anything. You didn't even know that it's linked to this Jackie Sellis. You don't know about the Institution of Security Studies that he chairs, and that's problematic.
Thank you. Honourable Member, there's some things about what you said that I know about and other things that I don't know about. So the initial links that you mentioned, yes, I don't know anything about that. But what I do know about is the way we've been working with the government of Germany to ensure that we are able to get the training that we want. And there's other, there are other governments that are supporting other entities in South Africa with things like training. For example, the French government is in a partnership with the SIU to provide training for them. And so I agree, we need to have safeguards to ensure, for example, the things we have put in place. And, my understanding is that the Hans Seidel Foundation has, for decades worked with the German government as a trusted partner. So, I think it's important to understand that their role is an implementing partner for the German government. But we have really, I want to urge, we put in place controls to make sure that we control what happens, and it's not like getting training that's decided on by another government.
And then perhaps, Advocate, if we did more to end corruption, we wouldn't have to be begging with Germany and France and other countries to partner with to do very basic services we're supposed to offer our citizens. It's actually shameful, because I don't think any of those countries take any funding from South Africa to do any services over there. And these are just the bare basic services that we're supposed to offer our country, and we are taking funding from foreign governments to do it. It's quite disgraceful.
If I might respond to that, please, Honourable Member. Two things. I think in the first instance, I agree with you completely that if we could deal with corruption more effectively in this country, it's not just about taking money from other countries to fight corruption. Africa is almost the beggars of the West when it comes to aid and funding. It should never be the case. Africa is a rich continent. We have enough to pay for everything we need. But we become beggars to the rest of the world because of corruption in our countries. And I agree with you completely. If we're able to deal with corruption, we don't need money from anyone in the world. We'll be able to fund all of this. And just to clarify the point I made about the budget, we have for this, as I said, we have funding for budget for this year, but for the outer years, we are going to need a substantial increase in our budget. Thank you.
And this brings us to the next question on corruption. So the Auditor General reports annually that billions of rands are classified as fruitless and wasteful expenditure. Then there's also irregular, unauthorized expenditure across all government entities. So how many cases has the NPA enrolled for violations of Section 38, 39, and 40 of the Public Finance Management Act? Can we get
Honourable
them?
Member, I don't have the stats before me. We can certainly get that.
Okay, yeah, I'm sure you have a team and we can submit that, because if we can pursue labor-related cases, I think these are when we talk about corruption. And the more we are pursuing corruption cases and this wasteful expenditure cases, I think we're less likely to find that they continue spiraling. I want to talk about the complaints. In your report, you've also, in your statement actually, on point 52, you've indicated there were 58 complaints that were lodged against prosecutors between 2019 and 2025. And then you've indicated how many were...
The reference? I beg your pardon?
I think it is point 52.
On my affidavit?
Mm-hmm.
Mm-hmm. $22. So 50, sorry, Honourable.
58 complaints were lodged, and then you explain what was the outcomes of
Sorry,
these
the paragraph
58.
number?
On paragraph 52. Have you got it? Yeah. So you've got about 3,500 prosecutors. Am I more or less right? And there's about 280 that are on contract. Across the country, how many prosecutors we have?
Across, around 3,500,
Yeah.
yes.
So, Advocate, to say that we've only received 58 complaints for such a long time, it's shocking. I'm sure half of South Africa is falling off their chairs or hitting into some car or taxi right now. It can't be. So there's either two things, and maybe you should look into it or explain. It's either that we don't know where, or South Africans at large do not know where to lodge complaints. The average person on the street, we can just step out here in Cape Town and go and ask anyone what they think about the NPA, and someone will have a story to tell. So to say we only receive 58 complaints means that there's something wrong with the system. And I have a personal experience. I've lodged a complaint against a prosecutor a long time ago. The only time I got a response, and I did it through the right channels, the only time I got a response is when I went on social media. So can you respond to that? Because it can't be that you have that many prosecutors and we only get 58 complaints that you've reported at least.
I will certainly look, the numbers, I agree with you, appear to be low given you know, the numbers that we have, but I will have to confirm. I imagine that my team have given me the correct numbers. We have on our website, people are able to get complaints. We have an ethics hotline where complaints can be made. If you go onto our website, you'll be able to find it. So, you know, I would imagine that that's the first point of call for people will be the website to make complaints. With regard to your complaint personally,
It's a long time ago. I've even given up hope. Okay. But I was using that as an example that I followed up, and I would even still have it, like 3 or 4 times
I can
And
say-
only when I went on social media, then they called me and asked for information about it.
Chair, I take heart in hearing it was a long time ago, so maybe things have changed now. I certainly
No,
hope
it
so.
was during your time, though, but I'll send it through. But I'm saying that that amount cannot be, it's shocking. Your statement also seems that you've made a deliberate effort to demonstrate that there's sufficient oversight at IDEC. So if there was, why was it necessary for us to insert Section 22A for oversight? Because, I mean, otherwise we're just doing wasteful expenditure.
That's a very good question. Initially, it was not in. It was raised by the Minister of Police, Minister Tele, because the DPCI has a judge. And so it was in that context that we agreed to it.
So did you agree that there wasn't proper, or the oversight that is needed, that the police have, that IDEC needed?
We didn't see the need for it initially because we felt that there were sufficient systems in place to address misconduct or allegations of misconduct in any part of the NPA. But having inserted it, I think it's actually better to have a higher level of oversight. So I would agree that that's a good addition, which wasn't in the original draft.
On point 34 of your statement, you have recruited investigators from SAPS for IDEC. Was that a wise move to do? Because we already have chronic shortages of investigators in SAPS as it is. And then IDEC has gone to, or you have seconded, and this is from your statement, or you've seconded investigators from SAPS. How does that leave SAPS?
Well, if that didn't happen, the ID wouldn't have been able to work. We would have created an ID that couldn't work. It required partnerships with various other partners in the justice system to capacitate it, because it was temporary at that time, and the numbers were very low. And that's why I mentioned earlier that the secondment model was not going to work, because where you have other entities that are themselves struggling with capacity, how do you expect them to support and assist a new directorate that is required to do work that the country is expecting it to deliver on at breakneck speed? It's just not possible. So under the old structure, it was necessary to get investigators that had the necessary powers and experience. And we are grateful to the DPCI for supporting and assisting the IDEC. Otherwise, it would have been pointless setting up this entity. But now that the IDEC is permanent, we're able to recruit from outside. But of course, if people, it happens in government, people move, we lose people to SARS and the external, partners or businesses, and it happens in government. And that is why I said, unless we regularize the salary issues, it will be easier for people to remain in the entities without moving for other better opportunities.
How many of the investigators that you have now in IDEC, I keep saying the wrong things, have had criminal charges at some point, whether they were successfully prosecuted or not? Are you able to give, I'm sure you don't have it offhand, but if you can get that. And also, how many were dismissed from previous institutions for misconduct? I think that's very important.
We'll certainly get that information. I would be interested in that as well.
Okay, the Scorpions and IDEC we've answered. We want to talk about the former NPA's ID, Advocate Kranji. Is it Kranji? He resigned in 2021. Do you know why he resigned? She, sorry, yes.
I suppose it would be best for her to answer that.
But, yeah, I know that, but I'm saying, do you know?
I'm not sure what the exact reason was at the end of the day, but I suppose, she had her reasons for deciding it was best to leave the NPA.
Are you aware of the reports where she said she was fed up because there was resistance to bring the right people to book? And do you have a comment on that? Do you know about those reports? Because
I'm not aware of that report.
so
But-
you came in, you didn't know anything, you didn't do any investigations on why she would just resign and just be fed up. We're asking for your opinion here. We're not saying that whatever you say is going to be the gospel truth, but what is it that you got from it?
I think there were frustrations all round, and Advocate Cronje decided it was best that she left.
Do you want to talk about some of the frustrations that she had expressed to you?
No,
Why?
it's her personal reasons, and I think it's best that if she
So
wants
she
to talk
didn't-
about it, it's best that she talks about it herself.
Honorable Adams, so you said you just got a high-level briefing from Advocate Johnson regarding the Khumalo arrest, which stemmed from the cases that Honorable Adams opened. Given hindsight, do you think that do you know, or do you think that there should have been an explanation that Honorable Adams should have given to IDEC on why he was not cooperating with SAPS before IDEC started and pursued the case? Because number one, in Advocate Johnson's statement, she said that the case or the report ended up coming to IDEC after Honorable Adams opened 4 cases. The police tried to contact him. He didn't respond. He came and he lodged a complaint with IDEC saying that the cases were missing, etc. So given hindsight, do you think that this is something that IDEC should have pursued? Are you familiar now that everything has happened? We're talking about hindsight, how IDEC should have handled the complaint.
I don't think it would have precluded IDAC from continuing with the matter because it falls within its mandate. But it would have been good to know why he was not cooperating with the police. I agree.
And have you asked them yet? Because we couldn't get a clear answer.
No, I haven't. I wasn't even aware of that.
Advocate, there's a lot of things you're not aware of. It feels like we are sitting with Lieutenant General Sabia, who was not sure of a lot of things. Let's talk about Lieutenant General Khumalo. When he was arrested, he was banned from going to his office. And Advocate Johnson said that it was because he was going to interfere, or there was a possibility that he would interfere with witnesses who were at the headquarters. Is that not bizarre? Because I don't even see your best prosecutors, when they're dealing with accused child rapists, asking a magistrate to say the bail condition, this accused child rapist must not go to the community where their child is. But it was done in this case. Why wasn't Lieutenant Khumalo not just asked to not interfere with witnesses?
I don't know what the circumstances of this case are, as I explained, and what fears or concerns the IDAC had about the head of an entity being able to influence or interfere with investigations with regard to his subordinates. So given the circumstances of this case, it doesn't appear to be that it was an unusual request, because it appears that whatever took place in crime intelligence, and this is the head. So a lot of the evidence will be in that office.
But so I'm using it in the same sense of, you don't do that. We have child rapists, family members. You don't get prosecutors doing that and saying that, and you're doing it in a labor-related case. And he wasn't banned from work either, so that's another thing. He was just banned from headquarters, so it's not like he wasn't able to access whatever information. So what Advocate Johnson said was that he was going to interfere with witnesses, not about him accessing information.
That's my understanding. And with all due respect, we do object to bail in cases with regard to the type that you mentioned, where you have rapists, etc. We object, we do that all the time. And a number of them in those cases are in fact kept in custody, but there may be cases where they are released on bail.
A lot, Advocate, but we won't go into it. So on this case also, you don't know, on this issue about the bail condition and them banning him from his place of employment. You're not sure also about this and whether it was not reaching.
All I'm saying is that I don't have the facts upon which
Okay,
the
that's what I'm
IDAC
asking, okay.
decided.
So, Advocate, you don't think it's like you knew that you were coming here, you knew that your IDAC head was here, you didn't familiarize with yourself with things that actually is quite bothering.
With all due respect, Honourable Member, those are questions that the IDAC head must answer.
Yes, she did,
Because
and now we're asking
it
you
is
as her
within-
head.
It is within the realm of operations that she actually, the IDAC and the ID, deals with these matters. And she would be best placed to answer those questions because I don't have the facts. And so instead of me familiarizing myself with facts, she would be first-hand knowledge
but
to
that's
give
not-
you the facts.
I agree with that, and she's been here. I'm asking you as her head, after this whole thing has exploded and it's all over, you haven't called her and sat her down and gone through this and see like what has happened, even up to now.
With all due respect, Honourable Member, we've been preparing for this, and there hasn't been much time between her testimony and now.
But even
for us.
before she came and gave her testimony, these things have been in the media for a long time. So even before she came to give her testimony, I think as our National Director of Public Prosecutors, you should have long sat down and got information about this. I mean, we're talking about, and I'm not saying that Lieutenant General Kamalo must be above the law, but we certainly cannot just have our head of state security just being arrested without, of crime intelligence, I beg your pardon, without you having sat down and gone through it and crossed I's and dotted T's, because it makes us as South Africans feel extremely unsafe.
With all due respect, Honourable Mates, it is the national directors. I dealt with the powers of an ID and DPPs and what they do. The NDPP is a review mechanism, and therefore the decisions to prosecute, the management of cases, the objections to bail are all operational issues that are dealt with by a DPP or an ID and the teams, not by the NDPP. And these issues have now come up in the context of this, this hearing. But those are issues that reside solely, you know, they're operational issues. And it's, the National Director needs to, of course, be briefed at a high level. But the operational matters are for the teams and the DPP to deal with. That is their power and responsibility. But of course, if they do something wrong, then you're right, the National Director must get involved and understand what is going on.
So how would you know if they did anything wrong if you, after you see all this and you don't call them and you don't get a briefing?
Well, if there are complaints about it, is one way of understanding that things have gone wrong. But otherwise, we must respect the authority that the Act gives to people to do their jobs.
But the issue is not saying that you must interfere. As you said, there's nothing wrong with saying, come and give me a brief on what happened here. You don't have to give instructions, but to understand and to be able to guide. And those are two very different things. And it is within your mandate to be able to make sure that our national prosecuting agency is working and operating as highly functional as possible. Let's move on to the case of
If I can just comment on that. I think it's important that to understand that I do receive reports, and it's important, especially when there are high-profile people involved, that the NDPP is properly briefed and understands, and we don't have rogue elements in the NPA doing what they want to do. So there is that level of supervision of a national director that is critical in these cases. And so I got the briefing from Advocate Johnson, but reasons why they objected to bail, they will understand from the circumstances of this particular matter.
You've indicated that you got intelligence from Lieutenant General Kamalo about the corrupt or alleged corrupt prosecutor. Was this the first time that you received intelligence from SAPS regarding prosecutors, including from the National Commissioner?
To my knowledge, yes, but I think this is the first time.
What was the minister's response? What was the minister's response when you told her about the intelligence report that you got from SAPS about?
She was very concerned about it.
Okay. And the president, when you met with him?
He was also concerned about it.
And what was besides him being concerned, he's always concerned and shocked. We know that as a country. What guidance did he give in the matter? What guidance did the president give in the matter?
Well, I had reported it to him, and it was now for the president to take it further. There was nothing further I could do about it.
Brian Pariachi, Advocate Johnson said that he was in his position before she got into office. Do you know anything about his appointment? Apparently he was headhunted to join.
Yeah, he was
IDEC.
appointed when Advocate Cronje was the ID.
He was appointed when who, sorry?
The previous ID, Advocate Cronje.
Oh, okay. So do you know anything about, were you part of the appointment? Did you know anything about it?
No, I wasn't.
You weren't briefed or anything about it?
I wasn't.
You wrote to the president, I think this point has been, or this question has been asked a few times about Advocate Chakwe. I just wanted to know whether he was involved in any bail matters concerning Mr. Molefe. Do you know, or can you check?
I'm not aware.
Will you be able to check and come back to us?
I can check. I would be surprised if he would personally do a bail application. It's unlikely, but I don't know. As the DPP, he has a role to play.
But you will be able to see if there's a pattern, if it's the same, because these are things I would have thought should have been done by now, given how these matters have been circulated so much. And then, well, I guess the same applies to Makhlala as well, if you can also just find out if there's a pattern, because a lot of his cases were also withdrawn. So just to see if
We've looked into that, and I have a list of all the cases that were withdrawn. We are calling for the dockets. The police have sent some dockets. They're looking for others. And we are checking to see whether there's a pattern, who was involved, what were the reasons for the withdrawals, etc.
Okay.
So that work is underway.
Okay, so are we able to be furnished with that? I would have thought our evidence leaders would have asked those questions as well.
Sorry, I didn't hear the last part.
I'm saying, are we able to get a copy of that, of all the cases
I don't
that
see-
were withdrawn regarding?
I don't see why not.
Okay, thank you. And I'm done. Oh, no, I'm not done. Let's also just go back quickly to, we were talking largely about corruption cases, particularly around politicians or politicians that are well connected. So let's talk about the PPE cases and the CR17 cases, NPA on that.
The question is?
On PPA cases, PPE, sorry, I'm saying PPA, PPE cases, how many of those have been prosecuted, successfully prosecuted? Because it's talking about corruption during COVID.
I don't have the figures, but I know that the Fusion Center at the time was coordinating the response to PPE-related corruption matters. But we can get those figures very easily.
Okay, and then the CR17?
What about it?
The money, we had bank statements that were sealed. Did the NPA play any role in that?
No.
It just went straight to a judge and they sealed. There
We had
was
no role
nothing.
in that.
There's never been a case that has been opened regarding the CR17
We had no role in that.
at all. Thank you. Thank you, Chair.
Can I check, honorable members, if you want to ask follow-up questions? Honorable Nomvalo, Honorable Shongwe, the list, okay, Honorable Skosana, the list is closed.
No, thank you, Chair. Chair, I just want to raise my discontent on the observation that I've made. I think we're having a stagnant interview with the NDPP because earlier when I was speaking to her, I had put to her the powers that she has to supervise IDEC and the DPPs. Ultimately, we agreed and she undertook to improve in future. That is where we left it. Now, when Honorable Mateus asked her about what she did after she learned about what happened in IDEC, she says she goes back to the same position that she was in to say, no, that is an IDEC issue. I can't intervene. You must let people do their work. So really, I'm very disappointed because I thought we were getting somewhere with the NDPP. Now, the question is, NDPP, is IDEC an entity falling under the NPA?
Yes,
Do you have a responsibility to supervise it?
I do, within the context of the law.
How often do they submit reports to you?
I get monthly reports from the IDAC.
You get monthly report. Do you agree with me if I say, notwithstanding monthly reports that they submit to you, you also have a statutory responsibility to summon any report regarding any prosecution and any case that you deem necessary at that time? The statutes, the NPA Act gives you that power.
You're correct.
Thank you very much, Chair.
Honorable Shongwe.
Thank you, Chair. Chair, I want to ask about this regarding the matter of this funding. You see, Chair, it is known that throughout the world, intelligence agencies usually channel funds through this organization. They never fund an individual or government directly. They fund through these agencies. The crux of the matter is that this foundation channels funds on behalf of chairmen which are hostile on our system. So I beg to understand, accepting such fund, where is it helping us? And if I may ask, is this German fund that you guys are talking about, did they fund the CR17 campaign? And just one last question, why is Maumela not arrested, even Namanj? Thank you, Chair.
On the first question, I explained when I was asked about the very bespoke training that we are putting together, where modules have been developed for prosecutors to really strengthen their ability to prosecute complex corruption cases. So this is helping us in that regard, and it's also about sharing and learning best practices from other parts of the world, so that we can also improve by taking on some of those practices. On the CR17 campaign, I don't know. I don't have that information. And on Maumela, once the police have investigated that matter properly, I don't know at what stage of the investigation it is. I have no information about it. But no doubt the prosecutors are working with the police and on this big matter. And when the evidence meets the standard, I'm sure they will do what is required of them.
Honorable Skosana.
Thank you, Chair. Advocate, I'm disappointed as well, like my other colleague. It's not personal. that
I don't take it personally.
that you don't want to take accountability for anything. The issue of IDEC, that it falls under you. When IDEC fails, it means you have failed. Am I right?
You're right.
Now, the issue of funding, I wanted to make that follow up. Because we've seen in this country, I'll give you this small background for a second, that there's an organization in this country called civil society called themselves different foundation, Helen Suzman, there was Brent Hest, I think is disbanded. You have your one apartheid judge, Judge Krichler, running a so-called corruption watch, and others, you know, who are being funded. Now, if NPA, besides the issue of Steinhoff, because I think NPA explained about that, the money went to DPCI, you know, that 80 million of Steinhoff. And I'm not sure whether we were told the truth there as well. But be that as it may, are you not worried? And if I may ask, perhaps for us to be quick on this one, how much have you received, or NPA have received so far in terms of funding? And which organization, in terms of names, who funded, if there's any, who has funded NPA?
NPA does not receive any funding at all. I want to be very clear about that. NPA does not receive any money, but we receive services. And these are disclosed in our annual report. We're very transparent about this.
Yeah, but let me say this to you. Service, there's value on service. There's nothing for free. I mean, a person might want favors, like what Judge Mkhweng, the former Chief Justice, said, that there's no free lunch. And I'm saying, I can say I'm volunteering, but volunteering, at the end of the day, there's value for money in that. You know, you might not quantify it now and say X amount of money, you know, these people have spent so much. Steinhoff was very clear that we are putting 30 million rand for you to give Price Waterhouse for forensic investigation. But with you, what we are saying now, I'm not disputing that, but I'm saying, in the high side, don't you think that indeed as well, the state must be able to cater for its own citizens? Citizens are paying tax in this country. You know, I know funding, because remember, advocate, that one day you'll be funded by drug dealers. They say, no, we are offering a service. We're not giving you money. We'll send X, you know, we've got a professional, we've got advocate so-and-so, we've got a professor so-and-so, we've got doctor so-and-so. They want to come and help NPA. But those people who have been seconded to you have been funded by drug cartels. Thank you, Chair.
Chair, I should say that we are not oblivious to the fact that we must make sure that there are safeguards to ensure that there's no such thing as any form of capture. The NPA must do its job without fear, favor, or prejudice. And we have always, you know, disclosed our donations or whether you're right, it does have a monetary value to it. But we do not receive funding, and we are transparent about any support and assistance that we get from external partners. And I do want to emphasize, you know, we are required, we have to have safeguards to ensure that we are not beholden to anyone, even to people that assist us with funding. And therefore, we've put in place safeguards to ensure that. And in a financially and fiscally constrained environment, we need to ensure that we have all the skills, capacities, and we try to be innovative about how we do it so that we can deliver to the people of this country. And your last point, I agree with you 200%. The state must be able to fund and pay for all our services. And if we don't have the levels of corruption in this country where people are stealing blind from the people of this country, we shouldn't have to go to anybody for any support.
Honorable Malema.
No, thanks, Chair. I was not going to ask any question, but I've got a big problem where you earlier said you don't need money, you are sorted, maybe in the future years you'll need money, and then you go and take money in kind from the Germans. That is a huge contradiction. Because if there was a need for any kind of training to be provided by NPA, you would have budgeted for that to avoid getting money from foundations that you have not even vetted. It must be, and the most embarrassing thing, I don't know why you're doing this to us. Maybe I was saying to one of my colleagues here, you are really answering like a person who's going on retirement. It's like you don't care. You don't care what happens. How do you come here and you say you don't know who gave you 50-something million? You have not researched them? What if these people are chaired by Ket Matlala? And you are going to hear it for the first time sitting here, that you are actually receiving money in kind that goes through a foundation that is chaired by Pet Matlala. And then you say, I don't know. I don't know that. For an institution like NPA, you ought to take very serious who becomes your partner, both in monetary terms and even in kind. We were sitting here, we had evidence of Matlala being solicited to finance a presidential campaign of one of the ministers. And therefore, it can't be far that NPA can also be captured by the same people. So I'm really saying, Advocate, you have done a disservice to us. You tell us you don't need money. You are rocking. You are cruising nicely. You can try next year. Maybe other years. This year we're fine. Then you come, you say you're taking donations in kind from the Germans. And you keep on saying to us, we're not receiving any funding, as if we don't know the difference between donation in kinds and donation in money. It doesn't matter whatever form it takes. It has got monetary value, and you have accepted it after you said to us, you don't need money. To an extent that Advocate Bredenbach said, oh, we shouldn't fight for you in the Justice Department for more money. Because it should be something that we pride ourselves with, that we don't take money from foreign countries for the sake of our own sovereignty as a state, especially an institution like NPA. The last point I want to make again, Advocate, you say, we ask you about Maumel. It's such a huge case. Actually, we must be embarrassed that cars are taken, houses are paraded and all of that. There's no criminal case. And then we ask you, when are you coming for Maumel? You say, when police are ready. That is a pure, completely pure than white corruption case of a hospital called Tembisa. Why should we be told about police when IDEC deals with those matters? It is IDEC that should have actually even developed an interest on its own that this is too huge to be left. These are the kind of cases we want. As a head of NPA that IDEC falls under, surely you should have developed an interest and said to IDEC, 680 million gone to skinny jeans, a hospital ordering skinny jeans, and a head of NPA, it doesn't matter, head of IDEC. You are the corruption buster yourself because all of them fall under you. You should be able to say, come here. What happened with this case of people buying patients' skinny jeans? Because when we go to hospitals, we normally get those gowns which are open at the back. What does a patient do with a skinny jean? That should have been an issue of interest for a corruption buster. We asking you, what are we doing up? We say, no, when police are ready, when it's ripe, then it will come to us and all of that. That's not a matter to be left to police. That's a typical example of cases that IDEC should be dealing with, not human resource. We have a case here that a CV does not have an address or something like that. It's a criminal case. But here is a case of 680 million, close to 1 billion, only that which we can account for now. And worse, through this body, not Asset Forfeiture Unit, the one of Kaiser Khanyawa and them, SIU. We hear from SIU that we are now sitting at almost 680 million. That's what SIU can uncover. Imagine if IDEC is there, crime intelligence is there, we're going to get more than $1 billion of one individual involved in corruption. The head of NPA says, well, we don't know, we'll wait for the police. That's so disappointing to tell the truth. Thanks.
If I can deal with that, there are two parts. Firstly, on the German funding, just to say that this project was a long time coming. It's not like we initiated it now. It's probably taken about 3 to 4 years to come to fruition. So it started at a time when we really needed the funding. So, you know, it took about 3 or 4 years before that came to fruition. It's not a new thing. So on the issue of IDAC, I agree with you that these are the kinds of cases that IDAC should be doing. IDAC has got limited resources at the moment. They are barely able to deal with the cases that they want. And I think this is the role of this committee, would be to strengthen IDAC, to give them the resources and all of the capacities, capabilities that they need. Because I agree with you completely. This is the kind of case that IDAC should be investigating. Thank you.
So can you please withdraw your earlier statement that you don't need funding? You are sorted because now you just confirmed you need funding. IDEC is funded through you. You
I
need
withdraw
money.
that
And
statement.
please withdraw the earlier statement that you don't need money.
I do withdraw that statement.
Thank you.
Thank you so much, honorable members. We have come to the end of this session. We are going to do welcome, Chief Whip, the Night Rider. We are going to break. And I want to bring it to your attention that I have made the following observation. When we come back to the sessions after this break, you come back highly energized. And sometimes it delays us unnecessarily. I'm just saying to you that if there is anything that makes you to take, just reduce it. Tomorrow you still have the medium-term budget policy statement. So let's reduce on whatever we are taking during this break, so that it makes the next session easier for us to write through. We will come back at 20 minutes past 7. Thank you so much. Good evening and welcome back. Let me check how many speakers are left. How many speakers from the ANC? 1. How many speakers from the MKP? How many speakers are left on your part? 1. You are sharing 15 minutes, or 20 minutes, 10 minutes? 25, 5. Okay. Bangazita, 1. PA, 1. Action SA, 1. And then DA, done. Okay. So we are left with 6 speakers. 1, 2, 3, 4, 5. 5 speakers. It's 30 minutes, 30 minutes, 30 minutes by 4 plus 10 minutes. So we should be done in 2 hours, 10 minutes. But before we do that, I want to allow the NDPP to say a matter that she raised with me during the break.
Thank you, Chair. I appreciate this opportunity. I do understand that the committee has decided that there will be a closed session during which I should disclose the name of the person to the committee. I thought that I should bring it to the attention of the committee to please reconsider this issue. It is not an issue we've been confronted with before. It involves an active investigation where the person of interest is not even aware of it. Disclosing the person's name under any circumstances would compromise investigations, and not just relating to this person, but to other potential implicated persons. And Chair, I simply urge the committee to reconsider this matter, as it is an important issue and it is going to be extremely difficult in the circumstances of this matter. Thank you, Chair.
Thank you. I think, honorable members, you have had the presentation of the NDPP, and I know that those of you who are full members in this committee, I would have shared it with you before she comes to present it, so that it does not take you by surprise. Can I check with yourselves what is your view on the matter that she is presenting the African National Congress?
Thank you very much, Chairperson. Chairperson, I think based on the reasons that the advocate has advanced, I think we accept the request. We are willing to stand down on the matter, but and only because it's an active investigation that may be compromised. Maybe just to make the point that we trust that witnesses who come after her will be very clear that we do expect full disclosure in the committee. But we are willing to reconsider, Chair. Thank you.
The MKP?
Yeah, no, Chair, we hear the reasons, and we actually do not have a problem. But what we can say is that the investigation itself should not be very long, to a point where we even forget about this subject. In due course, we must be given the name. We are not losing interest in getting the name. We still want the name, but we are just respecting the fact that it cannot be revealed at this stage, because of its sensitivity. So we understand that. And that, Chair, we advise that in future, if there are certain names, we're advising the senior counsel now, that if there are witnesses who come here and say that there are names that they can't reveal before this committee, at least you must be told in advance, so that at their level, they will reach an agreement, so that even our senior counsel can have ownership and persuade us not to take the matter further, because he is here to also guide us in terms of how we must conduct things which are legally related. Yeah, but in conclusion, we don't have an issue, Chair. We don't have a problem.
The DA.
Thank you, Chair. We agree with the previous speakers. It's not a point we're going to press.
The EFF.
We agree.
The IFP.
No, we agree, Honorable Chairperson, and just hope that we are not actually creating a precedent with the other witnesses that will still be coming.
Okay. The PA.
Advocate, we believe you, and we trust that indeed this is a matter of protecting national security. So by putting South Africans first, Chair, we agree that we will step back. Thank you.
The Action SA.
Chair, Advocate, I know Action SA holds no voting powers when it comes to this decision, but the Advocate hasn't said anything differently in comparison to what she told us earlier on and with all other cases. So I'm not sure what has changed from her response this morning to her response now. And we also know that when people are embroiled in and they have cases against them and allegations, we know that it's not just that sole person.
On a
We
point
know
of
that
order,
there are
Chair.
more people involved.
On a
So
point
I'm
of
just
order.
saying, let me speak, finish.
Chair, on a point of order.
You can't
Let's,
interject like that. Let me just finish.
Chair,
let's
on a
take-
point
I'm
of
just
order.
sharing my view.
Let's take the... No,
Chair.
no.
I think
Honorable
I've shared, I've said what I
Honorable
wanted to
James.
say. There's
No,
nothing different.
Honorable
Chair,
James.
on a point of order.
Honorable James, look at
Yes,
me.
Chair.
Look at me. There is a point of order that has been called. And I want to allow the speaker so that we take the point of order. Thank you so much.
Chair, we are now in a process of taking a decision, an equivalent of voting. And that should be a subject of permanent members of this committee. So you can't subject us to that which you are subjecting us to. We are saying as permanent members, this is our moving. She has got no voting powers on this matter. But there must be a level. At some point, people must feel or they are not permanent members. You can't be enjoying the same privileges as permanent members.
Permanent or not permanent, I'm a
No, no.
citizen of this country and
Honorable-
I will speak my mind and I will
Honorable
share my
James.
view.
But Parliament doesn't.
Oh,
Parliament doesn't work about who's a citizen, who's
I
not
will
a
share my
citizen.
view, I will
This
speak
is-
on behalf of
No,
South
land
Africa.
Parliament. Land
Honorable
Not be
Parliament.
silenced.
It doesn't work
Honorable
about
James
who's a
and
citizen, who's not a citizen.
Honorable James
Land
and
Parliament.
Honorable Malem.
Land its
I am
rules.
Honorable
I'm a
James and
citizen.
Honorable Malem.
And I will
Who's a
speak.
sub-citizen?
You will not silence
whoa,
me.
all citizens. Who's a sub-citizen?
Honorable James, Honorable Malema.
Become a
Honorable
full-time
Malema.
member.
What kind of
Honorable
Winnie
James.
Mandela situation
Be a
here?
full-time
You will not
member.
tell me
Honorable
when to speak.
Malema, Honorable James.
She's not a full-time member.
Doesn't
It's
matter,
not
I'm
my
a
problem.
citizen and I have the interest of South
Honorable
Africans
James.
at heart.
She's not a
Honorable
full-time member.
Malema.
Doesn't matter.
And Honorable James.
She must go and get the numbers to become a
must also
full-time
go
member,
somewhere.
Chair.
Go and
Honorable
find Winnie
Malema
Mandela.
and Honorable James. Honorable members, you know, I warned you before we went for break. I warned you. It's like I anticipated as a belief. You know, Honorable Malema, matlong a motho a sa gampia bana. I don't know when chambo to be now. Re bana ba modimo ka moka wa tsa. Honorable James, may you please conclude your point.
I've concluded. Thank you, Chair.
Thank you so much. Yeah. Honorable members, I just want to indicate that we had to give Honorable James a chance to speak, and all of you are aware it's a matter which we debated when we started the work of the committee, when the terms of reference were concluded, that for the purpose of decision making, the inputs of the full members, the 11 full members of the committee, are the ones that count. But because all of us are acting in the name of the Parliament of the Republic, we usually allow these members to express their views. And so let's continue to uphold this practice. It's unfortunate that it went the way it did, but I know these sessions, which I was made to believe are graveyard sessions, have not been graveyard sessions with this ad hoc committee. So the committee has reconsidered, or let me say it in a way that you will understand NDPP. The committee has reviewed and set aside its decision. But what Honorable Nomvalo is emphasizing is that the trust that the committee places on the statement that you have made must not be betrayed. That is, or you say, my emphasis. Yeah.
Thank you, Chair. That's understood and very much appreciated.
Thank you so much. Honorable Ngola and Honorable Sols.
Thanks, Chair. No, I wanted to say on behalf of Honorable Vessels, we also agree. Thank you.
Honorable Sols, what is happening this side where you go during breaks?
Chair, you are insinuating something that I'm not understanding, I'm not following.
Okay.
What are you insinuating?
Let's proceed.
Where do I go during break? Which side?
Let's proceed, Honorable Sols.
Chair, just so that there is no misunderstanding about the reasons given, I just want to be clear that what we've been discussing outside of the committee session and the explanation given was different than that what was said earlier, to say that the person involved does not know that he is being investigated. As such, if his name is revealed, it jeopardizes that, because when he finds out and then others connected, it affects the investigation.
Yeah.
So it was not a concoction of, it was really intentional, and we do not want to jeopardize national security. So we taking the advocate in our confidence, we believe what she's saying under oath, and it's for that reason that we go in that direction. Thanks, Chair.
You heard it, Advocate.
I did, Chair, very clearly. Thank you.
Thank you so much. The next speakers will then be Honorable Bangazita, Honorable Sols, and Honorable James. Your time is starting now. It's 19:42. At 20:42, your time ends, and the 10 minutes for Honorable James will last until 20:52. Bangazita.
Well, thank you, Honorable Chairperson. Good evening, Advocate Batohi. I was looking at your statement, your press statement, which you issued on the 5th of June, and where you were actually expressing a very grave concern about the possibility of the NPA being infiltrated. to me, that tallies well with the assertion that Lieutenant General Mkhwanazi actually expressed also during his press briefing. Now, I'm interested to know what steps you have actually taken to deal with this concern. In fact, you even said that you do not sleep comfortably at night because of this. What steps have you taken to deal with this matter?
Thank you, Honorable Bangazita, for that. As I explained earlier, I immediately upon receiving the information contacted the minister and advised her that I had needed to meet with her urgently. We then met the same week, and I briefed her about it. I also briefed the president about it sometime after that, when he was available, and expressed my concerns about it. And that was about as far as I could take it, because this was intelligence that I received. But internally, as I mentioned, I went on visits to prosecutors across the country, firstly commending them for the incredible work that they're doing, because I can only imagine that I'm hoping that it's not a large group of prosecutors, and urging them to still make sure that they do what they are mandated to do in terms of the Constitution. And that I even said to them, we are citizens of this country. We have a right to vote. But like family members, when you have a case to decide upon, you decide on the evidence and nothing else. And so it was, those are the steps that I took. But there's nothing further that I could have done in these circumstances.
Well, thank you, Advocate. But also, arising from your response, it actually immediately draws my attention to what you told us earlier, that you are actually getting some in-kind type of support or donation from a foreign organization. Is that not actually also opening a slight opportunity for infiltration to happen under the guise of supporting your good cause as NPA?
As I explained earlier, Honourable Member, firstly, the support, in-kind support, is not from a foreign organization. It's from a foreign government. And we have ensured that the support we get is controlled by the NPA. We decide on the kind of support that we need. We have sat down and developed modules for training. So it's completely in the control of the NPA. So there's no possibility of this kind of influence, improper influence, being exerted by any organization or entity because of the fact that this matter is completely controlled by the NPA.
Well, thank you. Advocate, I'm not sure whether you also do the vetting of your employees and also do lifestyle audit for all your employees at various levels to actually, one, guard against the infiltration and also to be vigilant against issues, possibility of corruption.
Thank you. Those are really important questions. Of course, vetting is done by the SSA, and as far as the NPA is concerned, we are fully compliant in terms of all the requirements that need to be submitted to SSA for vetting. And as far as the lifestyle audits are concerned, the President announced lifestyle audits for public servants. That is a very, very welcome development. I agree, there needs to be lifestyle audits for NPA staff at all levels, starting with the National Director. And it is something that we've engaged with a number of institutions like the SIU, the Public Service, to look at what they're doing and what we could introduce in the NPA. We are in the process of developing policies around this because you need to have a framework to deal with this. I do want to add, though, it is a very expensive exercise. It doesn't mean we won't do it, but I'm just alerting the committee to the fact that there will be a need for an increase in funding to deal with this. But internally, I have spoken to, we've been discussing the issue and how we do it. I think moving forward, after we do certain categories of maybe high-risk persons, that we start off with certain categories, and then later, as a matter of policy, the NPA you should have like a random selection of people that are, so you don't have to do everyone every year, but there must be a process whereby Shamila Batohi can be selected for lifestyle audit this month. Next month, it's somebody else. So there's constantly, you don't know when your name will come up, but it could save costs and certainly make people vigilant that there is this process. So we are looking at various options to ensure that the NPA is, in fact, doing what it should be and is above reproach.
Thank you. I would refer you to your statement, especially paragraph 71, where you gave a figure of 58. What is that? Complaints of allegations of corruption. I was wondering if you could actually give a provincial breakdown of that figure so that we have some kind of a view of where the problem could actually be.
That is certainly possible. I don't have it with me now, but we can certainly provide that information.
Okay, thank you. You will agree with me that of late the NPA has taken a lot of, should I say, criticism from South Africans, especially for moving with a snail's pace insofar as the prosecution of cases emanating, in particular, from the Zondo Commission recommendations. And your defense has always been that, you have the issue of resources, the budget. You also we are busy with the institutional transformation. Can you share with us your experiences and the impediments that stands in your way that could be actually attributed to the delay in the finalization of your institutional transformation?
Thank you. I think we've gone a long way in terms of institutional transformation. There have been many initiatives that we have undertaken to enhance the institutional reform within the NPA. And the challenges with regard to addressing particularly complex corruption matters is something that we must understand, that we are coming from a time when institutions were deliberately weakened and we didn't have the capacities to deal with these challenges of investigating complex corruption matters. And the Zondo Commission sadly did not give us a blueprint for prosecutions. The standard of proof, as I said, in the Zondo Commission is very different to a criminal standard. And so in order to ensure that we met the criminal standard for prosecutions, we have, in the past 4 years, and that is post-COVID, and also understanding, as I explained earlier on, the IDAC only became permanent in August last year, when we were really able to have a proper structure to identify the necessary capacities, capabilities, disciplines, and to start recruiting in order to ensure that these cases can actually be dealt with very, very quickly. So it's really important to understand that these challenges with regard to skills, capacity, etc., we are only able to really start dealing with them after the IDAC became permanent. Prior to that, we are dealing with trying to address these matters in a broader system that is not functioning optimally, where we do not have the skills, capabilities, capacities to deal with these matters. So I think it's important to understand that in the past year, and to be frank, the fact that the IDAC has, notwithstanding these serious constraints, has enrolled over 50 cases, has over 300 entities and individuals before courts already, some of them very high-profile persons, and as I mentioned earlier, some of the key Gupta lieutenants are in state capture already, implicated allegedly in state capture, are before courts. So there's a number of these matters, and I dealt with it when Honorable Breitenbach raised these, the fact that it hasn't moved through the system, the court system, quickly enough. So the country says we don't have people in orange overalls or convictions. The fact that there's over 300 entities and individuals in court, and it's not moving through to the system for us to have finalization, means we have to look at the institutional challenges within the court system that hamper our ability to deal with these matters efficiently. I do want to state and emphasize again that we have, with regard to the Zondo, the 51 cases that are before court at the moment, they are dealing with 127 recommendations from the Zondo Commission. And I also want to make the point about asset recovery. Asset recovery is a very important aspect of accountability. There's two parts. One is prosecutions and convictions, justice, finalization, maybe imprisonment or whatever the consequences are. And the other aspect of the strategy is bringing back the stolen money. And the asset forfeiture, we've had a deliberate, intentional strategy to actually proceed in terms of Chapter 6 of the Prevention of Organized Crime Act, which is not dependent on a conviction, because we realized how the tactics to delay cases moving through the system can hamper our ability to bring back money. Chapter 6 is not, I don't want to go into too much of technical detail, but it's not dependent on a conviction. And that has resulted in us bringing close to 50% of all recoveries in the past 25 years have been brought in the past 4 years. And that demonstrates our focus on asset recovery as part of the strategy to deal with corruption. I think the other issue that we really need to deal with in terms of trying to deal with corruption is the issue of protection of whistleblowers, which I mentioned earlier. It's a very, very important aspect in terms of trying to address corruption.
Well, thank you. Well, I know that the issue around the arrest of Lieutenant General Khumalo has actually discussed quite extensively, but I can't resist the temptation of wanting to find out from you that Lieutenant General Khumalo, as we all know, is National Head of Crime Intelligence. and in this instance, together with his entire team, is arrested. And that actually is a blow to the national management of the country's crime intelligence. Now, did it occur to you that the national security might be actually compromised by the arrest of this top management of our crime intelligence?
In terms of how the ID assessed it, I think in their view they saw a greater threat to national security with the situation that was unfolding in terms of their case theory with regard to the recruitment of people for specific reasons. And so the IDAC, the ID, has explained that this was part of a much larger case strategy, that this is one of several other matters. And so in their assessment, this was in fact in itself a risk to national security, so they needed to proceed on this matter.
Surely this is a crisis situation for the country. I would have expected that this development would be actually taken to the higher or even the highest echelons of the leadership of the country. Did you inform the president of the country about the impending arrest of the top criminal, the crime
No.
intelligence people?
I did not
Was the
inform.
president informed about it?
I did not inform the president of this.
I beg.
I did not inform the president.
Is there any particular reason? Because I would expect that the president would need to be actually put in the loop about these developments.
I think with hindsight, you're right. The president should have been informed of this.
Advocate Johnson, who is the leader of IDAC, in my view, also committed the same offense as Lieutenant General Kumar, by actually presiding over the process to employ her husband. What have you done to deal with this? I know that is 20 years ago, but wrong is wrong, now or 100 years ago. That is why the Nuremberg trials are still taking place, 70 years after the World War, or even
And that
more
is
than
why we are still prosecuting people for TRC-related cases 30, 40 years after the commission of these many offenses. So I agree with you. But the circumstances are very different. And one has to look at the context of this matter. In my view, Advocate Johnson made an error of judgment at the time. And the circumstances are extremely so far apart that it cannot be compared. You've got to compare apples with apples. In this case, we're not comparing apples with apples. She didn't do anything close to what is alleged in this case. Excuse me.
Your Honourable Advocate, when Lieutenant Mkhwanazi was here, he told us that actually Lieutenant General Khumalo did not employ the person in question. He merely presided over a panel that was actually interviewing, but the actual appointment was done by another panel, which has not been arrested. Could there be any reason why they have not been arrested if employing that particular individual was a crime?
Honourable Member, with all due respect, when one looks at one simple fact, it may not appear to be amounting to a criminal act. But in order to decide whether a crime has been committed or not, one has to look at all of the evidence before the investigators. And so this is one allegation, but it's not all the evidence. Clearly, all the evidence would have justified such action in the circumstances, and we have to consider all of the evidence. I want to really emphasize that.
Well, then we were deprived of that information because the issue that kept on coming up here was the issue that Lieutenant General Kumal presided over the employment of a particular individual, which was a major charge. Okay, but I'm no longer there.
If I could respond to that, Honourable
yeah,
Chair,
okay.
through you. I again emphasize the fact that there is a review process available. And I would urge that if anyone is aggrieved by this decision, that they invoke the review process so that the matter can be considered by the National Director.
I'm not sure whether you are aware, Advocate, of a bad relationship between Advocate Johnson's husband and that of Lieutenant General Kumal. And we learned that Mr. Johnson actually works under the supervision of Lieutenant General Kumal.
I'm not aware of a bad relationship, and I do believe, I think Advocate Johnson was asked about this question, but I want to emphasize again that if there's an insinuation that the reason for this case is that bad relationship, that is not the case, because as I explained earlier, this case came to the attention of the IDAC through a Section 27 referral. Had that referral not been made, this case would never have seen its day in court. So I think it's very important to understand the circumstances under which the IDAC became seized with this matter.
Lieutenant General Mkhwanazi actually strongly believes that the arrest of Lieutenant General Kumalo and his team is actually motivated by none other than the work that they are doing in actually investigating and arresting the drug and criminal, syndicates in Johannesburg. What would you say to that?
There's absolutely no way the IDAC would arrest people in order to subvert an investigation into organized criminality. I can lay my head on the block that the head of the ID, Advocate Johnson, will never allow or be in any way inclined to act in that manner at all. So I want to dispel that notion very strongly that that would have been a motivation for the arrests in this matter.
My last question, Honorable Chairperson, is just to find out how endemic is the problem of factionalism within the NPA, Advocate, if any.
I don't know how endemic it is, but with the leakages of information that we experience, I do believe that there are elements within the NPA that, as I said in my media briefing, not media briefing, in my interview, that may not be fully committed to the mandate, objectives of the vision, mission of the NPA. But how endemic it is, I don't know. But that's why I urge again there's an absolute zero tolerance to prosecutors who do not abide by our code of conduct. One thing we do not do in the NPA is we do not sweep things under the carpet. When there's an allegation, matters are fairly investigated, there is a process, and there will be consequences. So again, I urge members of the public, members of this House, if you have any information with regard to prosecutors that are not acting as they should, please send it to us.
Do you still have questions, Bangazita? Yes. If you have exhausted
the
your
last
questions, you
question.
must just say.
Well, Advocate, my concern is actually around the lack of communication, interaction, and actually sharing of ideas, sharing of information between and amongst all the units that are there in our criminal justice system. At one point when we were actually discussing issues with IDEC here, there was an incident which was reported whereby IDEC operatives or investigators actually demanded files or dockets which the other unit were actually busy investigating, to a point where IDEC had to subpoena those dockets, and they were hand-delivered by the National Commissioner after they had been subpoenaed. To me, that was a glaring, example of lack of communication, because why would IDEC, subpoena dockets when the police, another unit of the police, actually was busy investigating, doing some work on them?
Advocate Johnson dealt with this aspect in a lot of detail, my recollection is, and I don't have the detail of what, but my recollection is that she said she did communicate with the National Commissioner and various other heads in the police. And I want to, make the point that invoking a legal process where you communicate and then sometimes to protect a process, it is or the information, it's sometimes better to invoke a legal process, but not in the abstract. After you speak and communicate with colleagues and it's understood why the legal process needs to be invoked. So I think that's, in the circumstances, Advocate Johnson explained how it came to the Section 28 subpoena. But I want to say I agree with you, your point, that it's critical that as law enforcement we are engaging, we communicate, we share information, and we work together. The sad reality is, with what you are hearing in this committee and in the Madlanga Commission, you begin to wonder who do you trust and how do you share information? And that is maybe one of the reasons why investigative teams are becoming so guarded with regard to sharing of information, because one leak within a team is enough to destroy the entire case. So it is a challenge that we're facing, but I agree in principle there needs to be a lot more coordination and sharing. It's not like it's not happening, but it can be improved.
Thank you, Honorable Chairperson.
Thank you so much. Honorable members, allow me to take Honorable Souls. We will take follow-ups thereafter.
Thank you, Chair. Until what time? I think it's 2040.
It's up until 20:42.
Thank you, Chair. Good evening, Advocate. Honorable James, may I ask for you to just shift on the other side? I can't see, if you don't mind. Thank you so much.
Did she hear you, Honorable Sir?
Clearly, she did. So, Span Elder Chair, said I. Warmakar. Advocate, General Mkhwanazi testified that he ensured that there's criminal charges laid against Mr. Mdluli. And he testified and made an allegation that the NPA at the time, represented by Honorable Breitenbach, that's the only name he mentioned, and others, withdrew the case, the criminal case, against Mr. Mdluli, who was the then head of crime intelligence. Is this true?
I don't have personal knowledge of it because I wasn't in the country at the time either. So I don't know who withdrew the matter in court.
Section 22, I think, subsection C, 2C, gives you power to review matters such as this. Are you saying that you haven't looked into this matter?
This matter has a long history, and the Mr. Mdluli was subsequently charged. He is currently facing, I stand to be corrected, but he's currently facing various charges, commercial crimes, economic crimes, fraud is being one of them. And in respect of the other matter, so those charges are still being heard in court. With regard to the other matter, where he was charged with, where a decision was taken not to charge him with murder, he was instead charged with, I think, kidnapping, assault with intent to cause grievous bodily harm. I don't have the charges in front of me, but that's how those two matters are being dealt with.
Now, given your mandate, I understand that you have not looked into that matter, or you don't know much about the matter because at the time you weren't there. But given your mandate, the moment you heard the allegations against the NPA by General Mkhwanazi, that should have been enough reason for you to then delve in detail into this particular matter, because he was very specific about this particular allegation. Did you do so?
I couldn't in the circumstances because he is facing those charges.
Yes,
They've
but
been re-enrolled.
yes, but I'm saying, are you testifying that you are fully aware of the matter? Because I want to talk about it.
I am aware of the matter.
Okay,
Whether
great.
I'm fully aware, I'm not sure, but I am aware of the matter.
Okay, great. So, General Mkhwanazi only mentioned Honorable Breitenbach in his allegation. Who else was involved in allegedly withdrawing the fraud and corruption case against Mr. Mdluli?
I don't know for a fact, as I say, because I was not here, but my understanding is that it would have been potentially the head of the SCCU at the time. The matter was, I don't know, I can't speculate. I want to tell this committee things that I factually know, but it could have been, I think Advocate Chauke was involved. I don't know whether anybody else and who in that office would have been involved in that matter as well.
So, it would be Advocate Chauke, you correct, and Mr. Jiba. And I was wondering whether there's others that you do know too, but you don't, so we'll continue. So the Supreme Court disagreed with this group, with their decision in the NPA to withdraw criminal charges of fraud and corruption against the head of crime intelligence at the time. Does this fact that the court decided against the NPA decision, does it mean that the decision by the NPA to withdraw amounts to interference or defeating the ends of justice?
It could potentially amount to defeating the ends of justice.
Why potentially and not it does?
That's a good question.
You have a good answer?
I hope so. I'm thinking about this. I think it would amount to attempting to defeat the ends of justice.
Are you testifying that the NPA, with this decision, defeated the ends of justice?
I wouldn't say the NPA, but I would say individuals in the NPA.
I'm not sure you can separate because they acted within their capacity as officials of the NPA.
That is correct, but you cannot impute the conduct of one or two individuals to an entire organization of close to 5,000 employees. But individuals responsible must face consequences.
Those individuals in senior positions would then impact on the integrity of the NPA. It casts doubt on the integrity of the NPA, would you not say?
It certainly is an issue with regard to integrity of the people involved. But again, I emphasize you cannot impute the lack of integrity of a few individuals to an entire organization with people that of the highest standards of integrity. But the individuals concerned must certainly face consequences. There must be a fair process, and there must be consequences.
You see, Advocate, the allegations before us is that there are elements within the NPA that is involved in defeating the ends of justice. So that allegation would then seem to be true if you say that indeed this action amounts to defeating the ends of justice, and it is the NPA.
It is, I emphasize, individuals in the NPA that must face consequences. At the time when this happened, I was not in the country. I'm not saying, I want to make it clear that these things happened whilst I was abroad working, and now we are trying to deal with these matters so that there are consequences.
Okay, are you using your Section 22C mandate or power to review, to look into this matter again in detail, given the allegations made public? Because this happened since 2015. The court decided that the case should be reinstated. In 2015, the NPA decided to do so. It is 10 years later. 10 years. Is Mr. Mdluli, 10 years later, convicted and in jail for this criminal matter of fraud and corruption?
I do emphasize, I agree, it's 10 years later. And these were, these events took place during the state capture era. And we have been trying to remedy and recover from that in the past 6 years. As I said, the matter's been re-enrolled and is in court.
So your answer is no?
My answer is no, for those reasons.
Our research shows that Mr. Mduli was sentenced for 5 years in September 2020 for another crime, not this one that we're discussing. He was convicted and sentenced for 5 years for kidnapping and assault that he committed in 1999 when he was the station commissioner at Vosloorus. Is this true?
That is correct.
Does this mean that we had a criminal as the head of our crime intelligence at the time?
That is correct.
He served 2 years of his 5-year sentence. 2 years. He's now, as we speak, he's on parole. Was this because of political intervention?
I have no knowledge of that. The parole, NPA has got no role in the parole process. It's dealt with at correctional services.
When we look at your witness statement, Section D, page 21, paragraph 57 and 58. Are you there?
Sorry, the paragraph number?
57 and 58. Are you telling us as the committee that in order for us to understand the relationship between the NPA and the PKTT, we must go listen to the Madlanga Commission, to the testimony of Advocate Harrison, the DPP of KZN?
No, I'm not saying that. I simply set out the fact that she has led evidence there. But of course, if this committee wants to call her, that is the prerogative of this committee.
But you were informed, Advocate, that we want to know about the biggest allegation is that the relationship between the NPA and the PKTT has broken down. There's been major allegations. So we had to hear testimony from you around the details of that. Do you disagree with that allegation or not? You have an entire section entitled The Functioning of the Criminal Justice System Value Chain and the Role of the PGI. So when I saw the heading, I thought now what I'm going to see is you are going to now deal with the allegation that there is a breakdown in the criminal justice system value chain. And you were going to go into detail within the allegation. But then when I came to these two paragraphs, you are telling me, in order for me to get the details, you are not aware, you don't have direct involvement, so you can't talk to the detail. I must basically go and listen to the Madlanga Commission to get the details, because in your affidavit, you don't deal with it.
With all due respect, Honourable Member, that's not what I'm saying, that this committee should listen to what's happening, what has been testified in the Madlanga Commission. I cannot testify to that relationship because I've not had a relationship except for what I mentioned in my, when I was being led with the PKTT. And so this committee wants to get first-hand knowledge. It's important that you get it from the person that was in the NPA engaging with the PKTT. And I do want to say that to the extent that the committee wants to hear it, but in the Madlanga Commission, the DPP of KZN testified that they had a good relationship with the PKTT, pending some teething problems at the beginning. But she would be best placed to deal with that.
The approach should have been, based on my understanding, because you are testifying, that you would then have had this discussion with her, because you know that one of the things within our terms of reference is the very thing that we are discussing. That's the very reason why you have a section dedicated to it, but this section doesn't deal with the details. It gives us a high level, but it's fine. Let's attempt to go into it then. to deal with what I would have expected you to deal with. So you give a high-level explanation of PGI, but you're not testifying on the allegations that are made by General Mkhwanazi of the breakdown between the criminal justice system value chain. So do you believe, as the main witness has testified, that there is a breakdown in the criminal justice system value chain? Do you believe that or not?
Honourable Member, that's a very, very broad question. And there are some things that are working in the system and there are other things that are not. Specifically with regard to the PKTT, I don't know in what context the evidence was led that there is a breakdown of relations. So I can't comment on that unless I understand exactly what was said and what was meant. And then I can potentially comment on it.
Well, he was basically saying there was no communication between, based on the PGI model. There has to be this open-ended, this open, transparent communication, and you would know when arrests would happen, etc. So he was making the allegation that because there's a breakdown, this is why the IDEC, to protect, this is the allegation, to protect drug cartels in Gauteng, they then used that as a smokescreen to arrest, they used the arrest of General Khumalo as a smokescreen to protect the drug cartels in Gauteng. So do you see the depth of the allegation? Therefore, I expected you to go into detail in this section and then explain, do you agree, do you not agree, and why not? But we're talking about it now, so.
That is a very, very dangerous allegation to make, that a law enforcement agency that is mandated to deal with corruption and other related offenses would effect an arrest in order to protect drug cartels. As I answered earlier, I have no doubt that the IDAC and the ID would never, Advocate Johnson would never be motivated. She is a woman of integrity. She may have had errors of judgment in her youth. She's a woman of integrity, and I have no doubt that she would never effect an arrest like this in order to protect drug cartels. That is a dangerous allegation. And the Advocate Johnson said she was not even aware, if I recall her testimony. She had, that General Khumalo was part of the PKTT when they effected the arrest. They knew he was the head of crime intelligence, so she didn't even know about that link. So that is just a bizarre suggestion. And it would be good to understand from the person who made that allegation on what is the basis for that, and I would definitely want to understand that, so that if there's any chance that it might be true, I get that information and we can deal with it. But I have no doubt that that is an incorrect speculation or assumption that has been made.
So you disagree?
And the other point I want to make is that, yes, sorry, to answer you, I do disagree strongly. The other point I want to make is that the DPP in KZN, in fact, testified that there's a really very good working relationship with the PKTT. And that is where they were, in fact, the Political Killings Task Team, that is where their work, in fact, centered in KZN. And her testimony has been that there has been a very good relationship working with the PKTT in KZN.
And that is exactly the point. As I'm listening to you, you're saying, one, the IDEC head, Advocate Johnson, is a woman of integrity and she would never do something like that. You then testify that the head, the DPP in KZN, testified in the Madlanga Commission that they have a very good relationship. In other words, the DPP, KZN, knows that General Kumalo, which is now a central figure in the investigation that IDEC is undergoing, the DPP KZN knows that he is coordinating the PKTT because they are working together with the PKTT based on your testimony very well. Correct?
That's correct.
So, Section 24, subsection 2 of the NPA Act says that it's mandatory to have jurisdictionary consultation with the DPP when dealing with a case such as that IDEC has done. My understanding of that, are you aware of the section?
I am aware of the section, I just haven't opened it. My recollection is that, well, I should get the section open, that it is the DPP in the jurisdiction where the IDAC is going to enroll a matter that consultation needs to take place in. And in this case, it wouldn't have been KZN, it would have been the DPP in Gauteng.
Yes, but what it also speaks to is the consultative process because of the model of PGI, to say that if IDEC is thorough, what they would have done is look into who their core subject is, which is in this case General Kumalo. And one of the things they would have found out is that General Kumalo is coordinating PKTT, and to find out more about that part of the subject of investigation, they would then have consulted with the DPP. This, why I'm saying this, advocate, and you can help me, why I'm saying this, it's because it is shocking that this is provided for. If IDEC has done this, then Advocate Johnson would not have testified that the first time she heard that General Kumalo coordinated PKTT was on July 6th. If she followed the model of PGI and consulted with the DPP in KZN, she would have not been surprised on July 6th to find out that General Kumalo is the head of the PKTT. Do you think that it speaks of competence and it is okay in the scheme of things when you provide oversight that the head of IDEC, who's investigating a subject, only finds out when General Mkwanazi makes an announcement on the 6th of July that the same person they are investigating is the head of the PKTT?
Thank you. I want to be clear that Section 24, it is a requirement of the IDAC when you are enrolling a matter to consult with the DPP in the jurisdiction where the matter is being enrolled. And this is an important factor because the honourable member is linking this to a legislative requirement. And it's important that the requirement is clear. The DPP, the IDAC is expected and required to consult with the DPP in whose jurisdiction the matter is going to be enrolled. And in this case, that would have been the DPP of Gauteng, not the DPP of KZN, where the PKTT was conducting most of its work. Now, the point of prosecutor-guided investigations, the IDAC follows the prosecutor-led investigation model, not PGI. PGI, as I explained earlier, is where the police, like the PKTT in KZN, works with the prosecutors in KZN, who guide their investigations and they work together in KZN. So the IDAC was not actually involved in prosecutor-guided investigations with the PKTT or with any other unit in the police? I'm just trying to clarify so that the honorable member, if I can help, explain what the situation is.
You're definitely helping. And of course, I will take your position on the matter because you are the expert in the matter. But let's deal with why I'm asking the question. Is it appropriate for the head of IDEC to only find out about a subject that they are investigating? She only finds out about the fact that she knows that he's head of crime intelligence, but she doesn't know that he coordinates PKTT. Is that intelligence? Is that on that level of intelligence you don't know? Is that a good reflection of the capabilities of the NPA?
It's perfectly understandable that, as Advocate Johnson said, she had no idea that the head of crime intelligence was also involved in PKTT. In fact, one might ask the question, why is the head of crime intelligence actually a part of the PKTT? I'm not sure I understand that, but perhaps there is a good explanation for it. Because you wouldn't expect the head of crime intelligence, who's got enough work in CI, heading up an important unit in the police, why was this person involved in the PKTT? But I say there may have been a very good reason for it that I don't know. But it'll be good to understand that link. And the fact that Advocate Johnson, when they were dealing with this matter, didn't know that he was part of the PKTT is not that unusual. In fact, had she known, in all likelihood, she might have spoken to the DPP of KZN.
All right, so I accept that. Now I need you to explain to me, if you say that, based on your experience and based nothing wrong with her not knowing, even though on that level of intelligence that she operates on, I will accept that testimony. Now I need you to explain the flip side. Is my last question. You say that you are actually concerned that he's the head of crime intelligence, General Khumalo, and he coordinates PKTT. There has been testimony of this connection, that it all links. He's the head of PKTT, he's the divisional commissioner for crime intelligence, and then linked to the appointment of an unqualified person on the technical services side within the crime intelligence division. And the link then creates the impression that, and this was part of the testimony of Advocate Johnson, that the speculation is that this link is so that there is a network in order to be able to have control over access to funds, access to resources, such as the procurement of sophisticated equipment, etc. Are you of the same view? That General Khumalo is strategically placed in this position, and the link to the person from BMW that was employed, plus his control over PKTT, is all interlinked in order for them to have control over the resources. Do you agree with that? Do you think that there are that's a valid position to take, or would you say no?
Well, the honourable member has raised two things. Firstly, I want to clarify that I didn't say I was concerned about the head of crime intelligence being involved in PKTT. I said I didn't understand it, but there may be a good reason for it. And that seems to have come through now. But as I testified earlier, the IDAC, the ID, has explained that there is a broader case theory and that the capture of institutions happened. Recruitment was critical in state capture to ensuring that the resources of the state could be plundered. And that is the case theory in this particular case. Advocate Johnson has indicated that it was part of a much larger strategy. There are other cases. And so, given that this is also, part of an investigation, and I don't really know the details, this is as far as I can take it.
Thank you very much, Advocate. And in closing, I want to say that your testimony here has revealed some deep levels of vulnerabilities within the NPA. Take accountability for it, deal with it for the time that you have left, because it's very concerning that it makes us vulnerable, that we have intelligence on that level that publicly says, I don't know. It then makes the security of our country vulnerable, and we should do more to ensure the security of our country. Thank you.
Thank you so much. Can I check honorable members who want to ask follow-up questions? Gone. We are now at the third speaker. Honorable James, it's going to be your time. It starts now up to 20:55.
Thank you, Chair. Advocate, for the benefit of those who may not have seen the full request to the President, your letter that you wrote, what were the reasons you included in your request, in your view, that justified the suspension of Advocate Chauke?
Bear with me for a moment. So this matter is also the subject of an inquiry, which is commencing next week. I will be testifying at that inquiry and will set out in detail the reasons for it. But at a high level, what I can say here is that the reasons for it is that Advocate Chauke was not in compliance with the prosecution policy when he pursued a case against Major General Boyson with regard to racketeering charges when there was no evidence linking him to this matter. And also it relates to the withdrawal of the charges against General Mdluli when there was prima facie and strong evidence to the contrary. And those are the main aspects, and then some other decisions that were taken in the context of these matters.
Okay, the President only acted on your request, we all know this by now, July 2025, just days after General Kwanaze's press conference, alleging that corrupt prosecutors were aiding criminal syndicates, drug syndicates in Gauteng, right? Why do you believe the President waited almost 2 years to act on a matter raised by the country's top prosecutor 2 years later?
I want to say to the Honorable James that it was something that was out of the hands of the NPA, and as I indicated earlier, we certainly followed up to try to get the matter dealt with speedily. It was already, and there was nothing further that we could do. I indicated earlier that I do know that the President, that there was a further legal opinion that was sought, which would have also delayed things somewhat. But apart from that, I cannot really say why it took that long for the decision to be made.
And during this time, What was Advocate Chauke doing? Was he continuing with his daily duties as usual, despite being connected to these cartels and to these persons?
Well, there's no allegation that he was connected to cartels in this matter. But yes, he was the DPP in South Gauteng.
And he continued, despite the red flags, he continued to do his daily work. And no one did anything.
I agree.
Only up until the 6th of June, when General Kwanazi made those allegations, suddenly, 2 weeks later, the president acts.
These are complicated processes.
Definitely.
And there are processes within the president's office, clearly. You know, he needs to apply his mind to this, and one can understand why he might have wanted another legal opinion. And so I agree with you. It is totally unsatisfactory. It is unsatisfactory and potentially unfair for the individual and for the institution. And I've said this publicly, and that is, it was really important that this matter be dealt with speedily for both the individual and the institution. And I can't explain any further, but to say that I agree with you. It's not an acceptable situation to have someone under a cloud like this and still be conducting day-to-day work. But the reality is that is what, you know, with these labor processes, we have to follow process. And it was what,
And
there
it's
was nothing more I could do.
coincidental that the process, a decision was taken 2 weeks after General Kwanazi's allegations. I think I'm stuck there.
I can't help you get unstuck, unfortunately, because
No,
I don't know
clearly.
if it was linked at all. I can't comment on that.
Okay. Advocate, are you aware that former Johannesburg Mayor Herman Mashaba has repeatedly raised public concerns about Advocate Chauke, where he made clear that the Advocate Chauke was an obstacle to the prosecution of corrupt cases that were presented to him with clear evidence? Are you aware?
I'm aware he has made public announcements about this, but there's no case that he has presented to me where, if I heard you correctly, where maybe you could repeat the last part of your question, please.
Okay. Are you aware that former Mayor Herman Mashaba has repeatedly raised public concerns about Advocate Chauke, where he made clear that the advocate was an obstacle to the prosecution of corrupt cases that were presented to him with clear evidence?
I can't comment on that because I'm not aware, but I would certainly urge Mr. Mashaba to send me the details of those cases very
Okay.
urgently. In fact, if he can send it to me tomorrow, I would be very pleased.
Sure.
Thank you.
Here are copies of the many cases that Mr. Mashaba sent to you. You were CC'd in on these cases. A dossier was handed to Advocate Chauke of cases, I think amounting to over 35 billion of corruption cases uncovered in Johannesburg. You were CC'd in all of this. I can give you the date, the 16th of May 2029. You are now saying that you were not aware. I've just brought a few of them to this house to prove to you that you were CC'd in this case. You haven't responded to not any one of these cases. This was 4 years prior to your suspension. You received smoke signals already about Advocate Chauke, which you did nothing about.
I need to have a look at that.
Honorable James, you may come down a bit.
Thank you, Chair, for the reminder. I put it, you said earlier on that it wasn't brought to your attention. You said confidently you know nothing about it. I'm saying to you, 4 years prior, the suspension of Andrew Chauke, there were smoke signals. It was sent to you with evidence. with serious cases within the city of Joburg, and you ignored all of these emails.
Now that you prompt my memory,
Okay.
he did send emails, and we certainly don't ignore emails.
But you
I
just
need-
said you weren't aware.
I need to follow up and to see what happened to those matters.
I can tell you nothing happened.
If I could please have those cases,
They are in
because
your inbox, ma'am.
we are, sometimes emails don't reach you, but in this case, I'm aware that he did send some communication, but I need to check to see what happened to that. Because you may rest assured, Honorable James, we don't want to cover up anything. And if anything, I would want to get to the bottom of allegations that any prosecutor, any DPP, is in fact not prosecuting where there's clear evidence of it. So I need to see what happened to that, because we definitely respond to emails but from anyone, and particularly from heads of...
Yes, I would like to think that you would take an email from a mayor seriously.
We do.
You've ignored, you cannot say you do when I've got evidence and proof. Several emails, an entire dossier was handed to Advocate Chauke. He did absolutely nothing with it. It was highlighted to you that this person is corrupt. It was highlighted to you that this person is covering up for serious construction companies within the city of Joburg, Zimbabweans, with fake documents. It was brought to your attention, as well as Advocate Chauke, that is currently on suspension for over 2 years, that was allowed to continue covering up in the department. In fact, this has been going on for over 6 years, if you take into consideration when these red flags were highlighted to you. And you've done absolutely nothing. And then earlier on, you said that if there's any concerns with regards to cases, I must bring it to your attention. Will you take it seriously when you are saying to us now that sometimes we miss things in our inbox?
We always take these very seriously. And I want to say to you, I want to apologize to Mr. Mashaba that if he has not received a satisfactory response. But I do want to check to see what my office has done with those matters. And I can then give a more substantive reply.
I can tell you they've done nothing. But anyway, do you roughly know how many drug-related offenses have been handled by Advocate Chauke during his tenure?
No.
Are you aware of the conviction or the success rate in drug-related and other criminal matters prosecuted by Advocate Chauke's office in the South Gauteng division? Because that's where the bottleneck is when it comes to drug-related cases. South Gauteng division.
I don't have the figures, but we can certainly get that.
Okay. Would you agree that showing that Advocate Chauke frustrated the proper functioning of the criminal justice system in Johannesburg for so many years, that there may have been some plausibility to General Kwanazi's allegations that certain prosecutors in the same environment were deliberately sabotaged to protect drug cartels?
Before I can comment on that, I'd like to get details, proper details from General Mkwanazi about who he's referring to and what these allegations are about. Because they're just allegations, and I can't comment on allegations. I need the facts.
Thank you, Chair.
Thank you so much. We are moving to the last two speakers. That is Honorable Sangoni and Honorable Nomval. Honorable Skosana.
Thank you very much, Chairperson. It's been a long evening, Advocate Batohi. And maybe let me just start off by saying I'm a bit starstruck when Chairperson, I won't lie. I've admired Advocate Batohi's work for a very long time. I remember when she was trying the Hansi Cronje matter. There was this beautiful newspaper cover, where it was just her eyes, and then it says, "In the eyes of the tiger." That was amazing for me. And I think watching you as a prosecutor and the work that you've done internationally, we really commend you for the great work that you're doing. So thank you so much. Thank you for making the time to be here. Advocate Batohi, just tell me, since July 6th, when General Mkhwanazi made these allegations, I know you've spoken now about things that you're trying to do, but what happened in the NPA? Were you shook at all in any way by these allegations? Was there anything that was done?
I think, like the rest of the country, we were certainly taken aback by the allegations. Since that date, I have not approached Advocate General Mkhwanazi or the police for details of this. But given that we have now testified, it's out in the open, I will address a letter to the National Commissioner seeking details so that we can properly understand what's going on and take the necessary action.
Okay. In paragraph 22 of your statement, you indicate, so you're talking there about the prosecution policy and how matters are decided, or at least what must be prosecuted. You then say that you refer to a matter of public interest as a consideration to prosecute or otherwise. So I'm just interested to find out, how is public interest determined, firstly, and then are there any cases that you are aware of where public interest has swayed the decision to prosecute or not? And if you could share those with us, please.
If you give me one moment, Honorable Sangoni. My apologies for this. I did. This is. Oh, I wish I could find this. When dealing with public interest, it is an important factor, and it deals with aspects such as the gravity of the offense, the circumstances of the community, of the individual concerned. Generally, the courts have found that when there's allegations relating to a particular crime, it would be in the public interest to prosecute a matter. But there are instances where you would consider factors that I've just mentioned and come to a conclusion that it would not be. For example, some of the an example that I might be able to give here now is, for example, a father who has been involved in an accident, and his child is killed in that accident, and the father is responsible primarily for that accident. You might consider everything and say, should we charge the father for the culpable homicide with regard to the death of the child? And then we would say, look, he's suffered enough. So those are some of the factors. I said the nature and seriousness of the offense, the interests of the victim, community, the offender's circumstances in some instances. So I think those are, there's no closed list, but those are some of the guidance that we give when we make these. But it's generally we lean on the side of prosecution, but we do consider those factors.
So there's no controversial, I use that word lightly, but controversial cases that you've chosen not to prosecute, and, prosecutors hide behind, it's in the public interest.
No, it's not.
For example, Agrizi.
For example?
Agrizi.
That was not my understanding, it wasn't a public interest matter, but it was the circumstances, and the ID explained issues relating to him cooperating in other matters. So it was certainly not a public interest issue.
Okay. All right. Then on paragraph 83, you were asked a little bit about that issue where you make a recommendation to depoliticize the appointment of senior leadership within the NPA. Can you give us examples where this is done, perhaps in other jurisdictions around the world, and whether you necessarily think that that is a better model, given the fact that the politicians, at least that you have worked with, have given you space to do your work, even though you're appointed in the manner that the Constitution or the NPA Act outlines?
As I mentioned earlier, it's the fact that it is the president's prerogative to appoint the head of the NPA. Unless it becomes a Chapter 9 institution, I've said that there are very, very few jurisdictions, and in fact none of them come to mind now, where there's no some level, where the executive do not appoint the head of the prosecuting authority, and there isn't some level of accountability to the executive. And that being the case, it therefore becomes really important for the executive to respect the independent mandate of the prosecuting authority, and for the prosecuting authority to understand its accountability and reporting functions to the executive, and that in this balance, the lines are not crossed. So, I think the president instituting the process to appoint, for example, when I was appointed, was a very good model to be adopted in terms of how a national director could be appointed. And that's the same model that's being now, it's the call for nomination, so it's the same model that's being utilized. I think as a matter of moving forward to enhance the system, it might be good to regulate this process. Although there's a tension between a president's responsibility to do it and legislating a process, that balance has to be struck. But I don't think that they are mutually exclusive.
Okay, so if I get you correctly, firstly, the way that South Africa appoints the NDPP in particular is nothing untoward. It's done exactly like that in many parts of the world. And then secondly, there have been attempts and steps that have been taken by the president in particular to make the process more transparent and accountable. Am I right?
Absolutely. And I think that's a very, very good model that the president has been following.
Okay. Thank you so much. Advocate Batohi, each time we speak about stalled cases, well, not that they're stalled, but cases that are not moving as quickly as we want them to be, we speak about the Zondo Commission in particular, the Nugent Commission as well as the Mpati Commission, SARS and PIC. Do you have those matters in court as well? Because there were recommendations for criminal prosecutions arising out of them?
Yes, those matters are definitely in the mandate of the IDAC. I think the ID testified, and I stand to be corrected, that there probably are 3 matters from one of the other commissions. I'm not sure which one it is. But these are not a lot of matters. And again, I want to emphasize there's a lot more cases relating to the State Capture Commission in terms of the recommendations and the number of cases in court, the asset forfeiture processes. But given the capacity constraints in the IDAC, and again, the committee can help with that. If we really are serious about fighting corruption, we need to ensure that these entities that we create are not weakened, but are strengthened with the necessary capabilities, capacities, salary dispensations. And if we don't get that right, we are still going to struggle with moving with the required speed. But I do want to say that with all of the groundwork that we've put in place to capacitate, to make the IDAC, there was a lot of work that went into making the IDAC permanent, a lot of groundwork to capacitate. Things will move a bit quicker, the country will see it, but we still need to ensure that the IDAC is even further strengthened to be able to deal with the enormous amount of work that falls under its mandate. It's a lot of work, and there's just not enough capacity at the moment.
All right, now I hear you there. I'm really interested to understand what I thought sounded like frustration coming from you as it relates to how the SIU works. Now, I remember you said they're busy, writing reports, referring matters for prosecution, and those matters are not ready for prosecution. You think they should go to the Hawks, I'm assuming, for investigation. Why the Hawks? Is it not the responsibility of IDEC to investigate that? And then just generally, how is the cooperative relationship with the SIU and the NPA? Because a lot of issues end at SIU, we've referred the matter to the NPA, then you never hear much of it again.
As I mentioned earlier, we have appeared before SCOPA and other parliamentary committees together with the SIU and the DPCI, and given very detailed reports in respect of the cases. So it's not about frustration about how the SIU works. It's frustration about the process, because the Act currently requires that the SIU refer matters to the NPA. Now, prior to the IDAC, which with its limited capacity to investigate, all matters that were referred, in fact, went to the DPCI for investigation. And, it delays matters, but that's the process. But the Act says it must come to the NPA. And that, I said, should be amended moving forward. But you're absolutely correct that now that the IDAC has investigative capacity, there could very well be cases that are referred to the NPA that the IDAC takes over. But again, I really want to urge that the capacity issues are dealt with, because that's the way it should work. There are very serious cases that the IDAC should be investigating.
Okay, and then the SIU and the asset forfeiture unit, right? Because we've seen SIU attaching asset forfeiture attaches. Where is there duplication? Is it ideal that it's like that? I'm obviously, again, looking at issues of institutional reform. This is notwithstanding what the successes that you've spoken about, in terms of recoveries. But who does what?
That's a very, very important question. There are various entities in the system that have some kind of recovery powers. SARS has some. The NPA, of course, with the asset forfeiture unit has. And the SIU doesn't have criminal asset recovery powers, because that is in the Prevention of Organized Crime Act, and the NPA has those powers. The NDPP brings those applications. But the SIU has certain powers to recover damages. And so that's a really important issue, because I think this needs to be understood, and there needs to be an important conversation about who does what and where exactly should these powers lie. Because and the NACAC has made recommendations, was looking into this aspect, and I think, again, in some context, I was saying that maybe we need to have, where everybody is everyone is fishing from the same pool, then it becomes competition amongst agencies, and it should never be like that. So, because there's enough corruption, but we need to be clear about who does what, clear mandates, so that at the end of the day, together, we're able to ensure that we collectively recover as much as we possibly can from criminals in this country. But that's a very important issue. NACAC's dealing with it, and there needs to be a lot more conversations about this.
In fact, I was going to ask you about the NACAC recommendations, because you did say that you support them, I suppose in terms of the overall attempt for coordination. But can you just speak to us on this issue of whistleblowers? There's obviously lapses and gaps, and my understanding is that in order to get protection as a whistleblower, you need to be a witness in a SABS matter, then they take you in for protection. But what needs to be done there, Advocate Batohi?
Honorable Sangoni, you're absolutely right. There's no legislative framework in our country for protection of whistleblowers. The department is looking at that very closely. And one of the aspects that needs to be dealt with. Currently, you're correct, the framework only provides for protection of witnesses. And unless you're a witness in a criminal case, you do not qualify for protection. And that is a huge gap. The Department of Justice is working on that. And hopefully that when legislation comes to Parliament, it will be fast-tracked. But protection of whistleblowers is a tricky matter, because General Lubia once said sometimes whistleblowers come forward as whistleblowers, but they end up being suspects. And but of course, the legislation needs to be drafted in a way that we are able to establish who the true whistleblowers are that need protection, because otherwise we're fighting a losing battle in terms of trying to address corruption.
Okay. If there's one thing that I know you've heard enough of today, is the matter relating to the arrest of General Khumalo. But I do need you to understand, Advocate, that why this thing bothers us so much is because we think that, well, let me not speak for all the members. I think that, it looks like a fight-back strategy that is being adopted by those that General Mkhwanazi alleges are protecting drug cartels and all sorts of things. Now, you've been saying, and you've been at pains to explain to us that that matter would never have been handled by IDEC if it was not as a result of the Section 27 referral. Now, when Advocate Johnson was here, we put it to her the fact that this entire Section 27 referral seems to be a concocted plan anyway. You have a member of parliament receives those documents mysteriously, then there's ministers, chief of staff saying this is a Section 27 referral, then suddenly he pitches up there as well, right? If you could come to the conclusion, and I don't expect you to, but if it was said to you that the Section 25 referral was part of the plan, it was concocted to be like that, hence it lands on Advocate Johnson's lap, would you accept that?
No, definitely not. And that is why I again urge, there is a review process open. That would be totally unacceptable.
What are you refuting, Advocate, that it's concocted, the Section 27 referral, as in these people that we may think, right, are fighting back? It was not just because remember, the member got these documents anonymously, and then he went everywhere, ran to Orlando, went to the Western Cape, somehow finds himself in the minister's office. The chief of staff tries to intervene, until the referral gets to Advocate Johnson's desk. I'm not accusing her. If that whole thing, for it to get there, was part of the fight back plan, right, would you then have a different view in terms of how the case has come about?
I'm trying to understand your question properly so that I answer it properly.
Okay, let me try again. You said Advocate Johnson
I do think I understand it. I'm just reflecting on it, because my understanding is that if the Section 28 referral was part of a fight back plan, and you're not saying Advocate Johnson is part of that, would it then what's your question after that?
Would you still view the case in the same light?
In the light of it's a justified case. Look, it's a difficult one, because if it's part of a, we should never prosecute people because it's part of any fight back campaign. But the way you frame it is there may have been others that had some ulterior motives and not the IDAC. So the IDAC is looking at it purely from a perspective of criminality. And they come to a conclusion that there is criminality that needs to be prosecuted. Then I would agree that if there is, on the evidence that the IDAC has, that there's evidence that this is in fact part of a much larger strategy to extract from crime intelligence and it's part of a number of cases, then I would say as long as the evidence is there, it would justify a prosecution. And the manner in which the evidence was obtained is something that is separate from that. But where there's a fight back and people manufacture evidence and then and there's no evidence and the IDAC then acts on it, that is completely out of the question.
Okay, I think I have time just for two more questions. The referral to IDAC that you made around that suspended prosecutor, I mean, without going into detail, but are they moving as speedily in that matter as they did with the Lieutenant General Khumalo matter?
That's a very complicated matter. Because it's an NPA staff member, I've urged them to move with speed on it. But I'm not sure. It's, as I said, it's at the level of intelligence that we received. And so there's going to be a lot of work that needs to happen in that investigation. But they are certainly regarding it as a priority matter.
Okay. Advocate Batohi, this is almost really the last question, I think. So nobody is, well, I'm not disputing Advocate Johnson and how you characterized her as a woman of integrity, right? And I think what you said was that there has been lapses, and I want to ask now, you as her direct supervisor, when you hear these issues that are being raised by General Mkhwanazi as well as former Minister Bheki Cele, where they want to intimate that Mr. Johnson doesn't have a good relationship with Khumalo. He stands in line to maybe be appointed head of CI should he go. Then all these issues around all these issues around how this entire case come about and what is happening, unfortunately, with now advocating to this matter. Would you not think that at some point there's a reasonable apprehension of bias on the side of Advocate Johnson in this matter? And how are you, as the NPA head, ensuring that whatever is happening there, I mean, she explained to me that there's a team investigating, but that there's impartiality in the handling of that particular case?
With all due respect to those that have made these allegations, I think we're dealing with allegations on both sides. And why would we choose allegations from one source to be more credible than what Advocate Johnson is saying? And so, from what I know of Advocate Johnson, I would not suspect that there's any bias. And because of the circumstances of how the IDAC came to investigate this matter, I have no doubt that it is not motivated by bias at all.
Okay. So, last question. I would have loved to ask you at the end a nice sweetheart question, asking you to reflect about your last 5 years or 6 years at the NPA, but I don't have time. So just know that my intent was there to give you that question. But you said you don't want to sweep things under the carpet. There will be consequences. And I think you were talking about this matter. Now, Section 28 of the NPA Act, I think as amended, still reads, an investigating director may investigate a specified offense if they have reason to suspect that one has been or is being committed. They are required to investigate if the national director refers such a matter to them. Now that you have become aware, Advocate Batohi, that Honorable Adams obtained classified information that he was not entitled to have, which on its own could be illegal, will you then direct Advocate Johnson to investigate that matter as Section 28 demands you to? It may not fall within her direct scope, but what she said when she was asking, when she was responding was, you know, they don't go 90%, 70% of a matter. Would you ask her to then investigate that, because this section says you may direct her to do so?
I will have to consider this matter if there is a complaint, but I don't have enough facts at my disposal now to say that is something that I will do. And whether it's something that will also fall within the mandate of the IDAC, I don't know. So it will be something that perhaps the police might be better placed to investigate, also given the limitation of resources in the IDAC. But if there is a complaint, then certainly one of the investigative agencies can investigate that matter.
Thank you very much, Advocate Batohi, and let me thank you once again for your service to the nation. I hope that you'll enjoy your retirement. Thank you, Chair. I'm done.
Retirement is a tax event. I don't intend to stop fighting the
Thank
good
you
fight.
so much. Can I note hands for follow-up questions? Honorable Malema, Honorable Ngola, Honorable Shoma.
Thank you, Chair.
Before you start, it's only 3 hands, honorable members. Thank you. You may proceed.
Advocate, the agrees matter was, when it was offered 204, it was in the interest of justice, right?
Yes, that's correct.
And the interest of justice is public interest, right?
That's correct. Generally, they're
So
two
it
other
is
sides.
correct to say Agrees' decision was based on the public interest because justice is public interest.
That's a good question.
Because she asked you earlier about whether Agrees' matter decision was based in public interest. You said no. But that which is in the interest of justice cannot not be in the interest of the public.
Public interest would generally be in the interest of justice, but interest of justice doesn't always require a public interest aspect to it. So in this case, my understanding was that it was certainly in the interest of justice, but public interest in the way we, the criteria that we consider, my thinking was that it was not a public interest matter, but certainly a matter relating to the interests of justice. So I think there is a slight nuance to these two concepts, but they're very, very closely related.
Oh, it is in the interest of public because we might have looked at it now as being in the interest of justice, which might have those problems in relation to public interest. But what Agrees is going to give us is what the public is interested in.
That's
And therefore,
correct.
this decision, it is in the public interest.
I think you're correct. It might well be in the public
I must get
interest.
honorary
I think so.
advocates, you see.
I think a doctorate for that.
Now, the last question I must ask, Chair. I know there are so many factors which were considered when 204 was offered to Agrees. But one of the factors is that he's so sick that he can't even appear in court. How is he going to appear in court to give us evidence against these big fishes who are looking for?
We are looking at, not in this particular case, but in other instances where witnesses can testify via video link in cases. So that could potentially be a solution in this matter as well, where the witness is unable to come to court. We're looking at increasing the use of technology in certain circumstances so witnesses are able to testify remotely. So that is an option.
Yes, because in the public interest, I wouldn't want to hear that when he's supposed to appear to give testimony against that which he committed to give it to us in the 204, we are now told he's unable to do so because he's sick. So as long as you are saying you've got those other things in consideration, that we can use the technology to get him to testify from wherever, that makes me be at ease. Thanks, Advocate.
Thank you very much.
Honorable Ngola.
Thanks, Chair. Just one issue. Are the acts of Advocate Johnson in relation to the employment of her husband an error of judgment or a pure case of nepotism?
Given the way Advocate Johnson explained the process, I would be inclined to say that it is an error of judgment of a young prosecutor at the time. As I said earlier, it's something that we should not do. So I would say that it was an error of judgment on her part at the time. But she explained the process. It's still not ideal, and I said as much to her. So I would say it was a serious error of judgment on her part. Perhaps due to inexperience of the time, I'm not sure, but it's an error of judgment. Given her, I'll leave it at that.
No, Chair, I'm done. I'm fine.
I want you to look at me and say so.
Yeah.
Honorable Shongwe.
No, Chair, thank you. I was covered by Honorable Malima on the Akrizi issue. But I may use this time to add something. Advocate, you said while you were speaking to Honorable James, she asked you pertaining Mr. Herman Mashaba, and you promised that you will urge Mr. Mashaba to furnish you with certain documents on that issue. May I also add that you asked Mr. Mashaba that why did he hide documents or hid document or information from the former public protector? Remember when he hired Sibiya, it was then when Mr. Sibiya came with a letter from public protector that cleared him, the first letter. But he was playing smart if he hid the second letter where the public protector asked that Gauteng hired Mr. Sibiya and hid that information about Mr. Sibiya of not passing his competency. So when you're doing that, whatever you're going to do with Mr. Herman Mashaba, please ask him why did he hide information and why did he hire Mr. Sibiya while he didn't pass his competence? Because we are here in this mess because Mr. Mashaba hired General Sibiya, then Mr. Sibiya. Thank you very much.
Just a quick one, Advocate. When he says Gauteng, he means Johannesburg. So we villagers mix the two.
You want to say Joburg Metro?
For the record, Joburg Metro.
Yeah, because he's right. Where we come from, that is the understanding. Ijoni. Do you want to comment on that, Advocate? The point that has been made.
It would have
by
been good if the
Honorable
honourable
Shongwe.
member could raise it with him directly himself, but I take the point and we will.
You're going
I've
there,
got
you
no
might
further
as well
comments
carry mine.
to make on that, Chair.
Thank you so much. Honorable Skosan,
Thank you, Chair.
your time starts now. It's 9:30, 1 minute past 10. You must be done.
Thank you, Chair. Once again, thank you, Advocate. I'm going to start by making some remarks and quick, answers on that, if you may, please. One, is Bulelwa Makeke still working with NPA? Because there was an issue about his qualifications that she has a diploma, but it came up that it was a 2-week certificate from Damelin. And we were told that it was an error. And the last time I heard that, in fact, she was promoted to be an acting deputy director general. I'm not sure whether it's true.
Well, firstly, she is part of the NPA. She's still with the NPA. I am aware that during a process for the recruitment of someone for the post of DDG, she applied, and that's when the issue of her qualifications came up. And my understanding is that there was a confusion about the SAQA requirements, and Yeah, so at the end of the day, she didn't get the position, and it's going to be re-advertised. But there were challenges about whether what she had done actually met the criteria for consideration as a diploma or not. And we were getting conflicting versions from the entity that is actually required to give us the correct answers. But my understanding is that the issue has been resolved and that the report that we received was in fact not an accurate report.
A follow-up on that. If NPA can allow that a person lies on when she made that application and there's no consequence management, there's nothing happened to her, am I right?
Nothing's happened to her, but there's no indication that she lied. My understanding is that the report was not accurate.
So in other words, are you saying she did not say on the application that she has a diploma instead of a 2-week certificate?
I don't have the precise details of this, and I'm finding it difficult to give you the accurate answers. But my understanding is that the matter has been resolved. It was not an accurate report. And that's as far as I can take it now, at this point.
I'm not happy with that. That response, honestly speaking, is protecting one of your employees. You know, in Afrikaans they say, "Elke jakkals, pray sy eie sterk." Now, I'm saying, advocate, the issue of Bulelwa is not a minor issue. It's not a minor issue. Don't take it for granted, because you are the examples of ethics. You know, for young men and women, you must set an example that you don't lie. When whether it's at 83, whether it's at 24 or 1, when you are given an application, you must tell the truth about yourself. Now, she can't say it was an error. It can't be an error. If you have a 2-week certificate, you must just say that I've got this in two weeks' time. No, not in a year. You know, it's not a diploma for 2 years or 3 years. You know, but let me give you a benefit of a doubt, because you say you are not sure about that.
I do have a response on this, and that
Okay.
is that I've been informed that she did not lie, and that the matter was investigated by our OEA office, and that it has been resolved through an investigation that she did not lie.
So was it a 2-week certificate or a 3-year diploma?
I can't give you the details of that. What I can tell you is that it was a matter that was investigated by the OEA, and it was found that she did not lie. I want to make that very clear, that is the position. She did not lie.
Advocate, I think we must pass that, otherwise we're going to take 10 minutes. I ask a simple question now. Was it a 3-year diploma, a 2-week certificate, a 1-year diploma? What was it? Then we can pass that, please.
I want to say that I don't know, but what I can add to help the honorable member is that the matter was investigated, and I'm informed that there was even a lie detector test that was done for security vetting, and it was confirmed that she did not lie.
Advocate, I said to you earlier, you know, we had a witness here, and my colleague ended a General Sibia about this competency he was talking about. Have you passed that, or you haven't passed that? You know, if you know the answer, how he responded, you'll be embarrassed. But let me just pass that. It looks like you don't want to tell me the truth about this, whether it's a 2-week certificate, whether it's a year certificate or a 3-year diploma. But you say because he was vindicated by your internal structures, it's fine. We'll get to that. Number 2, you know, there was an issue from Honorable James about you not responding to emails. There's a gentleman here in Cape Town. He comes to Parliament here. He sent us emails which is sent to you. You never responded. The name is Fikile Bambi. He said I must mention that clearly. Have you ever responded to his emails? Many of them.
I should explain that when any communication comes to me, I immediately send it to the relevant part of my office, the deputies, to deal with it. And we have, as a matter of process, that at the very least there must be an immediate response acknowledging receipt, and there must be, as soon as possible thereafter, a substantive response to whatever the matter is about. I don't know about this particular matter and whether it was responded to or not, but if you give me details, I can assure you that he will get a response within the next couple of days.
Thank you. Thank you. I'll forward that to you. On your statement, paragraph 22, if it's sufficient evidence for NPA that they must prosecute, unless it's not in the public interest, what constitutes the public interest, and who decides that a prosecution where evidence exists is not in the public interest? What criteria are you using on that?
So, as I indicated earlier, that our prosecution policy indicates that when considering whether a matter is in the public interest, we take into account relevant factors, for example, the nature and seriousness of the offense, the interests of the victim, interests of the broader community, circumstances of the offender, and it was, there has to be compelling reasons to not prosecute. Our courts have actually pronounced on this, that there must be compelling reasons to not prosecute in the face of what they refer to as formidable evidence against the accused. So there's no closed list in terms of trying to establish what are compelling reasons, but there's guidance that is provided in our policy. It could also be that the matter is a trivial offense, as I said, dealing with the gravity of the offense. The accused might be very young or might be very old, or tragic personal circumstances, as I mentioned earlier.
Now, I think you have heard about the so-called rogue unit within IDEC. I think you've heard about that.
I heard about the allegations.
And there were names there. They say Perumal, Sunel, the other one, I think, and the prosecutor called Tyler Shabalala. Do you know him?
I do know him. It's Silas Shabalala.
Shabalala. We are told that he's prosecuting people as well, as far as the Eastern Cape, besides in Gauteng. Is that the norm?
It depends. I need to get details. There are cases where a DPP of another jurisdiction can give delegation to prosecute to a prosecutor from another jurisdiction, depending on the circumstances.
Yeah.
But I don't know about the individual cases, but it is possible legally.
That's how people are perceiving this thing. That to say, some of them in particular, I gave you only one example. That when they target people, there's the rogue unit works with a particular prosecutor to go all over and target people. It's an allegation. I'm just giving you that there's that perception out there that this is how the rogue unit operates.
Firstly, I'd like to be very clear. There's no rogue unit in the IDAC. And if the honourable member has any evidence to that effect, I would really like to have that evidence.
Thank you.
I would urge that we do not make bald allegations without any evidence to support it. I would welcome that evidence because as a national director, I would not want people that are behaving contrary to our code of conduct in the NPA. So I would really welcome that evidence.
Thank you. Thank you, Advocate. We had that before at SARS, where there was Lochenbeck, Lakey, Pillay. We had them. They were rogue. But obviously, as I said, I don't want to invoke again to say, their principal was rogue as well. But it's a debate for another day. But you can't say people must not say, wait, advocate. You can't say to people that they must not call others rogue because you believe they are not rogue. But if some people believe they are rogue, they'll call them rogue. Yeah, I mean, there's nothing wrong with that. You believe they are innocent, there's no rogue, it's okay. But some people who are feeling the pain, who their lives are destroyed by the same people, alleged, they will call them rogue. It's not me who's calling them rogue, but I'm just saying to you, they are being called rogue. But for the sake of progress, because we've been ventilating this matter, and you're going to take another 5 minutes to respond, and the chair will say, my time is over. And I still have another 6, 7 questions for you. I understand Advocate Johnson as well said the same thing we are saying, that there's no rogue. And General Kumaro said there's rogue as well at IDEC. And there's some in the judiciary who are compromised. You will deny that, it's fine, because, I mean, you have to protect your staff anyway. But let's move, Advocate.
Chair, I do ask that I be given the opportunity to respond to this.
You're going to respond the same as Advocate Johnson. You'll say that there's no one.
Honorable Skosan.
There's no chair.
Yes, but I think we should not allow, nature doesn't allow vacuum. The chair has had to go out to respond to some emergency, so I suggest that...
Thank you, Chief Whip.
Yeah, so...
Chair, may I answer?
Yes, that's what I wanted to suggest.
Thank you very much, Chair. I think that, the case, I've got confirmation that Silas Chabalala is in fact in IDAC, and he has got national right of appearance. That means if you appear in, I didn't realize he was a prosecutor in IDAC. If you're a prosecutor in IDAC, you're in the Office of the National Director, and you actually have national jurisdiction to deal with that.
Thank you.
So he is completely within his rights to do that.
Thank you.
And the second aspect of the fact that there are rogue elements in the NPA, in the IDAC, I would again urge that evidence to this effect be presented. And if the honourable member has evidence that these persons are bringing cases targeting
Can you
people.
protect me, please? Because she already responded on that. We are going back again there. She's going to give me the same response she gave me 5 minutes ago. Please, you said that. Can we move, please?
Chair, these are serious allegations. I'll be very quick. I just urge the honourable member to please give me evidence of this so that I can deal with it. Thank you.
Chair. Coming to the issue of these so-called agreements, because I see a lot of big companies, when they are corrupt, they pay back the money. They are not prosecuted at all. I can give you names, McKinsey, some APP and others. They just pay back the money. They are not being prosecuted at all. Now, which means now, we are not equal before the law. If you don't have money, you'll be prosecuted. If you have the money, you'll pay back the money. Now, the issue of Vincent Smith and Angelo agrees.
Chair, sorry, can I respond to that issue?
No, I want to give you two, please. Otherwise, as I said, Chair, unfortunately, when he responded, I can't force her to respond, yes or no, because she takes 5 minutes. And for me, I'm asking for 1 minute, and it takes 5 minutes to respond. Now, Section 105, a plea and sentencing agreement vis-à-vis 204 witnesses. I just want to find in terms of racial lines. In terms of states, how many white people were accused, and how many black were accused, and how many colors were accused, and how many Indians were accused? In terms of racial lines, who were given the same agreement, these sentencing agreements, ever since you've been a national director of public prosecution? People who, like Angelo agrees, who were given suspended sentence like they were given by court. But I'm saying this plea agreement, in terms of, because I've never seen, or perhaps I'm ignorant, in terms of racial lines, is this only exclusive for white people, or anyone can get that? He can plead and
anyone
get
can
scot-free.
get it, and I can attest to the fact that I've done many cases where we've had Section 204 witnesses that were not white.
High profile?
There were, years ago, certainly important cases, murder matters. So I would like to say that it's not something, the issue of race does not come into consideration. I don't know that we carry statistics on that, so it will be unlikely that we'd be able to give statistics on that. But I want to assure the member that the important aspect of 204 is the ability to get evidence to prosecute a case.
Okay.
And sometimes if it's insider evidence, for example, you have to withdraw against certain witnesses and use them as 204 witnesses in order to get to the bigger fish.
Is anyone from Steinhoff who's prosecuted as we speak, and how many people were prosecuted on that matter?
I think the CFO of Steinhoff is in custody currently, and I think he's a white male. Of course, we know that Uster committed suicide. There are still investigations continuing in that matter.
Sissoko, a chief investigator at IDEC, we're told that he was hijacked. I think last Friday, if I'm right. Is it true?
That's correct.
Was Robert McBride right-hand man? Was he Robert McBride right-hand man?
I have no idea.
Was he not having a proximity to Shedrack Sibia, or Paul O'Sullivan, or Benjamin Chauke?
I do not know.
You don't know. Now, I've been hearing that, most of the things you distance yourself, you say you don't know. It's fine.
I really don't
Paragraph 25, Section 179 of the Constitution provides that the NPA must exercise its function without fear and favor, like you said. Remember? If this is so, why has the NPA not prosecuting the case of Pala Pala, where the president was hiding foreign currency in sofas, far in excess of what the exchange control regulations allow? Because Advocate Johnson said the matter was not brought to her. Now, as NPA, what is your stand on the matter of Pala Pala, besides being that the matter is classified?
If there is evidence against any person in the Pala Pala matter, there must be a prosecution. That matter, I explained earlier, there's two aspects to it. The one aspect, accused persons are in court. The other aspect regarding the money in the SOFA is a matter that was declined by the DPP and is currently under review.
If I may ask about the DPP as well, who was doing that case. Does she has the clearance is being a clearance certificate? Is she vetted?
I don't know if she has top security clearance. I can get that information, but it doesn't affect her ability to do her job.
No, I'm not saying it affects. I'm asking whether does she have a top secret certificate, or was she vetted?
I don't know. I'll have to check the list.
But do you vet them, or all the NDPP? I mean the DPP?
We certainly ensure that we are fully compliant and that all the necessary steps are taken to ensure that the State Security Agency can conduct the vetting. So we are fully compliant in the NPA.
Now, you said that for some people, if they ask, that you are raising a lot of issues, but you raise them very late because we are about to go. In the report of the Zondo Commission, the State Capture Commission, because you've been talking about the Zondo Commission a lot, was that the report which was handed over, you said is in the department, was it peer reviewed? If it was peer reviewed, by which institution? Because a lot of people are taking the matters for a review. Some of them who were fingered, they are cabinet ministers as we speak. Now, I just want to find out, because it looks like we rely more on that Zondo issue.
So before I answer that question, I have confirmation that the DPP in Limpopo does have top security clearance. On the second issue, on the question that the honourable member raises now, I'm gone blank. What was the second question, with due respect? Oh, the peer review.
Yes.
Thank you, Chair. I'm not sure what process the honourable member is referring to when peer review is mentioned. I can't comment on that.
Yeah, what I mean that report, remember, as I said earlier, that a lot of people who were fingered are challenging it. So I'm asking that other report was handed over, was it peer reviewed?
I'm
You're
not
not
aware.
sure. Now, my last one, because my colleague asked for another 7 minutes. At paragraph 69, you speak about Zondo Commission report and say NPA was not spared of being captured. I've read that report of Zondo Commission. Can you refer us to the page where Zondo says that?
Sorry, which paragraph is the honourable member referring to?
Paragraph 69. You said Zondo says the NPA was captured. My question is, how was it captured? Who captured and by who? That's my last question, Chair. Because I've tried it. That's what you said, so I wanted to find out. Maybe you can.
To clarify, if you read my statement, it says that the Zondo Commission heard testimony relating to the capture of the criminal justice system, not that there were any findings. Regrettably, as I testified earlier, there were no findings made, and we certainly hoped that the Commission would have made findings about this. So unlike SARS that had the Nugent Commission, for example, the Commissioner was able to act quickly on findings there. But
yes.
With regard to the NPA, we had hoped that the Commission, because they had heard a lot of testimony around the capture of the criminal justice system, that they would make some findings around it. But these findings were not made. And so I just want to be clear that I didn't say that Zondo Commission had made findings, but we certainly hoped that they did. Regrettably, they didn't.
Thank you, Chair. I was reading your paragraph, but unfortunately, Chair, my disappointment is that the advocate, when he's talking to us here, there's somebody who's sending him electronically answers, and it's disappointing. It's like you have your legal advice. I'm not talking to you. We are responding on someone who's sending you answers. I thank you, Chair.
Chair, I'm trying to assist the committee in giving them accurate answers and as full as possible. Thank you, Chair.
That is the information you did not have, and you had to get it. Honorable Nomvalo, your fellow comrade has left you 4 minutes.
4 minutes. I'll try to be very quick.
Chair, I didn't answer the question on...
And I would request the witness to give short answers. I will also try to give short questions.
Chair, If I may, I didn't answer a question about the corporate alternate dispute resolution mechanism.
Just note the question. He does not have time.
Okay, thank you, Chair.
The chair will give you time to respond to the question.
Advocate, is it possible for a matter to be withdrawn on the basis that the NPA still wants to add more people as accused people, or for the matter to be struck off the roll because they still want to add more people?
It is possible.
It's possible. You said you don't know Paul O'Sullivan, eh?
I said that I don't think I've met him, but he has sent emails.
Have you ever heard about him playing a certain role in the work of the NPA?
No, I haven't.
Do you know that there is a case, there are charges which were laid against him, and I don't know whether he was arrested, but before COVID, and charges were later withdrawn, or the matter was struck off the roll on the basis that more accused are to be added. Are you aware of that?
Not aware of that case.
Yeah, I know that I will always get such answers to you from you because you are not too much involved. You are not executing your statutory obligations, like I said. That is why you don't know. Can you make us a favor, because Paul O'Sullivan is a subject in this investigation, and we really want to know what happened in that case, because he was charged, as per the information that we have. He was charged and later arrested. The charges were withdrawn, or the matter was struck off the roll on the basis that more accused people are to be added. And that happened before COVID, either in 2019, 18, or 17. So if you can give us a report in that case, is that possible?
If I can get the details, we'll certainly.
Yes, and tell us the status of the case, because we are saying we don't know what's happening.
Sure.
Currently. Then the next thing, if I captured you correctly, you said you only heard once, or you only received one report in relation to the work of the PKTT. Is that correct? Did I hear you correctly?
No, I said that the DPP provides reports, and it may have been included in the reports that the DPP sends, but specifically a report relating to PKTT. There was a report when the Minister Cele had raised some concerns about the conduct of prosecutors working with the PKTT, and then the DPP compiled a report in that regard specifically.
Yeah, so for the prosecutorial work that was done by prosecutors who were involved in the PKTT, you never made any supervision.
That's the DPP's role, to manage the operations.
No, let's not go there. If it's your role or the DPP, I'm asking now if you never made any supervision. Did you make any supervision of the work that was done by prosecutors who were involved in the PKTT work?
That's the DPP's role, and there
So
was,
you never made any supervision.
that is the DPP's role.
No. You never asked for any report.
There was no need for me to ask for a report. The DPP is the one that was engaging with the PKTT, and her evidence at the Madlanga was that they were working well with the PKTT.
No, leave the Mazanga.
Unit.
I'm talking about during the course of the work of the PKTT, when they were busy doing their work. Have you ever summoned any report on progress of the work that the prosecutors were doing?
As I explained, it appears that things were working well with the PKTT and the DPP, so I did not ask for any reports on that matter.
Now I understand why you said, when I asked you about the case of Sindiso Magaka, you said you do not know. It's because you never even tried to involve yourself in the work of the PKTT, which involved prosecutors who belong to your organization.
I did explain at the beginning the role and powers and functions of a DPP and the role and functions of a national director. It's really important because these are operational matters that the DPP manages and is expected to, as very, very senior and powerful people in the NPA to do their jobs, and that's what they do. If there's a risk and there's a need for a report, of course, I would ask for reports intermittently, but not for the sake of receiving reports, if things are working fine.
Yeah, no, I'm no longer going on that one because I think we'll never agree. I thought we were agreeing, and I've just learned now that we're not agreeing because we are going back to the same position. Now, the last one, I asked about the unjustified delay, according to me, of matters which delay for more than 5 years. Like I cited the what's the name? The Zandile Kumete case. And I think there is a matter which has delayed for 8 years or more, which relates to the former Minister of Police, Minister Pashane, who was charged with something which is related to blue lights and so on and so forth. Now, where do we locate the interest of justice in that regard? Or the former commissioner? Thank you very much. Now, where do we locate the interest of justice in such delays? Are we still pursuing the interest of justice in a case where a matter is delayed for more than 10, for close to 10 years?
Through you, Honourable Chair, it's not in the interest of justice, but one needs to look at the reasons for the delays. And as I explained earlier, there may be instances when prosecutors are responsible for delays, but in the majority of cases, I have asked for reports. We get many reports from Parliament, parliamentary questions, asking for delays with regard to specific cases that have gone on for years. And in the majority of them, the prosecutors are not responsible. It is the defense, it's the accused, it's for legal representation. There's a whole range of issues, for example, where lawyers withdraw from cases, and there are very, very few cases. So when we do say it's not in the interest of justice, I agree completely it isn't.
Yeah, but
it's very rarely the prosecution that is responsible for
I'm
it.
sorry for interjecting, but I'm talking about an instance where a delay is as a consequence of the NPA, where they keep on postponing the matters, like in the Zandile Kumete matter.
In that matter, there have been numerous reasons why the matter has been postponed. And there are some reasons at the instance of the prosecution, but they cannot be completely blamed for the 8 years of delay, because there are various reasons why the matter was delayed over that period. And if we really want to look at this matter, we need to look at it holistically and not selectively. Why the case was delayed for that period
No,
of
the
time.
chair is saying I'm running out of time. What?
Yeah. You have been riding on the benevolence of the chair. Advocate, there is that other question which you noted, you said you wanted to respond to it.
Chair, just to mention that with regard to the corporate alternate dispute resolution mechanisms, that this has been a mechanism by which we have been able to recover billions for the fiscus. I want to be clear that even though the corporate entity is the one that the agreement is reached with, it does not include individuals within the entity. And part of the agreement is that the corporate, which is the company which is paying, will actually cooperate with the prosecution to ensure that individuals are prosecuted. So no one's actually escaping accountability. It's a win-win situation because we're able to get the money back and also ensure that we get cooperation, that individuals in the company are able to be prosecuted and held accountable.
Thank you so much. Can I note hands for follow-ups? Your hand must be down, Honorable Scosa. You can't ask a follow-up on your own line of question. No. No. Yeah. You see, we allocated you 30 minutes. So you are indivisible, whether you shared it between you, and that speaker is either Honorable Nomvalo or Honorable Skosana. The only person who can ask a question from your part, if there is Honorable Shongo. The two of you are indivisible. Now, as we speak, Honorable Malema, Honorable Ngola, I don't see any hand. The list is closed on those two speakers. Honorable Malema.
Advocate, was Jackie Slavy's case not a high-profile case?
It was a high-profile case.
Was Leonard Lord not given 204?
Beg your pardon?
Leonard Lord, was he not given 204 in the Slavy case?
I don't know. I'm not aware.
Remember that Leonard Lord was accused, or you don't know the case?
I know it, but at a very high level. I don't know the details of who was given.
No, it can't be high level. It's public information. I mean, if it was details which are not publicly known, I wouldn't know about it. You are not aware that Leonard Liotti was...
Agliotti, I'm
Yes,
sorry, I
yes.
did not, and my apologies, I didn't
No,
understand.
no, the problem is that you are quick to say, I don't know, even when you don't hear the question. That's the problem.
The name was not clear, and I thought, who is this person?
Yes.
I certainly didn't
Was
know.
he
but
not given 204?
I think he was, I'm not sure.
Yes, he was, in exchange for
Agliotti.
slavery.
That's my recollection from the
Yes.
publicly available
So
information.
it will not be for the first time in a public case like a greasy given 204 in order to catch big fish
Certainly, it's not the first time.
in a high-profile case.
That's correct.
Thank you.
Are you done, Honorable Member? Honorable Ngola?
Is he done or he doesn't know as well? Chair, just one issue from me. So NDPP 2018, the government of South Africa establishes the PKTT. You get appointed the National Director of Public Prosecutions in 2019. The year you get appointed at the height of political killings in South Africa. In 2023, the Interministerial Committee extends the existence of the PKTT. 2024, 31st December, the minister issues regulations disbanding the PKTT. 6 July 2025, a provincial commissioner takes to the public issues and alleging that NPA is colluding with drug cartels. Later than that, the Madlanga Commission summons the Director of Public Prosecutions in KwaZulu-Natal. Later that, the ad hoc committee of Parliament invites you to come and appear before it in relation to that. But still you have not seen a need to solicit a report from the DPP on the effective contribution of the NPA in respect of political killings.
The evidence of the DPP was that they worked well with the PKTT, and in her testimony during Madlanga, in the Madlanga Commission, she said that...
Can I interject you respectfully,
If I could
NDPP? Leave what the DPP said in the Madlanga Commission. I'm giving you a series of events that would have forced or coerced your hand to request a report from the Director of Public Prosecutions in KwaZulu-Natal. Now, I am saying, in light of all these incidents from 2028 to now, you have not seen...
From 2018.
2018, sorry, Chair, thanks. From 2018 until now, you have not seen a need to solicit a report from the DPP in KwaZulu-Natal in respect of the contribution of the NPA in the political killings testing?
With respect, Honorable Ngola, it's important what the DPP said at the Madlanga Commission. She said that the prosecution and the PKTT worked extremely well together. And that was her testimony, that they're working well together and that she's satisfied with their work. So I'm not sure that, what a report would have achieved, given that she was satisfied with the working relationship and, in her view, the success of the PKTT.
How did you assess the contribution of the NPA in the work of the political killings test team if there is no report submitted before the Madlanga Commission?
As I mentioned, that this was an operational issue that the DPP was managing, and there was no issue that that resulted in the DPP having to submit a specific report about the fact that there were challenges or there were any issues about performance relating to the PKTT. And then she testified that the PKTT was working fine with the prosecutors. So that in that assessment, there was nothing untoward. There was, if of course she had said that things were not working out, it would be a different scenario. But in these circumstances, there was no need to solicit a report from the DPP in terms of the NPA contribution to the PKTT work.
So you would only be required to request a report if things are not working out?
Not necessarily, but generally that happens more frequently, that reports are requested. But where there are high-profile cases, specific cases, DPPs are requested to report at regular intervals without being requested a report.
So as things stand, you are not aware whether NPA has in a particular way sabotaged the work of the PKTT?
That the NPA has any way?
Has in any way or to whatever extent sabotaged the work of the PKTT?
From what the DPP in KZN says, they worked extremely well together. And the evidence of Advocate Johnson indicates that she didn't even know about the fact that the head of crime intelligence was involved in the PKTT. It did not feature in the work with regard to these arrests. So, in my view, in my opinion, I'm of the view that there's no sabotage by the NPA of the work of the PKTT at all.
Thank you so much. What is half a second, Honorable Skosana?
Thank you, Chair. Advocate, I've been sent to give you a farewell of disappointment. They are saying, I must say to you, you failed the Senzo Meyiwa family. Your prosecutors have failed the Senzo Meyiwa families and many families, not necessarily him alone, but his case has been going on for many years, and people who were supposed to be, in their view, to be held accountable, they are untouchable. May you please, before you leave the office, encourage your prosecutors to do the right thing. This postponement, as my colleague was talking here about,
the time has expired.
so the half second is gone. Please, can you please consider that? Thank you so much, Chair. Thank you, Advocate.
Thank you, Chair. May I respond? I will try to be quick. Chair, I will not sit here and accept the blame on the part of the prosecutors for the absolute disaster in the prosecution of the Senzo Meyiwa case. I can give details of the fact that there were two teams in the police that were investigating this matter. One reporting to the minister, one reporting to the National Commissioner. And these teams were at loggerheads with each other. If I recall correctly, they may even, I stand to be corrected, they may even have been dockets open by one team against the other. It was a total mess. There were requests by the teams for specific prosecutors from the Johannesburg office. There were allegations that against certain prosecutors. And in an effort to salvage the case, I discussed the matter with the DPP of Pretoria and Gauteng and said, we're going to take this case out of Johannesburg and transfer jurisdiction to Pretoria, get a prosecutor from Pretoria to look at both the dockets, at all the evidence, and decide on how to proceed and unravel this total mess in this case. And so that is what happened. But that was done by the NPA in an effort to ensure that the victims in this case got justice. And it's something like that should never happen in our criminal justice system. But it did. Thank you, Chair.
Where you work, advocate, is there a CEO or a DG?
A CEO or in the NPA?
Or a DG?
No, Chair.
So in your position, you act like you are the Director General of the NPA in terms of the organizational hierarchy?
No. Well, Chair, I hope I understand you, but the National Director is not the accounting officer of the NPA.
Who is the accounting officer?
The Director General of Justice.
So the staff of the NPA reports to the DG of Justice and not to your office?
You have raised a very important point, Chair, because legally speaking, a large chunk of the NPA staff derive their legal authority from the DG of Justice. And it puts a national director in a weakened position to properly run an organization.
Because what I want to understand is with regard to the recruitment of staff. Who does the recruitment of staff at the NPA?
Chair, we do the recruitment of staff in the NPA. We do have an HR capacity that deals with the recruitment of staff, but there are various levels of approvals, certain levels of, depending on the level in the NPA, the process happens in the NPA and the final approvals go to the Department of Justice or to the Minister, depending on the levels.
So the person who is a chief director, or let me say,